Good morning and welcome to the Arizona State Board of Pharmacy meeting. It's December 11th at 8:30 a.m. and I'll call the meeting to order. Dr. Gandhi, if you could do attendance and conflicts of interest, please.
Certainly, Madam Chair. Thank you. Mr. Braswell is not in attendance today. He's getting married this week. So, Mr. Thorwald,
Here, no conflict of interest.
Ms. Nair,
Here, and I'm recused on 4A, item 24-0125 and 4N 24-0416.
thank you. Ms. Davis,
Present, and I've submitted mine previously in writing.
Ms. Walmsley,
Present, mine have been submitted.
Ms. Lehan,
Present, might have also been submitted.
Mr. Dang is going to join virtually. Mr. Dang,
I'm here, present, and no conflict, sir.
thank you. Mr. Al-Nasif,
Here with no conflict.
Mr. Anderson,
Present with 2 conflicts on 11D and 24A, and they've been submitted in writing.
thank you. And just as a friendly reminder, as those agenda items come up, if you can announce your conflicts and the reason why would be appreciated. And happy holidays, Madam Chair and board members.
Yes, thank you. We're looking very festive today, and so are our board books. So appreciate the level of festivity. A couple of housekeeping notes. If you are interested in CE, make sure that you sign in the back. You will get Arizona accredited CE for the morning. It's also available for the afternoon. You will have to sign in for both. And we'll move forward with the agenda. Do I have a motion with regards to accepting the YouTube stream as the meeting minutes?
Madam Chair, Member Thorwald, I move we accept the minute meetings.
Second.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. We'll move on to tab 4, which is the complaints. I have a number that I would like to pull since I was not a part of the complaint committee for discussion. I'd like to pull items 4F, 4G, 4I, 4K, and 4O. 4M has already been noted for full board discussion. Do any other members want to pull any additional items for discussion?
Yeah, I like to pull 4L.
4L. Okay. We'll go ahead and take them in alphabetical order, and then we'll come back and take a motion on the rest of them. So item 4F is complaint number 24-0498. A pharmacy failed to notify the board of a termination of a pharmacy technician after she arrived to work and was deemed to be under the influence of alcohol. The recommendation of the complaint committee was to offer consent agreement for $1,000 civil penalty, and if not signed, proceed to hearing. My question on this one was why did we decide to go to that level of discipline since I wasn't on the complaint committee? Just for discussion, I feel like that's a little bit higher than what we would normally do.
Madam Chair, we discussed that the pharmacy failed to report the for-cause termination of the pharmacy technician who came into work under the influence of alcohol in April of 23. The board only discovered this unreported termination in August of 24 during a separate unrelated matter. We discussed that by not reporting the incident, Safeway allowed a potentially impaired and unfit licensee to continue working in Arizona, posing a risk to public safety. And we felt that timely reporting is crucial for the board to take appropriate measures to protect Arizonans from unsafe licensees. Thus, that was the recommendation.
I would just like to add, I believe this is a little bit higher than norm. The fact, I believe we didn't have evidence first that the technician did not enter the pharmacy. That's from my perspective. And there is no evidence that the PIC or pharmacy department aware of the reason of termination. So for this reason, I disagree with this recommendation, actually. So.
And my thought here was it doesn't appear that Safeway, the organization, was actually aware of the situation. It was that all of this was done, the Pick wasn't aware. It was all done by a front end manager. Now I understand that the permit has a corresponding responsibility to this, but I felt like I don't know how the organization could have done something differently because of the way that their employee handled the situation.
My concern was the reporting. I believe that the timeliness was very poor in getting it to us, and that it did put the public safety at risk, and that's why I think it should be at the higher number.
Further discussion did include the fact that we were concerned about the transparency of the permit holder. When questioned, the permit holder said they had no record of the for-cause termination. That didn't seem to set well with the committee members, because if you're going to for-cause terminate somebody, you'd have some sort of employment record for maintaining that record. So that was another discussion point.
Thoughts on this one? I'm personally not comfortable with it, but I'm one opinion.
Have we had a situation in the past where we have been with a company who has not notified us and find the permit? Do you recall?
I can't think of a time that we've done that.
I think it was a unique scenario in that we discovered this under an unrelated matter by having a conversation with the licensee. And she shared with the board that she was terminated for a cause. And it questioned this board to ask the permit holder, why did you not let us know? Over a year ago, there was evidence that this individual had a potential substance use disorder that was unaddressed. And that was what I think was some of our discussion during complaint committee.
It was also their record keeping, how poor it was, and not having any history of that, of what happened.
Madam Chair, this is Kevin.
Yeah.
I agree with you that in the past, we have never done this, but we have never fined such a large amount for this type of behavior. So I think we should maintain consistencies.
I think that if this was consistent and uniform with everything else that's happened, that would be the case. But this is unique among these types of things happening.
Thoughts on what we want to do with this?
I
I-
agree with Ms. Walmsley that if the PIC didn't know, the pharmacy didn't know, it was all handled by the front end. It doesn't seem appropriate to discipline the pharmacy.
But Dr. Davis, how would the pharmacy manager not know when your employee is no longer on the schedule? That doesn't make sense.
Sometimes HR keeps something confidential from PIC, so I can see that happening. It doesn't mean that happened, but sometimes HR department do not share all information with direct supervisor. So, and that's why I said we don't have evidence either way. So,
We have evidence that they knew that the technician came to work impaired. It was significant enough for them to take for-cause termination and terminate the employee. The employee never returned back to the pharmacy. So the pharmacy manager who schedules that employee has some sort of knowledge that the technician was terminated, because I'm sure there was some sort of discussion between store management and the pharmacy manager that this technician is no longer coming back to work.
yeah, but she did not enter the pharmacy under influence. So that's what was clear in their statement. She did not enter the pharmacy. She did not process any prescription. So I don't know if I misread it, but I don't know if she even clocked in. I mean, I don't know. You know what I mean? So I cannot we cannot say that she worked under influence.
Doesn't appear it doesn't appear that she did. Includes an explanation that on the date the technician was terminated, she did not enter the pharmacy and did not perform any technician duties.
Mhm.
I don't think that's the key point here. I think the key point is that they never notified us at all, and that it could have endangered somebody else in the public afterwards, and that when you don't have somebody showing up for work, you have to know there's a reason, and you have to ask, or it just does not make sense to me that it would be any other way that the pharmacist would not know.
Perhaps an alternative, and I'm already concerned about the number of conferences, which is why I pulled the others, but perhaps this is an example of where we should have a conference and we should bring in the PIC as well
Mhm.
to determine what the PIC knew with regards to this, because I can understand that the store manager who does not hold a license by us didn't understand that that was a requirement. And if they didn't report the reason for the termination, I don't know how the organization would have ever known that. If the PIC didn't know that, I don't know how the PIC would have ever known that. Now, if I was the PIC and my technician didn't show up and the store manager said the technician was fired, I would probably ask questions. But I don't know that I have all the answers that I need to make to make a decision on the case. Is it possible to add the PIC to this complaint? Or at least bring them as a fact witness for a conference?
You could add them to the complaint and renotice for a future meeting.
I'd be in agreement with that.
I think that's a good compromise.
Because there's no statement in here from the PSC. It's only from the corporation.
I would be in agreement with that as well.
Let's learn more.
That will be my motion, is to table the complaint and to renotice to include the PIC and get a statement from the PIC for discussion at the next meeting.
Second the motion.
Mhm.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Next one is 4G, complaint number 24-0481. A pharmacist was alleged to have made errors and resulting in suboptimal patient care. This one was determined for conference. Just wanted to see from the group what we hope to learn from the conference and why we decided to go the direction of a conference versus continuing education.
I can say from my point of view that it's tough for us to understand if the person who had made the errors, if it's a he said, she said. I kind of wanted more information from the pharmacist involved. The kind of there's concerns about competency. And I think that speaking to the individual, we might gain some more confidence or maybe suss out whether or not we see there's competency.
And I agree with that.
So if we do a conference, we're only going to hear from the pharmacist right now, the way that this is noticed. So as you've stated, this is kind of the he said, she said.
We were also concerned about the way they were training in the facility. We wanted to get more information.
Which we're not going to get from a conference, the way that it's noticed.
That's what we were hoping to gain. So if we need to add someone to the conference, that would be appropriate.
Yeah, I had a concern about the training and the environment there, regardless of the concern about the pharmacist, because what I noticed, like, while she was within the training, supposed to be with a trainer, assuming a pharmacist, she got coached for like allowing non-pharmacy staff to enter the pharmacy. But so basically, to my understanding, she was by herself instead of somebody else training her. So I know the case is against the pharmacist, not against the hospital, but just before we roll for this pharmacist, I need to know the environment in that hospital.
So I think we should perhaps take a similar approach as we did the last one. I don't know that we have all of the information we need at this point to discuss this. So
I agree.
my suggestion would be to table this complaint and to open and to add the permit holder and to gain additional information from the permit holder. And that's my motion.
Second.
Motion and a second. All those in favor?
Aye.
Aye.
Question about
Go
that.
ahead.
We said permit holder, but maybe the pick as well.
I would
So if we could add that.
I would be willing to amend. Frank, are you good with that? Okay. So adding the permit holder and the PIC. All those in favor?
Aye.
Aye.
Any opposed? Hearing none, motion carries. Lost my notes. Next one is for I, complaint number 24-0479. A pharmacy received the wrong medication. This one was again recommended action of a conference and to request medical information from the pharmacy technician trainee. I wanted to see what we hope to gain out of a conference versus what we would typically do with continuing education.
I think the big picture on this one is that the pharmacy technician trainee disclosed in her response to the board that she had, that a contributing factor that she believes may have been may have contributed to selling the prescription to the wrong patient was the fact that she has poor vision. And she also acknowledged in her response that she was working an inordinate amount of hours and had fatigue. So we kind of wanted to explore her well-being and understand vision correction, and any sort of medical condition that we need to address to make sure that she can safely function as a pharmacy technician. I think we're fortunate that we caught this early as a technician trainee, just to make sure that she's wearing corrective lenses, that that's what's required for her to function safely.
And I believe she was the one, she did the mistake during her externship. Is that right?
Correct.
Yeah. And one of the concern, if somebody doing their externship, they should be under supervision. And I believe she was working solo without trainer, without any supervision.
Right. It seemed like it was a community college or some sort of sponsored trainee program externship. And to Mr. Nassif's point, her narrative described that essentially she was working by herself. So we kind of want to learn if she's assigned a technician mentor, or is the PIC at this location mentoring that technician trainee to become a technician, how it's kind of organized, because there are a lot of just unknowns in this whole scenario with technician trainee externship programs.
Do we know if the PIC was the preceptor?
We don't know.
Also, if I recall, she was working a second job, and we don't know what that was, but it was seemed to be an extraordinary amount of hours that would have made somebody very tired and not overly responsive in my mind.
Hence is why we kind of landed on a conference.
I don't know. It doesn't change my opinion, but I appreciate the information. I think I don't know what we're going to do differently by asking the questions.
So normally, like, technician cannot perform job before training, right? And
This
I
is a
just wanna-
cashier function. It was selling a prescription.
but we don't know that. But if she did other tasks, she was cashiering at that time. But that's what we need to hear from her. What was the situation there? Was she said to fail or to make errors?
The error that was reported was the patient received the wrong medication. The wrong thing was sold to a patient at the cash register. I mean, mistakes do happen. I'm not downplaying it. I don't see that this warrants a conference, in my personal opinion. I don't think we're going to get anything different by bringing somebody in front of us and asking them about their poor vision.
In my experience, in order to have someone even run your cash register, you would have already trained them. So they would have already been in a situation where they would have their trainer. They would have learned these functions to be there. You wouldn't just put someone on a cash register that doesn't know your system. And from these externships, in my experience, once you've trained them, you allow them to do those functions. You don't stand next to them the entire time as they're doing them. And just like any other technician, they could pick up a wrong bag. They could make a mistake. We do see that from people that are not in externships. And so I kind of lean with Ms. Walmsley here as far as I'm not sure what we would gain. I've seen a lot of the externs need to have another job because they need to be supporting themselves while they're going to school and doing these things. Well, maybe it's not ideal. And I do feel like this person has probably learned a significant lesson, even having been in this situation, to have to reevaluate how they're doing things, what they learned from it. I'm not sure about a conference.
How about a middle ground? I'll just make a suggestion that we do 3 hours of non-disciplinary CE, and maybe that they're able to provide us some kind of exam that they have the ability to have good enough sight to perform their job. If they could provide the board with that. There's no conference needed. If she's saying the reason why she made the error was her poor vision, it would be nice to have some type of clarity that that's not going to be in the way of her performing her job.
I agree with you, Ms. Snare. I think, she's acknowledged she's got poor vision, and that's crucial for functioning as a pharmacy technician safely. And if she's not using appropriate vision correction, as a trainee, I agree that we need some sort of reassurance that her vision is going to be corrected if she's attributing this error to her vision.
I also agree with that.
Do I have a motion?
I'll make that my motion. 3 hours of non-disciplinary CE, and the technician trainee provides the board staff with vision health record of some type.
Would that
I don't
be,
know how you'd want to say it.
would that be an eye exam or something?
Some type of,
Gina,
that
is
allowable?
this appropriate?
You do have the authority to order licensees to undergo any type of physical or mental exam to ensure that they're safe to practice. So first 3 hours of non-disciplinary CE in what area?
med error prevention.
And then issue her an order to undergo an eye exam with an optometrist or ophthalmologist regarding her current eyesight, whether it is correctable and whether with correction she would be safe to practice as a pharmacy technician trainee. And that exam should be done probably within 60 days, and then a report submitted to the board.
That's my motion.
Well, just because you have the exam doesn't mean you have the eyeglasses or the other to do it. Some people just can't afford the eyeglasses at a particular time in their life. So that also may be an issue as well.
I'm going to throw out a contrary thought. If I get in a car accident because I can't see a road sign, do I have to provide the police my vision correction in order to keep my driver's license? Like, that's what we're talking about here.
Well, we're also talking about somebody that if they do the wrong prescription and it kills somebody because they couldn't see, it's another issue. It's the same way with a car. If you're driving down the road and you can't see and you run somebody over because they walked in front of you, you've still got the same problem.
That's my point, Frank.
So I would accept if she already saw ophthalmologist or optometrist already, and that she just submit a proof of that she saw already someone after the incident or after the error happened. I would be okay with that. I mean, there is always like financial hardship for some people to see a doctor, or so maybe she already done it. So, or maybe only a statement from her that she already done it.
If it's our role to protect the health of safety of Arizonans, and she's saying this is a factor in her making this error, I think it's appropriate for us to make sure that she has appropriate vision.
Totally agree, Ms. Nair.
I do too.
I think it's
agree.
our duty. I mean, if she wouldn't have said this in her response to us, we wouldn't be here.
And for the driver license, they put notes. You have to wear glasses, right? So,
Yeah.
so they put restriction.
All right, so we have a motion and a second. Do we want to do a roll call on this one?
Would you consider, there's been discussion here about getting documentation that she's already done it as part of the interim order request? If she has already undergone it, instead of having her do another one, accept documentation that it has already been completed?
Yeah, I believe.
Yes,
Yeah.
within an appropriate time
Yeah.
frame. I
Yeah.
mean,
Perhaps within the last 60 days or so.
that's fine.
Is your motion to dismiss against the PIC and permit holder, or are we gonna do those separately?
I would dismiss against them, against the PIC and the permit holder.
I'm sorry, we agreed to 60 days. Like, what if we already done it like right after that
It was-
happened?
If it
It
was
was
done within
stated
60
plus or
days.
minus 60
Yeah.
days.
Plus or minus 60 days, yep.
Yeah.
All right. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Nay.
Ms. Lehan,
Nay.
Mr. Dang.
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair. 2
Thank-
days.
Thank you, Dr. Gandhi. For K is the next one. Complaint number 24-0406. A pharmacy received 2 prescriptions for the same drug with directions, and the pharmacist dispensed one prescription without clarifying which order to dispense.
Madam
This-
Chair, I'm recused
Okay.
due to my employment.
Thank you. This one was recommended for a conference as well. Again, wanted to just have some discussion on what we hope to learn from the conference.
I'll provide a brief summary. Just the incident centers around 2 e-prescriptions for metolazone received nearly simultaneously. The first prescription with instructions for daily dosing was received at 13:49 and was filled and dispensed. The second was received 2 minutes later at 13:51 and contained the correct instructions for twice weekly dosing, but was placed on hold without clarification of the prescriber's intent or why 2 prescriptions for the same drug were issued nearly simultaneously. The lack of the action led to a failure in addressing the duplicate therapy. The patient experienced significant health deterioration and exemplified a concerning pattern of unresolved duplicate therapy issues related to e-prescribing that we've seen with this permit holder in the past. So the committee felt it was important to learn more as to what system solutions may be underway by the permit holder to help their pharmacists identify and resolve duplicate therapy and conflicting orders.
So my thought when I read this, because they are 2 different prescriptions, is I do think that the pharmacist was at fault here. They had a duty to do some clarification here, and rather than a conference, my thought was to do 3 hours of CE, whether it's disciplinary or non-disciplinary, kind of was where my head was. They received DUR alerts of the duplicate therapy and they overrode them without taking the appropriate action. So to me, that was somewhat of a reckless behavior. I don't know that CVS could have done anything differently in the way that their system brought in the information from the prescriber. There was an alert, the pharmacist overrode the alert, and they didn't take action. They didn't take the appropriate action. So I didn't know what I thought we were going to learn from the conference. If we think that we need to hear from them, that's fine. But my thought was more down the line of CE.
Actually, I think it stated that there was no DUR alerts present.
Correct. That's what we discussed, is that
third
the
paragraph.
pharmacist did not receive any DUR alerts because the technician was able to place it on hold, which didn't flag to the pharmacist that dispensed the daily metolazone to that patient, that a second one came through because the technician placed the second one on hold and the system did not alert that pharmacist that there was a second one even sent 2 minutes later.
Okay, I missed that. Then I do think that that's appropriate to hear about their system.
Definitely a concern about the software and whether the system worked.
I think I'm two-minded on this because I do think your system should be able to accept 2 prescriptions back to back. Sometimes you're titrating up a dose or titrating down a dose, and you're going to need 2 prescriptions back to back for the same medication. So I think a system has to be able to accept those. I think this kind of falls to the prescriber to say, I sent this to you in error, don't fill the first one, because they can't recall it at that point. Most systems don't. I don't know if systems ever allow that.
Some prescriber systems do.
Okay. So I feel like this was more on the prescriber to stop the wrong prescription from going out, but
Agree. I think, the med use process is complex and the prescriber had a duty as well in this. But that's why we have pharmacists to identify and resolve therapeutic duplication. And the system did not support that pharmacist in helping him resolve that therapeutic duplication. And we have a potential patient injury as a result of that.
Thoughts?
I think it's easy to say now that that it should have been caught, but it was within minutes and maybe the same people weren't working on it. So they may not have seen that because of the time being so quickly back to back prescribed.
But Ms. Snare, that pharmacist who's dispensing to that patient owns that prescription for that patient and has to understand what that patient's on. It's their duty to resolve therapeutic duplication. If there's a duplicate order for metolazone, I've got to do my due diligence to understand, what's the intent here. And if the prescriber made a mistake and sent a second prescription, and that was the one that he wanted the patient to take, and he did not cancel the first one, agree that there's a corresponding responsibility here. But at the end of the day, the pharmacist, in my opinion, had a duty to resolve that therapeutic duplication.
Was counseling performed on this one? I don't remember. Who's the compliance officer on this? Steve? Because counseling would have caught this too. Should have caught it.
Steve Hyber, Compliance Officer. Good morning, board members.
It says that counseling was documented on 410.
Yes. Counseling was documented, so they met that requirement, and it was flagged patient/caregiver not present. It's how it was filed on their system.
So
It doesn't appear counseling was
it's
performed, but they did
Document it.
document it as such.
I think we should accept the complaint committee's recommendation.
Is that your motion?
It is my motion.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none. Motion carries. Next is 4L, which I am recused from, so I'll let you take that one, Jeff.
Thank you, Ms. Walmsley. This is complaint number 24-0208. Respondent Walgreens 15502. Pharmacist Stephanie Lopez, technician Nicole Fitzsimmons, and respondent technician Andrew Jordan. Type of complaint: the pharmacy dispensed a brand of thyroid medication that caused the patient to have an allergic reaction. I think, Mr. Nassif, that you asked this to be pulled.
Yeah, correct. So just giving this more thought and then looking at the type of medication. So we recommend to dismiss, but I believe, we all know those medications are not FDA approved and grandfathered, but, and I just knew that the wholesaler, they let you substitute, like when you ask for generic equivalent, they list it as like equivalent. software allow this, so I understand all of this, but we should not ignore the fact we allow pharmacists to substitute only if they are AB rated. But I would just like to, I'll be like fine with the letter of concern to the pharmacist, not totally dismiss, just because there's a lot of medications in the market are not AB rated, are not FDA approved, and I just want from our pharmacists to give more thoughts and attention to those meds. So I would just like to move from dismiss to letter of concern to the pharmacists and dismiss technicians.
I would support that.
Non-disciplinary letter.
Yeah, no, yeah, just a letter of concern. Yeah, non-disciplinary.
Do you want to make that your motion?
Yeah, this is my motion.
I'll second.
All right, so we've got a first and a second. All in favor for?
Aye.
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 Any opposed? All right, motion carries for letter of concern.
I'm
Yes, Ms.
sorry,
Bell.
I'm not clear on the basis for the letter of concern
It-
regarding
It
substitution.
is like a AB, they're not AB rated, this medication that they switch or substitute. And because there's no study from the FDA and the type of medication, it's neurotherapeutic index meds to treat thyroids. So I believe we need just pharmacists to pay attention to those kind of meds.
Thank you.
Thank you, and we'll hand it over to Ms. Walmsley.
All right, let's do 4M. Complaint number 24-0570, a pharmacy performed
Ms.
data.
Walmsley, I'm recused from this. one.
Okay. A pharmacy performed data entry and shared order processing at an unpermitted facility without shared services or remote work policy and without relocating a portion of the operations. This one was recommended for a full board discussion.
So I have some points for this case. I mean, just reviewing the rules and policies or rules here in this case, and referring to R423606, and then we go to, I believe that's the one, I'm not sure. Yeah, to F. So it says there clearly nothing in this section shall prohibit individual blah, blah, blah to work inside or outside the pharmacy. There is nothing in the rules will say from home or from office. So I don't know why this individuals or this permit holder like brought to the board. And this is my question here, just.
Can we have Mr. Jacobson join us? He did in our committee meeting as well.
Good morning, Board of Pharmacy. Max Jacobson, Compliance Officer. Mr. Allen-Seif, you're right. The language does leave that pretty open as far as where the location is allowed to be performed. However, traditionally as a compliance team, we have enforced this as a work at home policy, not as a shared workspace policy.
So yeah, and this is what I asked for full board conference because we need to clarify this. Our pharmacists and community like need this clarification. We don't know how many pharmacists or technicians work from home or from offices. We don't know. From my perspective, if we allow staff pharmacy to work from home, to me, it would be safer if they are inside the office. And just for example, like we have a hospital, we give a permit for inpatient pharmacy in the hospital, while pharmacists in the floors, they do data entry outside the permit. I didn't see any verbiage in our rules. It say that's okay for inpatient, not okay for outpatient or community pharmacy, which is, I believe, this is important for inpatient pharmacy to do so. This is for patient safety. They need to be in the floor. I'm not saying we should stop this, but since there is no verbiage in the rule to say that's okay for this settings, but not okay for this settings, and that's why I believe I mean, I'm in favor of like allow them now. If they have policy or not, this is a different discussion. But I'm talking about like the setting that allow people to work from office outside the permit. I believe this, based on the rules I see, it should be okay.
If I can remember correctly, I also asked for some clarification on what the statute said about this.
Yeah, Mr. Thorwald, we were able to find that. And it looks like this rule comes from the statute ARS 32-1930. That statute helped to define further practices originally dealing with central fill facilities.
How did it address this specifically?
I don't believe so. From what I understand, this was a developing practice. Moving to remote and shared services was just kind of developing at that time. And really the statute was designed around central fill.
So statute basically was mute on this specific thing and left it to rule.
That is my understanding.
But we have specific rules on shared services
Okay.
that address
Thank you.
remote practice under 621.
Yeah, and everything above F, like section F, is talking about share service, not specifically to remote, like having policy and having like HIPAA protection. But we go into F, is specifically there's two conditions are met if both the following, and there's both conditions. From my experience, my perspective, those two conditions will met if you work in the office more than working from home, or maybe. And when we allow people to work from home, we don't know if they're working in the coffee shop, like having coffee with the friends, who knows, right? So to me, it's safer for community if we allow them to work from the office versus from home. And since the rules are not specific and is a gray, I would like to just give a clear message to our pharmacists so they don't fall in violation in the future. So because we don't know how many organizations allow their staff to do so. Like
It's allowed. It just has to be addressed in the policies and procedures, which
Yeah.
it wasn't, but it is now, correct?
That is correct. So this practice of allowing front-end operations at an unpermitted facility was only allowed previously by deviation from this board. So specifically granted to do that by this board. And in this case, you're right, there was no remote work SOP in place at that time.
Madam Chair, if I may, I know we're talking about shared services, and we got to keep in mind that shared services takes place within two permitted locations. In this situation, it's only one permitted location and one non-permitted location. So shared services necessarily doesn't apply in this situation.
I think what I mentioned before is we're almost setting it up that a closed door pharmacy wouldn't need a permit, and they do. So you're moving a whole group of people functioning in this pharmacy role without any permit. So that would be, a slippery slope.
But
to
I
say.
agree with what Mr. Al-Nassif said. So like a floor in a hospital is not permitted as a facility, but pharmacists are performing data verification from the floors. So how is this different than that? Because that happens every day in the state. So that's a kind of a double standard if we're going to hold them accountable for this, but we wouldn't hold a hospital accountable for that.
That came to my mind as well when I was thinking about this matter. And that's where satellite pharmacies and the hospitals came into place, I think, to address all those things. But of course, then businesses evolved and other things are taking place at this time. So our rules don't address and capture all of that. And maybe that's something we need to visit in the future.
My thought on this one is to do a non-disciplinary fine for the failure to notify of the move and a letter of concern for the inappropriately addressed shared services. And then I'd like to put it on a future agenda to look at the shared services rules and work remote processing to make sure that we're clear. I mean, that's where the practice is going, and we need to make sure that we allow those practices because that's what the workforce wants. And as long as it can be done safely, I don't want to stop those things from happening in Arizona because that's why people aren't going to pharmacy school. So part of the reason why people aren't going to pharmacy school. So I want to make sure that we are looking to where the ball needs to go and not being too close-minded on it.
I just like to add, I mean, I don't think this is a shared service issue. It is working remotely issue. So, and so I just like to clarify, I mean, like for all our pharmacists and organizations, what this group of pharmacists, what are they missing here? Are they missing the policy, or they should have a policy and then they're good to go? They can't keep doing what they're doing, because there is no relocation violation here. They did not move medication. They did not act like a pharmacy. Just to Mrs. Snare concern, I mean, they're not really like
Yeah,
opening a
Mr.
pharmacy without permit.
Mr. Al-Nassif,
Yeah.
it was the practice of pharmacy, data entry and stuff. That's incorporated as far as practice of pharmacy goes.
Yeah, so we have a call center, for example. Some organizations have, are they all went through the board of pharmacy process for permits?
Yes, it's my understanding that at this time, any sort of front end call center or pharmacy practice operations that don't contain drugs either have a permit with the Board of Pharmacy or a deviation to undergo those practices.
So working from home, do we need deviation to allow organization like let their staff to work from home?
Not working from home.
So that's my point. So how we allow
But they have
people work from home?
policies in place.
That's what I'm saying.
because
So
they
But they've
wouldn't allow
added
you to
those
work at
in
a
this
coffee
case,
shop.
right?
yeah,
They wouldn't allow you to work at a coffee shop. They keep very close tabs on
yeah, they don't allow you, but we don't know if they're
Privacy
doing it. So would you rather to?
supervised electronically.
Yeah. So would you rather like a person work from home without knowing they're from home, or somebody in the office within the network, safe, secured network, if we worry about HIPAA, or you working from home using like who knows which networking you're using, for
I
HIPAA
think there's
protection.
risks for both. And
Mis-
we want to ensure that it's done safely. So they don't have policy around how they're doing this safely. They weren't aware, we weren't
They-
aware they were doing it. So I think that's where they.
Mr.
erred.
Jacobson, are they in compliance now?
I guess that would depend on how the board rules today, whether this is an allowable practice without deviation or without a permit. As far as having a policy, they do have one now. They have implemented one and submitted it to us. I believe it's in your board book, maybe page 638 in your board book, their remote work policy.
Also, it's possible to know where somebody is working by geolocation. So if they're working remotely, that can be determined easily by the system if it's set up for that.
I don't know. I think just a letter of concern
I-
is where
I
my
agree
head
with
is.
you, and I agree that it warrants more discussion. So we can add some clarity in the future, hopefully.
Yeah, but at this time, so the letter of concern due to not having policy at that time
For remote
Yeah.
remote work.
for remote work. So if they have policy, there won't be an issue, right?
Yeah.
Okay.
I don't want to set a precedent that
Okay.
remote work isn't allowed.
Okay. So just because lack of policy.
Mm-hmm.
So my motion is a letter of concern to the permit holder with regards to lack of policies regarding remote work.
Second,
I have a motion and a second. Any discussion? All those in favor? Any
Aye.
opposed? Hearing none, motion carries.
Excuse me, was that motion for the permit and the
Yeah.
PIC or just the permit?
Just the permit.
Okay, the PIC is also on this complaint as well.
I would make a motion to dismiss against the PIC.
second.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Last one for discussion is 4O, complaint number 24-0282. The pharmacy dispensed the wrong medication strength and administration instructions to the patient, resulting in the patient experiencing nausea and dizziness.
I'm recused due to my employment.
Thank you, Ms. Lan. This one was recommended for a conference. Again, what are we hoping to learn here and why not CE?
I'll provide a brief summary. The evidence presented to the complaint committee is that involves improper handling of a telephone prescription for Ozempic, which resulted in harm and side effects to a patient. The prescription originated at a store 8952, CVS 8952, where it was improperly transcribed into the pharmacy system and placed on hold. The transcription included an incorrect product selection, specifically the 8 milligram per 3 ml pen, which is not suitable for the prescribed dose of 0.5 milligrams. Unfortunately, the error went unidentified. Subsequently, the prescription was electronically transferred to store 7872. At that store, a pharmacist modified the directions to align with the incorrect product selection made at 8952, rather than addressing the mismatch. This resulted in an overdose of 4 times the prescribed dose, causing the patient to experience significant adverse effects. The pharmacist's decision-making raised concerns for the committee, despite recognizing the mismatch between the dose and the product. We don't know if she consulted the original prescription image or what work she did to resolve the discrepancy with the provider. And additionally, she did allow a higher than normal starting dose to be dispensed for what was likely a therapy naive patient. So we did want to learn more because of the complexities of how it's originated at one store, was transferred to another store. The fact again that the technician typed it incorrectly at store number 1, was placed on hold with no pharmacist review, then transferred, then manipulated. So there was a lot of uncertainty on who's accountable here.
Yeah, just the fact direction or like altered or the medication, like we didn't have any evidence who was responsible for this and how did the system allow it. You know what I mean? Just we asked for a conference for more information.
I'm leaning more towards for the pharmacist involved in the technicians, personally.
Certainly still like to find out more about it. I still don't think there's a good decision here that could be made without having more information.
It's very similar to the metolazone issue where the prescription is placed on hold in error with and then the pharmacist at the time that prescription is placed on hold isn't doing any sort of clinical review. So technicians are using their judgment, placing things on hold, and then the system just allows them to sit there until the patient's ready for it to be dispensed, or it's called up for dispensing, and then a pharmacist is reviewing it. So that's we've had 2 cases within, just these complaints of this corporate permit holder of having issues with how they place things on hold. And I think we need to understand how these things get placed on hold in error by a technician mistyping transcription error, and then how they come out of being on hold. How is the error resolved by the pharmacist who's now charged with trying to fix the error that was placed on hold months ago in this scenario? It's challenging, and I think we have a lot of questions.
I don't know. I just think that it was an error compounded with another error, and then it was transferred, and that resulted in yet another error. So I think it's a series of errors, but I don't know that we'll learn anything more from a conference.
Yeah, I believe what we need to know, the process. So when you put something on hold without pharmacist verification and then transferred to a different pharmacy, I just need to know, is the hard copy or original e-script transferred with this record? Or does the pharmacist on the new location will just guess? I mean, I don't know, to be honest with you.
Totally agree.
You know
And,
what I mean?
and that was my question too. What did she have? What resource did she have to consult to make sure that the
Correct. It
therapy
was the right
appropriate?
thing. You know what I mean? Just to need to, I mean, not to seek any discipline, nothing. Just we need to make sure that process is solid and ensure public safety. And instead of like holding individual accountable and the same error keeps happening and we see similar errors before us, could be something easy to fix from their software and we keep our public safe and hopefully less type of these errors will happen in future.
Mhm.
So,
Madam Chair, this is Kevin.
yeah.
So in my opinion, there's a subtle difference between the two cases here. The previous case, to my understanding, the DUR, the system had failed to alert the pharmacist of the DUR. For this one, is evidently is not the system. Is we can't blame it on the system or the technology. I feel is the pharmacist as who's at fault. Just say, let's just for an example, when the prescription, the originating prescription was filled incorrectly by pharmacist John Doe. And then John Doe transferred it to me, my store, and I'm taking that prescription. Obviously, me as a pharmacist who's receiving the transferring prescription, I have to utilize my clinical skills to see if has this prescription been filled correctly or incorrectly. I can't just go off of how the prescription was filled at the other store. You can't, people make errors. It's always to your best interest to double check, use your clinical skills, your own clinical skills, and find out if the prescription that you are receiving has been filled correctly. So I agree with Ms. Wormsley that having a conference is a waste of time. We're not going to learn much. For this particular case, I believe that we should hold the pharmacist who's receiving the transferring prescription at fault.
Can we talk to our compliance officer, Nancy? Is she there?
You read my mind.
Yeah,
I was
just,
just going to
yeah.
ask for Nancy to come.
Just I have a couple of questions or one question for her to see like.
I do also remember wondering if everyone involved was named in this complaint. Because
Yeah.
I think there were other people that were part of the error that aren't listed.
Nancy, is this your first time in front of us?
Second.
Second time.
All right.
Welcome.
Sorry,
We promise to
Nancy.
be nice.
So
Good morning.
Good
This is
morning.
Nancy Chang, Compliance Officer from the Arizona Board of Pharmacy.
good morning, Nancy. So my question is, so when the prescription sent to the first pharmacy, Pharmacy A, and put on hold, did the pharmacist, to your knowledge, verify this prescription or just technician able to put prescription on hold without a pharmacist approval?
In my investigation, that was the question that I asked the committee. And the senior analyst responded and stated that the prescription verification process are not done when a prescription is placed on hold.
Okay.
And it should be verified by the receiving pharmacist when the prescription is transferred in.
So
to
when
the
the
receiving pharmacist.
so when the prescription is transferred to the other pharmacy, Nancy, do they have access to see the image that of the original prescription?
They should, but it's not clear in terms of whether the pharmacist verified the original transcribed prescription.
And if I
Okay.
recall correctly, we asked you about the data on that, and I can't recall what the specific question was, but it didn't appear like there was information provided by CVS to demonstrate that the image could be sent, or
The question asked was, who altered the instructions on the administration of the dose?
right.
And the answer back was because of lack of time and because the store closed in June of this year, they were unable to identify who altered the instructions. So the system wasn't available to allow us to see who make the corrections or the changes in the prescription without verifying the prescription. In the credentialing activity report on page 718, it's shown a lot of order data verifications and hold and filled and changed. But then the final data verification was done by the pharmacist, who is also the pharmacist in charge. And there was a warning verification that was bypassed.
That was a DUR.
That was, assuming that would be the UDUR because it's just say warning verification bypassed. So apparently there is, based on the credential activity report, it's shown that there's something being verified and that a verification was bypassed. We just don't know for sure what exactly that the pharmacist did. And in her response, she didn't really acknowledge that it was verified against the prescriptions.
Right.
And this is my concern here, like when you're able to put something on hold, leave it for a few months or like for a long time, and then the patients come back to pick up or to ask for this prescription filled. What if they had issue with this and they just postponed it for a few months instead of like deal with this concern at that time before they put anything on hold? You know what I mean? Like there's many concern about the process, and it's all about assumption what's happened because they didn't give us enough evidence or like data to assure who did this error. It is like, should we hold the pharmacist from pharmacy A, the initial pharmacy, or from the new pharmacy? We don't know. And the fact that she also doesn't know if the hard copy or electronic copy of prescription transferred to the new location, just we need to know. So again, the conference is not just to put people on like accountable, but we need to know the process. Like it's a big organization. There is many of Arizonans use this pharmacy, and I wonder how many prescriptions put on hold every day. I like personally to hear from them what is the process there. You know what I mean? And just to make sure everything is fine. Okay, that's a pharmacist error. Then we can roll. This is my perspective.
Okay, I think that's good discussion. Does somebody want to make a motion on it?
This is my motion. Just ask for conference. So-
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? All right, motion carries. Welcome back, Ms. Lehan. Let's take the remainder of the consent agenda. So the remaining items from tab 4 through everything through tab 11. Does somebody have a motion for all?
I move we accept the consent agenda as modified.
Second.
I have a motion and a second. Dr. Gandhi, roll call since there's discipline, and make sure to note your recusals.
Thank you. Mr. Thorwald,
Aye.
Ms. Nair,
I noting recusals.
Ms. Davis,
I noting recusal.
Ms. Walmsley,
I noting recusals.
Ms. Lehan,
Aye, noting recusals.
Mr. Dang,
Aye.
Mr. Al-Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Madam Chair, one absent.
Thank you, Dr. Gandhi. I have a request for a bio break, so let's come back at 9:45. Thank you. All right, welcome back, everybody. We'll resume the meeting. We're going to go to item 11A and 21A together, and I will turn it over to Dr. Anderson.
Ms. Walmsley, did we want to do the rest of the consent agenda?
We already voted on it.
The other tabs?
Yeah, we voted on all of them.
Got it. Okay. All right. This is tab 11A and 21A as a companion to 11A. This is complaint number 24-0319. Respondents Brian Gellenbeck, pharmacist and pharmacist in charge, Yitzel Yaritza Gamboa Valenzuela, technician, and Curexa West LLC. We have the parties on the line or in the room. Great. And we have Mr. Jacobson for the board. Would the parties please introduce yourselves? Could you?
Hello, I'm Brian Gillenbeck. I'm the pharmacist in charge of Curexa West.
Thank you.
Hello, I'm Itzel Valenzuela, and I'm currently the shipping specialist at Curexa.
Thank you. Mr. Jacobson.
Hey, good morning again, board members. Max Jacobson, Compliance Officer, Arizona Board of Pharmacy. Board staff opened this complaint because it was discovered that a technician was working without a license. The PIC stated in his response, the technician was hired as a shipping clerk with the intention of moving to a technician when her license was active. The technician stated in her response that she pointed out her license was in the renewal process at the time of hire. But after a phone call with the board of pharmacy, she realized a reinstatement would be necessary, and she promptly did submit a reinstatement application. The permit holder submitted a written response stating that Ms. Valenzuela worked a total of 59 shifts before this was discovered as a pharmacy technician. She indicated that her license was in the renewal process at time of hire. The oversight in licensing verification was due to a combination of procedural gaps, including her use of her full legal name, some miscommunications, and oversight. After recognizing the issue, steps have been taken to prevent this type of occurrence in the future, including an updated SOP, adding acknowledgements, and improved verification process. Ms. Valenzuela's technician license status is currently open with an expiration date of December 13th, 2024, which is just after this meeting.
Thank you, Mr. Jacobson. Would the parties, Mr. Gellenbeck or Ms. Valenzuela, like to make a statement before we open the floor for questions?
No, thank you.
Okay, we'll open the floor for questions.
So these 59 shifts that were worked, they were while you were doing technician duties. It wasn't as a shipping clerk or non-licensed.
It was a
duties.
mixture of both, so shipping as well as like monitored training, but not doing things on my own.
So what happened with the lapse? Can you speak to that?
As to why my license is currently not active?
Why you were working on a non-active license?
Well, I suppose I was hired to do shipping and to do training as well on the side. So it was more so labeling like pre-filled vials, not so much filling prescriptions in that case in regards. So I was just more so doing what I was told, if anything. Not that I was going out of my way to fill prescriptions on my own or anything like that.
So you thought that what you were doing was not technician work? Is that what you're saying?
Not that I didn't think so. I guess I was just under the impression with that if I was under renewal application, that I could just submit for financial reasons, to submit my license and that I would be able to actually start the real technician work. But it was more so training, not more like the actual tech work.
So I think I may be able to clarify some things there. Initially, she had an Arizona pharmacy technician license. She let it lapse maybe to move away for some time. When she came back, she intended to renew her license that had lapsed. However, After discussion with the board or board staff, it was determined that her license had been lapsed long enough that she would need to apply for a new application. And I think that may be where some of the confusion stemmed from.
Mr. Gellenbeck, can you describe your pre-employment process and how you do license verifications and how you work with your HR folks with that?
Okay. Are you talking about at the time she was hired or with our new policies?
At the time she was hired.
At the time she was hired, Human Resources and the hiring manager interviewed her, and she said that her license was needed to be renewed or was in the renewal process. And what she said was she needed to renew it. They told me that the license was in process, which was a little confusing for me. What they really meant was she was in the process of doing the steps she needed to get it renewed, and later found out that it needed to be actually reinstated and not just renewed. And so HR knew that, and her start date was going to be a few weeks from there, from the hire date. So at the time, they didn't have the process we have now where you must provide proof within 10 days of that licensing. That was not in place then and would have caught this unique situation. So this has all come to light that we need a more robust process to make sure this doesn't happen again.
So where do you post the licenses within your pharmacy? So on day one, when she's hired, she's coming in your pharmacy, she's employed as a pharmacy technician. Where's the hard copy of her license in your pharmacy on day one? What was your process then and what is it now?
It is stored electronically. I also have printed up all the pharmacist technician license for an additional hard copy since this has happened. But originally, when they told me the license was in process, my response was, we can just limit it to shipping duties, clerical duties. They're allowed by the state of Arizona until the license gets renewed. And so since she would have been starting as a shipper, there was not a need to get the license on day one because she would just be doing shipping duties initially.
But it seemed like there was acknowledgement that there were 59 shifts where she did a hybrid of work
Yeah,
that was
We
technician.
did realize at that point when it came to that, hey, the license is still not renewed, and she had affixed labels to pre-counted vials by a machine, which is technician duties in Arizona. The intent was with the trainers to just show her, because he knew she was going to transition to that, to get her ready, show her the process. But in fact, she did affix labels to medications.
So when she was hired as a clerk, right?
Yes, that was in.
Okay. And so not to this case, general, like, do you give access to your software, pharmacy software, the same access to clerk and technician?
No. When the technicians will print off a patient label, and then when it goes to production with our system, they just affix the label to the pre-counted medication. So to do that, the person who's affixing the labels does not use the computer to do that. Technician prints it off, and that was a technician that did have the license that has access to that software, but the person who's affixing the labels does not need the software to do that.
During this time when she was supposed to be a clerk, but she acted like a technician, so obviously she had access to the software to enter and process prescription, right? No, at all?
No, somebody does that before, and the person is just affixing labels, is taking a label and just putting
And just
it
to put
on.
it in? Okay.
Mr. Gellenbeck, does your pharmacy take access? Arizona Medicaid?
No, we do not.
Do we have the opportunity to just do the standard working without a license So $50 a day to the permit holder, not to exceed $1,500 civil penalty. Non-disciplinary CE in law for the PIC, and $30 a day for the technician, not to exceed $300 for every day she worked without a license.
That would be what I would go with, and if that's your motion, I'll second.
That's my motion, and I will say 3 hours of CE in law for the PIC.
Second.
Second? All right. Do we need, this is all non-discipline, so roll? We
So
don't-
to clarify, it's $300 for the technician, $1,500 for the permit holder, 3 hours of CE in law for the PIC.
Correct.
If it's non-disciplinary, it doesn't need a roll call.
All right. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you.
Was there something that was associated
About
with it?
her application.
Oh. Ms. Valenzuela, my apologies. We do need you back for 21A. I'm sorry, 21A, tab 21A.
I'll make a motion to approve upon payment.
I'll second.
Any further discussion? All in favor, please say aye.
Aye.
Okay, motion carries. Thank you, Ms. Valenzuela.
All right, let's do 11B and 21B, which I believe is Renee Tilot. And yes. Ms. Mitchell, do you want to give us a brief summary?
Kayreen Joy Titla was licensed as a pharmacy technician on June 28th, 2019. Her license was set to expire on October 31st, 2024. It's been extended through this board meeting to allow time for board consideration. At the time of renewal, Ms. Titla was employed by the San Carlos Apache Healthcare Corporation. On or about August 6, 2024, Ms. Titla was charged with disorderly conduct fighting. She failed to report her charge to the board within 10 working days, and a complaint was opened against her license. The complaint was opened when Ms. Titla applied for the renewal of her license on October 23rd, 2024. Consequently, the complaint and her renewal application are being presented to you today.
Is Ms. Titla present? Max, can you see her online?
I'm here. I apologize. I'm not there in person. I'm sick today.
That's fine. If you could please introduce yourself for the record.
My name is Kayreen Tilla.
Would you like to make any statement to the board before we proceed with questions?
Just that I apologize for failing to report. I've never been in this situation, so I failed my part to know what I'm supposed to do.
Thank you, Ms. Titla. Board members, questions or discussion?
Hearing none, I'll make a motion for $250 non-disciplinary civil penalty for failing to provide notice of new criminal charge within 10 days and approve renewal of license upon payment of that non-disciplinary civil penalty.
I second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Hearing none, motion carries. Thank you, Ms. Titla, for being present. The board staff will be in communication with you. Next up is 11C and 21C. Yeah, we already. Yeah, it was already done. 11C and 21C. 11C is Brandon Hendrickson and 21C is also Mr. Hendrickson. License renewal and a open complaint. Ms. Brown.
Good morning, board members. Jenica Brown, Executive Assistant to the Deputy Director. This complaint contains allegations that the board potentially has not considered before involving personal expenses on a company credit card. As the board has considered allegations of theft of non-pharmacy related merchandise in the past, this case is being presented to the board for further consideration. Brandon Hendrickson was issued an Arizona Pharmacist license on July 30th, 2002. He applied for renewal of his license on October 31st, 2024. The expiration date of his license was extended to December 13th, 2024 to allow the board time to consider this matter along with his renewal application. Board staff opened a complaint against Mr. Hendrickson's license after receiving notification from Revelation Pharma that he was terminated on or about September 19th, 2024 for incurring non-business related charges on the company's credit card totaling $17,897.65. On October 9th, 2024, staff sent Mr. Hendrickson a notice of complaint and requested a response to the allegations. Staff then issued a subpoena for records to obtain documentation from Revelation Pharma. Board staff received a response to the subpoena, which contained a narrative of events in addition to supporting documentation. According to Revelation Pharma, in May 2024, Brandon Hendrickson used his company credit card for several personal expenses. In June, he sent an email to Revelation's accounting department indicating that the personal charges during the month of May were a mistake. Despite his email, Mr. Hendrickson continued to use the company credit card for personal expenses in June, July, and August. He did not report any mistakes and failed to provide an explanation for the personal expenses. By September, he had not reimbursed the company for any of the personal expenses, and he was terminated on September 19th, 2024. Mr. Hendrickson also responded to the complaint and stated that he self-reported each charge at the end of each month on his monthly electronic expense report that was submitted to his superiors and Revelation's accounting department. He also stated that he had additional charges in the subsequent months, which were all related to housing for his wife and daughter, a car repair bill, and fees for a storage unit. He reiterated that he clearly self-identified each charge on his monthly expense report as a personal charge that was to be paid back to the company. He stated that upon his termination, Revelation Pharma withheld his final paycheck in addition to the payout for his unused paid time off and sick time, leaving a balance of $8,081.64 owed to Revelation Pharma. Staff sent a second subpoena for records to obtain Revelation Pharma's travel expense policy that was referenced in Mr. Hendrickson's termination documentation. The policy does not indicate that the company's credit card can be used for personal expenses. To date, Revelation Pharma has not reported this matter to law enforcement, and there are no criminal charges pending. The board has two matters to consider: the facts of this complaint and Mr. Hendrickson's Pharmacist renewal application.
Thank you, Ms. Brown. Board members, just a reminder, we also had an issue with Mr. Hendrickson last month. Staff, if you could provide some context, I think we have an outstanding consent agreement that we offered him. Just keeping that out there because I think that that's still open unless something happened in the last couple of days.
Yep, that's correct.
I did receive that. It'll be signed and returned.
Thank you, Mr. Hendrickson. Would you like to make a brief comment before we proceed with questions?
No, I'm good.
Thank you.
Can you give me a reminder of what the consent agreement is for?
Now that is a separate matter. So Gina, guidance on how we should proceed with that, but I just wanted to make sure that everybody was aware that it was still open.
Yeah. I would defer discussion on the consent agreement that is out to Mr. Hendrickson until and unless you find a violation in this case.
I want to make a motion for legal advice.
Do I have a second?
I second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. All right, welcome back, everybody. Discussion after our executive session for legal advice.
Madam Chair, I have a question for Mr. Hendrickson.
Go ahead, Mr. Dang.
So, Mr. Hendrickson, all these monthly expense reports, were they reviewed and approved by your immediate supervisor?
To my knowledge, yes. Everything I submitted would get approved by my supervisor and then higher ups from there. And those numbers were then used for their monthly reporting numbers.
Okay. And then according to the May 2024 report, you stated that those personal charges were made by mistake. Was your immediate supervisor aware of that?
Yes, the first charges that got made that first month were an error. I notified them of that at the time.
And what did they say?
That it was no big deal. It happens all the time. Just said to reach out to the accounting department and get it squared away.
Okay, then why did the June, July, August happen again?
Those were not mistakes. Those were intentional on my part in order to help alleviate the financial problems I was having at the time.
So those intentional activities, did you inform your immediate supervisors of those activities?
Yeah, I clearly indicated on each monthly report that those were personal charges made by me and that those would be reimbursed back to the company.
And did you get the approval from your immediate supervisor for those intentional charges?
No.
Thank you.
Did you pay back the company when they ask you to make the company whole on the first account?
No, I don't know if there's a miscommunication, but they said they were going to get me an address to send a check to, and there was really never any communication on that.
So, Mr. Hendrickson, you acknowledge that you still owe your former employer $8,000 in change.
Yes.
And what is your plan to make them whole?
It'll have to be some sort of payment arrangement. Unfortunately, I don't have the full amount to just hand over to them. I've not received any communication from them since the termination, so I wasn't sure how they wanted to proceed with that.
Board members, I do want to call your attention to something in the board book. Page 1071 looks like it is screenshots of his expense report for May, June, and August. It does look like he did report that these are personal expenses. There's pretty significant amount of personal expenses here, more than what was originally called out, but he did report it to his employer, so it doesn't look like he was trying to hide that he did this. Which is to me different than just like stealing and trying to cover it up.
I agree with you.
The cases that we've had for theft of non-pharmacy related items were more, I think, distinct from this because while it was an intentional act, he wasn't trying to defraud. It doesn't appear that he was trying to defraud the company based on the evidence that we have. So I think that that's a little bit different than what we've dealt with in the past.
But he didn't have permission to use the corporate card for his personal expenses.
But is that our business versus to me, it's different if he's stealing and misrepresenting information and those kinds of things, because that to me is reflective of his moral conduct and those kinds of things versus an HR violation. I mean, we don't take into account if somebody's late to work. To me, it's kind of the same kind of thing, right? Like that's against a company's HR policy. That's not really our business.
I agree with that.
I agree too. So in that case, regarding the complaint, I would make a motion to,
I second.
I have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. With regards to his license, staff, please clarify for the record. I know we have the outstanding consent agreement. He still has some time on that to sign. Has his license been extended to that date
His license has been extended to February.
for the next meeting?
Correct.
So I would be comfortable making a motion to approve his license contingent upon the execution of the consent agreement.
Second.
I have a motion and a second. All those in favor?
Before you vote,
Yeah.
what if it's not signed and returned? 'Cause right now you're approving contingent upon receiving that. If it's not received, do you want to take action on that or reconsider that in February?
Reconsider that in February, and we were going to go to hearing anyways on the consent, right? Like that's the terms of the consent. If it's not signed, we'll move to hearing, right?
Correct. However, if you, yeah, that's fine.
So I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Hendrickson, for being present.
Thank you. I appreciate it.
All right, let's move to 11D and 24A.
I'm recused due to my employer.
I'm sorry, which item? I'm sorry.
11D and 24A, Banner Health and Deborah Lynn Pruitt. For the record too, Dr. Gandhi shared with me a letter that was sent to us this morning, correct? Dr. Gandhi, or was it late yesterday?
Steve, that was today or yesterday?
This morning.
This morning.
From the original complainant. I have reviewed it. I'm happy to have it added to the book, but I don't believe that it changes any of the materials that we've been provided. Dr. Gandhi, do you agree with that assessment?
I would, Madam Chair.
Ms. Walmsley, Roger Morris, counsel for Banner. We have not seen that letter and I would like to see it before we get started.
Mr. Morris, that letter wasn't shared with the full board, just to chair, so the board's not weighing in on the decision.
My
based on that letter.
misunderstanding. I thought the way that was described went to the whole board.
Yeah, Dr. Gandhi just shared it with me to determine whether or not we wanted to admit it to the packet or not. Since it was received late, we determined that it was not appropriate.
No problem.
All right, Mr. Heiber, please.
Good morning, board. Steve Heiber, Compliance Officer. How do you want to handle this? Do you want to do 11C or 24?
11D. Let's do 11D first.
11D, yes, sorry for that. All right. Okay, case number 240496. The board received a complaint alleging that during the investigation, the internal investigation conducted by Banner into the situation involving the other complaint, 24-0397. That was the case involving some vaccines that had been received warm and returned back to the pharmacy. During the investigation, internal investigation of that situation, getting to the root cause and all that, there was a second complaint that occurred or that was generated and sent to us. And that the allegations in the second complaint stated that products that were allegedly expired over 8 years ago or up to 8 years ago, many visibly contaminated with what appeared to be black mold, were placed on the desk of the individual who filed the complaint. This complaint came in tagged anonymous. So, I removed the complainant's information from this complaint that was sent to you. The complainant also stated that the designated representative placed those contaminated products on her desk. And for sorting and identification, the complainant also stated that her manager, who is on the board profile for this wholesaler permit as the designated representative, had only visited the facility one time over the prior 4 months, and that employees were not trained on the handling of hazardous drugs. And then lastly, the complainant stated that she had some concerns alleging that she and a coworker were coached on what to say when the pharmacy board performs an inspection. The complainant stated that they were told not to ask any questions or say too much. We did receive a response. It actually came from the CEO and also signed by the designated representative. They stated the warehouse employees did discover those expired products, but they were in a waste bin. They were not loose. They were in bags. When the CEO stated they were in bags when they were placed on the desk. And there are images in your packet. You can peruse them, page 1127 through 1134, and you can see the actual products are in bags, those photographs that were provided to us. Banner stated that there was one employee who wasn't properly trained for handling of hazardous drugs. That employee was identified and then subsequently trained. The CEO at Banner also stated that as of August 1st, that issue with the training has been corrected. And they also deny that they told employees not to be truthful in their interactions with the board. If you have any further questions, just let me know. Thank you.
Thank you, Mr. Hyber. Mr. Morris, would you or someone from Banner like to make a comment?
Sure. First, I'm going to have everybody introduce themselves, just so we know who's who. Yes.
Deborah Lynn Pruitt.
Tell them your position.
I am the procurement manager for Banner Health,
You're the designated.
and I am the designee on the wholesale licensure.
I'm Kevin Roach. My position is Senior Director of Pharmacy Prep and Dispensing for Banner Pharmacy Services. I'm Deborah Lynn's leader.
And I'm Steven Sorosky. I'm an attorney with Banner Pharmacy.
And then Roger Morris, counsel for Banner. We also have a couple of other senior officials from Banner in the audience, should we need them to be able to go forward with this. I know you want to do 11D first. 11D is sequentially second after 24A, and some of the events that occurred for 24A may be relevant to do 11D. Would that be okay for Mr. Hyber to go through 24A also so that we can put it all together?
Yep, that's fine. Go ahead, Mr. Hyber, and then we'll let you take a stab at it, Mr. Morris. Thank you for that.
All right. So as Council Morris stated, that this case precedes the most recent case that I described earlier. This case has already been through board review at the previous board meeting, and it was scheduled for a conference today, I believe, under 24A. This complaint, to just go back once again on this, is the wholesaler failed to quarantine some drug that was returned back to the wholesaler. The drug had been shipped out to a clinic in Tucson. This wholesaler's primary purpose is to receive drug product and then distribute it to Banner facilities. That might be other Banner clinics or pharmacies, et cetera. They don't distribute outside of that group, as far as I understand. That product that was shipped out to that clinic was received warm. The clinic called back to the wholesaler, the distribution point at Banner, and they said, we received it warm, we're concerned, and then they were told to return that product. Now that, if you go in and dig into this case in the documents, you'll see that's contrary to Banner policy. They aren't supposed to ship back any refrigerated products. So that was breakdown number one that occurred. Then that product came back, and when it came back, there was some discussion apparently between the employees that were working that day and they decided that that it wasn't something that needed to be quarantined and removed from active inventory, but on the contrary, it was placed into active inventory. And bear in mind that these return drugs involved several vaccines. I believe it was like 9 different vaccine products with lot numbers that matched up with the lot numbers that were already in the pharmacy. So when they were improperly returned back into the inventory, they were intermixed. So now it was like basically doing the shell game, right? You didn't know which one had the contaminated product anymore. So all these products were left in inventory, and then they were subsequently distributed out to other clinics. That resulted in, once this complaint came in and then we notified Banner, then they realized, oops, we've got an issue we've got to address. So then they put a hold on everything that was out there that was related to this original shipment, and then they were able to do a recall, and it impacted a total of over 4,500 different vaccines. There were some vaccines that were unfortunately administered during that time frame between it coming back, being intermixed, and getting redistributed before the notice went out to put it under quarantine. And that was a total of 14 doses were administered with up to 19 impacted patients. The practitioners were notified, and those patients were obviously under the appropriate surveillance in order to look for any possible side effects. And I think I've covered everything. If I've missed anything, I'm sure council will let us know. That's it. If you have any questions, let me know.
Thanks, Mr. Hyber. Mr. Morris?
Sure. Obviously, very serious issues here. Banner has taken them very seriously. A number of very significant changes have occurred in Banner's operation, including personnel changes, movement of supervision. And with that, Kevin, why don't you start and describe what happened, how it happened, and why it won't happen again?
Thank you. Overall, Mr. Hyber's summation of the facts of the complaint on the vaccine handling incident are accurate. The Banner Health staff violated policy and accepted a return of possibly temperature compromised vaccine and subsequently put that vaccine back on the shelf for redistribution. There are a few points that I'd like to address based on some of the questions raised in the board's complaint committee. Prior to this incident, the operation has had a longstanding policy, as Mr. Hyber mentioned, on return of pharmaceuticals that specifically states that any cold chain product would not be returnable. There have been questions about the employee's knowledge of this policy, as this incident was a violation of policy. Less than 2 weeks prior to this incident, on July 1st, the personnel manager for those employees reached out to me, copying those employees, to inquire about a possible product return scenario. It didn't deal with refrigerated product, but it was a return question. Both pharmacy technician employees were copied on the email. I directed him to the policy online and asked if the policy allowed for that scenario, and if the policy required any modification or revisions going forward. He stated that he would review that with his team. He responded a few hours later to me on July 1st and stated that he'd reviewed the policy with his team and that they were supportive of how it was written and there was no update needed to the policy. We decided that it would be a good opportunity to remind our facility buyers about the policy. So on July 2nd, the following day, one of his technician employees addressed this policy on our weekly pharmacy buyer call. So they reviewed the policy with our buyers. There are emails and meeting minutes that support this incident. Overall, we're very frustrated that this incident was not reported to us earlier. The employee that reported this to the state board reported it to Deborah Lynn and I after the board complaint had been submitted. The doses were put back on the shelf at the end of the day on Friday, July 12th. Deborah Lynn and I had reached out to the department employees and their direct line supervisor on the following Tuesday, July 16th, to schedule a mock inspection of the operation and review compliance with Arizona Board of Pharmacy Wholesale regulations. There was a direct opportunity right there to escalate concerns or issues with that scenario. Once informed of the incident on the afternoon of July 18th, Deborah Lynn and I acted aggressively to interview staff, pull data on shipments at risk, and notify receiving customers to immediately quarantine product. Mr. Hyber's correct about the over 4,500 doses that were either shipped to facilities or stored within the wholesale or refrigerator that we could not rule out as possibly being part of that initial shipment. The financial impact of having to discard those doses was over $500,000. Since this incident,
Kevin, just to interrupt, there were 140 doses that came back, correct?
it was 160 doses from the Tucson
And
clinic.
that resulted in the 4,500 potentially compromised.
Correct.
Can I ask a question too? It says that you plan to destroy those. Did you actually destroy them?
The doses have been
Okay.
destroyed.
Yeah, okay. Just wanted to
We were
clarify.
waiting for reverse distribution.
Yeah, just in our notes, it says you plan to,
Yes.
so I just wondering what happened. Okay.
Yep. We recognize the importance of acting in the best interest of public safety. And since this incident, we've made significant organizational changes to address this issue and prevent it from ever happening again. The manager and the technician employee and the wholesaler who made the determination to put the vaccine back on the shelves were terminated. The reporting structure of the employees in the department was moved from a supply chain reporting structure to pharmacy, directly reporting to Deborah Lynn. The employees in the department were re-educated on the returns policy and compliance concerns escalations in general. A new SOP and process was developed and deployed to intake and record customer complaints and ensure visibility by management and leadership. Our courier was immediately engaged to modify delivery schedules to reduce the time from order pick to deliver for our Tucson deliveries where this occurred. And we've begun including temperature tags in our refrigerated shipments, and we've educated our receiving facilities on the interpretation of these temperature tags. We recognize the seriousness of this event. We feel that we responded to the immediate incident with the appropriate aggressiveness and conservatism in our approach. We believe the significant changes we've made to this operation will prevent this type of issue from occurring in the future.
Kevin, do you want to talk about the other incidents now?
Sure. If we want to move to the other subsequent.
A couple questions, if you don't mind, just before we switch. You said there were 2 employees that returned them back to the shelf once it was received, correct?
There was, working that day, there were 4 employees, 1 unlicensed employee or non-permitted licensed employee. He was not involved in the discussion. The 2 technician employees and their manager were working that day. The way it was discussed to us is that one of the technician employees and their manager made that decision, and the other technician was not in support of that and subsequently submitted the complaint.
And those were the 2 that were let go?
The technician and the manager, correct.
The manager of the technician was a non-licensed person?
Correct. He was a supply chain employee.
This is Kevin Dang. Are these staff who were involved with the complaint new employees at the site?
No.
How long have they been working there, sir?
At the time, I don't know exactly. Well, are you referring to the employees that were terminated or?
Yep, all of those employees who were involved with this complaint.
The employee who submitted the complaint, I believe, started in March. The others had been Banner employees for longer than that. I don't know higher dates on either.
So my subsequent question is for Mr. Haber. Mr. Haber, when was the last time that you inspected this facility?
The wholesaler permit was recently inspected after this incident, and they passed with satisfactory results. Prior to that, it had been over a year since we inspected the facility, more likely 2 years, Mr. Dang.
Thank you. So the inspection that took place 2 years ago, everything was fine, right? There were no issue with medication, adulteration, or anything?
No, we didn't have any, we didn't see the expired products during that inspection. And I think if you read closely, some of the products were up on a high boy shelf in a tote on a high boy shelf, which we wouldn't routinely climb up about 30 feet to look in totes. So we didn't see it then, if that's what you're asking.
Yeah. So what baffles me about this incident here is that these employees have been employed at the site for quite some time. So they're not inexperienced staff. They know what they're doing, but what caused them to not properly reporting up to the chain of command? That is what I'm baffling about.
I'm sorry, I'm gonna, so I believe there was a policy in place, and we have 2 or 3 employees did not follow the policy, and they got terminated. And I believe the leadership was not aware of the issue until somebody filed a report to State Board of Pharmacy. And then from my perspective, the permit holder, I believe they went above and beyond by recalling hundreds of vaccines. And I'm assuming, did you reach out to those patients? You said 19 patients?
The reach out was performed by the clinic, nursing and providers.
And they did, right? So, yeah. So from the respondents, like, I believe they did their best to protect public, and then the people who was involved or made the errors, I believe they got terminated. So I don't see there's anything we can hold this permit holder accountable on those in this case, is my perspective.
I agree.
So I'm ready to make a motion on this one for vaccine, unless anybody has any comments
On 24,
for the
20
vaccine.
24A, the
20
conference.
Not the 24A, the one for
Yeah,
vaccine.
that's the conference.
Yeah. Okay.
That's 24A.
Yeah. So I move to dismiss this.
Before you do that, you've already made the decision to kind of hold these together. You heard discussion on one, then
On
jump to
one.
the other. It may be best to hear all the discussion, and then take action individually.
Is there any other discussion? I think
don't know that we should keep these together necessarily, because I think it's starting to ask questions and conflating them both.
let's do 24A. I feel comfortable making.
Madam Chair, just a quick question. How long are you monitoring those patients that were administered the vaccine?
I can't speak to the monitoring of the patients and that process. We consulted with our clinical pharmacy leads, our risk and compliance leads, and ultimately the nursing and physicians, and the decision or the guidance was to have the clinic staff and providers work with those patients to offer revaccination and monitoring.
Just a follow-up. So if, let's say it was a 6-month follow-up protocol or whatever you guys have in place, if something happened a year from now, my assumption is you would deal with it appropriately.
Yes.
Tariq, I think you're leaning towards dismiss. For that reason, I would be more comfortable with a non-disciplinary letter of concern to memorialize the fact that this happened. I acknowledge the fact that you've made a lot of improvements, and I don't want to discount that, but this is there were a number of patients that were potentially impacted by this.
Okay, so I rescind my motion.
Well, you didn't have a second yet
Okay,
anyway.
right. So yeah, so I will make a letter of concern my motion.
I amend my second.
Oh, you did have a second? Okay. All right. So we have a motion, a second. All those in favor? Well, wait a second. Dr. Gundys.
Letter of concern reflecting what, Madam Chair? Just proper storage and handling?
Yes, I think that's appropriate. Mr. Al-Nassif?
Yeah, this is my motion.
Okay.
Yeah.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Back to 11C D. Any further discussion, or are we ready
Can
for a
I-
motion?
He has some more discussion
Sure,
about
okay.
11D, if that's all right.
I would like to just clarify a few things. First and foremost, none of the bagged and expired products were placed directly on an employee's desk. It was on a table adjacent to the desk. The employee was actively involved in the inventorying process and did not raise concerns at the time. We had two other pharmacy technicians present during that event who were not employees of the wholesaler, but were present during that event and helped with the getting the waste ready for disposal. We interviewed the staff that were present. We reviewed the security footage of the incident. None of the staff members interviewed by us or by Banner or HR expressed any concerns about how the incident was handled in terms of how the waste was handled. I did want to just clarify where the expired product was per Mr. Hyber's comments. The expired product and the product that had a mold-like substance or what was suspected to be mold was in a blue waste bin. So I acknowledge that blue waste bin should have been emptied and disposed of in a more rapid fashion. But I don't know why the staff did not take the waste out or work with our waste disposal company on doing that. We do have, we had a vial of expired drug in one of our refrigerators. That drug in the refrigerator had been removed from the orderable or available inventory, so no facility could have ordered it. And it was not visible to us when we reported or pulled data on our expired products or our soon-to-expire products. That's a violation of our outdated.
But that product was quarantined?
At the time, not until it was reported to us that there was a vial in the fridge.
Okay.
So that should have been removed out of the fridge as in compliance with our outdated and unusable medication policy. It would have been quarantined and sent for destruction. We've re-educated staff on this policy. And going forward, we will be reviewing waste in the waste bin regularly and continuing to reinforce outdated and unusable policy with staff. There were other elements of Mr. Iber's discussion on just the handling of hazardous medication. He's correct that we had an employee who was a non-pharmacy technician licensed employee who did not have hazardous medication handling competencies. We worked to develop or to assign a learning module to that employee, and we reviewed all of the hazards classified meds in the department, their specific risks and handling precautions, and developed a SOP for staff on their handling of hazardous medication.
Just as a note, in future meetings, this board will be dealing with some remodels from this facility for its additional changes. So more of these issues can't happen, but they're going to be doing some changes.
Thank you. Board members' questions?
I have a question. You kind of touched on it, but I didn't get clarity. What are your corrective actions that you've taken? You kind of alluded like we might be taking some actions further, but I want to hear like a little more concrete what corrective actions you've taken.
In terms
regarding getting rid of products that are sitting for quite a long time and having mold in them.
Well, we've reviewed the waste process, and we're looking at, as part of our walkthroughs in the department, looking at what is in that waste bin as it's getting product in there. When do we need to schedule for disposal? So it's becoming more of our regular inspections as we walk through in the department.
So like you've added it to a for the employees to do within a certain amount of time frame? Like, is it every week that you check the bin? Is there anything concrete like that in place?
At this point, we do not have a checklist for the employees to check the waste bin. It's been part of my walkthrough of the department, Deborah Lynn's walkthrough of the department to look at that bin, but has not been part of a formalized checklist. We will make that part of our inspection checklist.
So for handling hazardous drug, do you use a third party for disposal to dispose expired
Yes.
hand? Okay. So I believe when you use a third party, you're required to do OSHA training, right? For people to, when you handle the expired drug to a third party, There is a special training for
So
OSHA.
just to be clear, remember, this is a wholesale facility, so all
Yeah.
of these remain in their sealed original manufacturer containers.
Okay, that's my second question. So you don't break packages, you don't manipulate tablets, you don't crash, you don't do any of this, right? So you keep it in the sealed package. Okay.
Mr. Hybrid, did you want to make a comment?
Yeah, I did have one thing. I haven't heard any talk about the reason why I noticed Deborah Lynn Pruitt on this complaint was one of the requirements for a DR is, and I'll read it right from the statute. The designated representative of a full service wholesale permittee must be actively involved in daily operation of the wholesale distribution of prescription only drugs. That's under ARS 32, 1982 B3, if you're interested. And I know she wasn't there because the response indicated that they had changed her schedule during COVID. And when, basically she was working remotely during that time, she wasn't coming in. And I know we made a lot of exceptions during that time, but she should have resumed coming back in on a regular basis. So the supervision would be there for the employees as well as compliance with the statute. So, and they did commit that her schedule as of August 1 had changed and she was now making regular visits. But I did want to point that out if you had any questions in that regard.
Yeah, that I'll acknowledge that was my oversight that during the pandemic, we changed work locations. I asked that Deborah Lynn work from home during that time. And I acknowledge that when we emerged from the pandemic, she should have gone back to the place of business. I should have directed her to go back. That said, there was a direct line supervisor to the employees in the department that was on site. There was regular communication on all operational decisions between our team and that leader and the individual staff members. We did audit the operations and we provided a pathway to escalate issues and concerns. I think that's evident in the July 1st email where I got the supervisor reach out with a question on the returns policy. They are reaching out. I think, once this the complaint on the vaccines was submitted to the board, the employee did eventually escalate it to Deborah Lynn and I. So there was knowledge of where to escalate and how to escalate concerns. It just wasn't done in a timely fashion.
I have a question. So are these two things correlated? The lack of you being in person and this being missed? Because is it your duty to check the waste bin?
At that time, they were under different management, under supply chain. Since this has occurred, we've restructured. It is now under Banner Pharmacy Services, and I am managing that department. So I am there daily.
Now you're there daily.
Yes.
Before you were there, how often?
Well, before the pandemic, I had an office in the building, but they were always managed by another person. Now I have that personal responsibility.
So during the pandemic, you started working from home exclusively, and then it carried out until this was brought up, this complaint was.
Yes.
You were, okay.
There was one other issue that was read by Mr. Hyber from the complaint about preparing for the state board visit. Kevin, do you want to tell him what you did?
Of course. Yeah, I've repeatedly told the employee that submitted the complaint that she did the right thing in escalating her concerns. We've told employees that when communicating with an inspector, answer the questions directly and be truthful in your responses. And if you don't know the answer, be truthful that you don't know.
Additional questions, board members? Thoughts?
There's no violation of law for holding on to expired meds too long as they're quarantined. Right?
No, the rules and the statutes don't go into that level of granularity. They should be removed from active inventory for obvious reasons and quarantined pending return.
I'm comfortable with dismissing this one for both the permit holder and Ms. Pruitt.
I don't think that's appropriate. I think that it's been acknowledged that there's not been, let me see what the term was, actively involved in the oversight of the warehouse. And that, I feel like that led to this being an issue and things potentially being missed.
Well, I believe she stated that somebody was supervising that, but not her. She was working remotely, but there is somebody was in charge of that facility. That's what I understood. I heard.
That's what I heard too.
Yeah, and then what that issue raised, now she gonna be the responsible person for that department. Is that right?
And may I add, we always had constant communication with this department. If they had any question about policy or anything appropriateness, any question at all, they'd reach out to us. I mean,
Yeah.
we would have multiple times per week
Yeah.
communication. So we weren't completely cut off.
There were existing standing meetings with that team and with our contracting team as well, jointly to discuss operational decisions about, what product is moving, how to, work with our facilities to ensure compliance, facility level changes, adding new accounts, adding new users, just the nuts and bolts and operations of that wholesale operation. Deborah Lynn was involved in that.
And that person who was in charge of this facility no longer with you, right? This is just terminated.
That's
So yeah,
correct.
that's my understanding. Yeah. So there is direct supervision, supervisor there.
The
I mean-
pictures to me are pretty alarming, though. It's pretty disgusting that something would sit in a place where there's medication for such a long time and not be handled and disposed of correctly.
Yeah, it's quarantine. Yeah, I agree with you. I mean, I don't want to see that, but it's quarantined, and there is nothing in our statutes or rules says how long you're gonna quarantine. I agree with you. There's a concern about mold on some products. So, but still, there's no violation for this item there. I don't see any violation there. I mean, I have a concern for sure.
And we
So,
have clarity that it was quarantined. It wasn't in multiple locations. It was all bagged in that same blue container and quarantined.
Those pictures that that were submitted with
Yeah.
the complaint were products that were from that blue bin, correct?
Right.
So instead of dismissing, I would be fine also with a letter of concern, like due to storage, same like for unhandling hazardous drug. Just you need just to train all your staff.
To me, that's the minimum. So
Yeah, that's the minimum instead of dismissing. So this is my motion, like letter of concern due to handling, like lack of training for handling hazardous drug.
Do we have evidence that that actually occurred?
Yeah, they admitted that they never trained. I mean, they don't have any documentation for training, right?
The one gentleman who was not trained appropriately, who has since been, was the forklift driver.
It's only one person. Oh, okay.
Does that really fall under our jurisdiction, or is that an OSHA issue?
It is an OSHA issue. But I believe State Board of Pharmacy can enforce federal and state rules. So
So I had a motion by Mr. Al-Nassif. Do I have a second?
Second.
A motion and a second. Any other discussion?
Just to be clear, the advisory letter is to the permit.
to the permit, yeah. And then
And dismiss Ms. Pruitt.
I'm dismissing.
Dr. Gandhi? Oh, well, we don't need a roll call. All those in favor?
Aye.
All those opposed? Nay. Motion carries. Thank you for your time on both of these matters.
Thank you.
Let's move to 11E, which is Sophia Renee Grant, and I am recused.
Good morning. This is complaint number 24-0581. Respondent is Sophia Renee Grant, and board staff is Ms. Brown. Ms. Grant, are you on the line?
I am.
All right. Could you please introduce yourself for the record?
My name is Sophia Grant.
Thank you, Ms. Grant. Ms. Brown, would you please provide a brief summary for the board?
Certainly. Sophia Renee Grant was issued a pharmacy technician trainee registration on April 6, 2022. It expires on April 30th, 2025. Her registration is currently open. On August 29th, 2024, Ms. Grant disclosed an incident that occurred on or about March 4th, 2023 in Lynn County, Texas, in which Ms. Grant was arrested and charged with possession of a controlled substance, prohibited substance, tampering with evidence, and unlawful carrying of a weapon. The police report included in the board's files for consideration describes in detail the events where Ms. Grant had drug paraphernalia on her person and claimed ownership of an illegal handgun, as well as marijuana, ecstasy, and cocaine. Ms. Grant also submitted a written statement to the board claiming that the only thing that belonged to her was the gun, and she claimed ownership of the other items to prevent everyone else involved in the incident from being arrested. Of note, this disclosure was submitted to staff after board considered a separate matter related to Ms. Grant at the August 2024 board meeting. In preparing for hearing of her separate matter, staff realized that her disclosure on August 29th had not yet been addressed. On November 4th, 2024, board staff opened a complaint against Ms. Grant's pharmacy technician trainee registration for failure to report charges within 10 days and issued Ms. Grant an interim order for drug screening due to the seriousness of the allegations that were outlined in the police report. The interim order required Ms. Grant to provide a urine and hair sample to a drug screening lab no later than 5 p.m. on November 6, 2024. Ms. Grant responded to the complaint and subpoena on November 5th, 2024, and stated that she had already sent all documents and information about the case in Lynn County, Texas, a few months prior. She provided an order for dismissal that was signed by a judge in Lynn County on March 25th, 2024, in addition to the same statement that she provided staff on August 29th, 2024. On November 7th, 2024, board staff attempted to contact Ms. Grant regarding her compliance with the interim order. No response was received. Board staff attempted contacting Ms. Grant again on November 12th, 2024. She responded on November 14th and indicated that she is willing to undergo a urine test, but is not willing to provide a hair sample. Ms. Grant also stated that she will be in Tennessee until the beginning of December to deal with personal matters and is not unwilling to comply, but is not available to do so. This case is before the board for further discussion and consideration of Ms. Grant's failure to report charges to the board within 10 days, as well as her noncompliance with the interim order for drug screening.
Thank you, Ms. Brown. Ms. Grant, would you like to make a statement to the board before we proceed with questions?
No, I'm okay.
Board members, the floor is open for questions.
Ms. Grant, why are you unwilling to provide a hair sample?
I- Honestly, I do know that I'm an African American person and that chemically, like I have a lot of dye and things in my hair. I don't know what it may come out to be as far as that testing. Um, I was on probation and had to do random drug tests uh, throughout that year, which ended basically when I came in on my birthday, August 16th of 2024 is when my probation ended. Um, I haven't had any dirty drops or anything like that. So if I'm able to give you a urine sample and provide through the state those drug testing results, then I can do that. but that's my response on that. I'm sorry.
So to clarify, you've dyed your hair and thought that that would mess up the result of the test? Is
Well,
that-
my hair has been constantly dyed, like different chemicals. So I'm not sure if that would have any type of negative effect on the results. Yes, ma'am.
Ms. Grant, as a follow-up question, you were ordered to submit a drug test before November 6th. Today is December 11th. Why did you not at least submit a urine before November 6th?
I had no problem with it at all. I can't tell you why I didn't go and just do the urine. I have no real reason why it wasn't no, I'm not going to do it. I just thought that I had to do both, and that was the reason why.
Mr. Anderson, this is Kevin. I have a question for Ms. Grant.
Yes.
Ms. Grant, would you be willing to have your nail tested for controlled substances?
You said my fingernail?
Your fingernails, yes.
I guess I don't know. Why?
Okay.
What is a fingernail testing?
I'm sure there's a way that they can identify controlled substances through the nails.
Okay. Um, I'm I don't know anything about that, but this was something that happened. Yeah, yeah, I don't. Yeah, that's fine. I don't know. I guess.
Okay, so to summarize, we asked you to get lab work done to see if there has been any substances. You have not done any lab work. You've not undergone an evaluation, and you reported to us in an untimely manner. So I don't know.
Ms. Nair, there was no evaluation requested.
Oh, I thought there was.
So,
This drug
just to state this,
Oh, excuse me.
when I do apologize. I'm not trying to speak over anyone, but as far as like reporting in an untimely manner, like I was actually in jail in Texas. The last job that I worked actually with my pharmacy license, I haven't worked. I haven't done any pharmacy work since that incident, right? And so um I reported it. It is my fault that it was late. I had a lot of stuff going on dealing with the previous incident, which I was at a meeting for there. It's just a lot. I had a kid that died, right? My daughter died. And so being in jail for basically a month, losing my job, coming home, not having anywhere to live, it was just a lot. So reporting this was not like, it didn't really register in my brain at that point in time because I had other things to deal with. Um, that is my fault. I can't disregard that. But yeah, that's my reason. Like I I wasn't able to reach out to you within the 10 days because I was incarcerated.
Miss Grant, I'm really
Yes.
sorry for your loss.
Mhm.
And I do have another question. Do you want to continue working in the pharmacy field?
I do, but I wanted to get everything straightened out so I don't have any hiccups or anything about my license going forward. That's why I haven't applied to any pharmacy jobs. That's why I haven't that's why I haven't pursued anything in that line of business because I wanted to make sure everything with the board was straightened out. Like my license, I'm still on a trainee license. I need to take my test to be certified through the national board. I don't want to go into taking that test and get certified, and then I have to deal with anything on the back end.
So that's a good follow-up question for you, Ms. Grant. So, I mean, your license, your trainee permit or trainee registration expires on April 30th. So
Yes,
we're
ma'am.
looking about, 4.5 months left. Have you studied for the PTCB exam?
Yes,
what
most
sort of,
definitely.
so, and you're willing and able to take the PTCB exam within this time period before your license lapses?
Yes, I am.
I'm sorry, I still have a concern about not providing hair sample. I mean, I believe she should provide us with hair samples. There is no way around it. We need to make sure she's safe to practice, and I don't think there's anything around this. Or maybe like nail sample that will satisfy also if she's, but I don't think any dye or something would affect the result. And if there is any false results, we can discuss that, right? But
Exactly.
But not following a board order is concerning
yeah,
to me.
correct.
And is she regulatable is a question that's
Correct.
coming up in my mind when she's a trainee and just getting started in the
Absolutely.
field.
Absolutely.
So
She wants to move forward, but I don't see that you're taking the steps that you need to move forward.
I'm sorry. It wasn't like, no, I don't want to comply. That is not
But you said you're
yes.
not willing to do the test that we asked for you to do. That
Well,
is something you don't
I
wanna
don't
comply.
want I don't want to submit a sample that would possibly come back that is not correct. And I do understand there are things that you can go through to like if it came back inconclusive or whatever about my hair. This is
But
my
your
hair.
response regarding that is suspicious to me, because why not get it done and then talk about the results? Why are you throwing up a barrier to getting it done instead of getting it done and then if there's some anomaly, then discussing that at that time?
Basically, I'm looking at my situation. I, I as in my answer for my statement that I took that charge because the main reason I had a teenage child in the car. And so I did what I needed to do to keep my kid out of harm's way. I was in the car with two other adults. I do not, I can't
Sorry, Mrs.
take,
Grant.
I
Sorry for
can't,
interrupting. Sorry. But the concern here is you didn't comply with the board order.
okay, so
And this is an issue there. I mean, being a pharmacy technician, trainee, or certified, it's a serious job. You know what I mean? Like you have board
it
to
is,
follow, we have rules. We cannot just let people act on their own and not following the board order. You know what I mean?
yes,
And just
sir.
because you have assumption that you will get a false results from the hair sample, which is I totally disagree with you. And I believe you should have like follow the order and provide a hair sample and that's it. And then if you come with a false results, we discuss that within during our meeting. But you should not, and you're not allowed to not follow our order. And this is my issue here with you. I mean, a lot of details. We can keep talking about this for hours and hours.
Yes, sir.
And we're not going to go anywhere. But the fact is that you did not comply with the board order.
Thank you,
And
Mr.
as a board members, we cannot allow that happens ever, never.
Thank you, Mr. Nassif. I think we've had some very good productive discussion here. Are we ready for a motion?
So what options do we have here?
We can proceed to hearing if that's what we'd like to do.
Yeah, I move for hearing.
We have a motion to move this complaint to hearing. Do we have a second?
I'll second.
Any?
I mean, did I make that motion or am I seconding my own motion?
You second my motion. So
Okay,
it was
good.
my
Okay.
motion, move for hearing.
Great.
Any further discussion? All right, roll call, Dr. Gandhi, please.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley's recused, Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, one recusal and one absent, Mr. Chair.
Thank you, Dr. Gandhi. Ms. Grant, the board staff will be in touch. Thank you.
Thank you.
Sixteen A, Madam Chair.
I'm just trying to get my board book to go again, and it's not cooperating with me. 16A is Neogen Corporation. Is anyone present from Neogen?
Yes, Madam Chair, my name is Isaac Hall. I am Commercial and Compliance Counsel with Neogen Corporation.
Thank you, Mr. Hall. I see Mr. Kapoorty joining us. If you could give us a brief summary.
Good morning, board members. This is Ram Kalapuri, Compliance Officer with the Board of Pharmacy. So Neogen Corporation, located in Mount Sterling, Kentucky, applied for a non-resident full-service wholesaler permit with the Board of Pharmacy. In the application, the applicant disclosed that the Mount Sterling facility's wholesaler permit briefly lapsed in 2023 due to administrative oversight, and agreed to pay the Kentucky Board of Pharmacy a fine through informal settlement. The Kentucky Board of Pharmacy renewed the permit after an inspection later. From March 2023 to July 2024, Neogen Corporation distributed 900 units of prescription and 19,200 units of non-prescription veterinary products in Arizona without a permit. The facility has been operating since 6/30/1981.
Thank you, Mr. Calabrese. Mr. Hall, do you have anything to add before we proceed with questions?
Yeah, I wanted, I guess, to clarify a couple factual aspects about this. The Mount Sterling facility is a newer distribution facility that Neogen opened in March 22, prior to the opening, or sorry, March 22nd, 2023.
Madam
Prior
Chair,
to the
just confirm whether he's representing them in a legal capacity or as a fact witness. And if he is in a legal capacity, is he licensed in the state of Arizona?
Mr. Hall,
Who's
can
his
you address
counsel?
that question?
I understand myself to be here representing Neogen Corporation in a legal capacity. And no, I am not licensed to practice in Arizona. So I am aware of certain of the facts of the facts in this case, but I would be relaying secondhand information. So I can mute myself and observe further proceedings if necessary.
Mr. Hargraves, could you provide some direction?
Well, if he's representing them in a legal capacity and he's not licensed in the state of Arizona, he can't represent them at this time. Is there anyone else from the?
Yeah, Mr. Hall, is anyone else present that could represent the company?
No, Madam Chairman.
Madam Chair, was there someone that can appear this afternoon on behalf of?
I should say we had submitted a request for an extension, because the regulatory individual who is primarily responsible for these activities had a sudden emergency, a family emergency, a death in the family. And so is unable to attend today. So my request, understanding my limited ability to make such a request, but my request would be to extend consideration of this until the next board meeting where we can ensure that that we have Neogen fact witnesses available to answer the board's questions.
I'm comfortable with that. Do we
Yeah,
need a
let's do
motion to table?
Madam Chair, we can do that, as well as maybe direct me to work it out since they did have shipment, and I think typically
that's-
we have.
Yeah,
we entertain
that was the
discussion.
direction I was going to go, but I didn't know if there was other facts that they wanted to present to the board for consideration. But I mean,
If during my conversation, there's other things that I'm concerned about, we can cease that conversation and present it at the February meeting.
okay, so my motion will be to table the matter, but also allow Dr. Gandhi in the interim to potentially work on an agreement for the unpermitted shipping to bring back for us for consideration if
Second.
necessary.
Second.
Is there an opportunity to perhaps allow Dr. Gandhi to negotiate the non-disciplinary civil penalty?
Yeah,
And then once it's negotiated and signed and paid, to just issue the permit without restrictions, or does it need to
It's-
come back?
It'll need to come back. to you.
Okay.
But it'd be non-disciplinary or disciplinary.
Correct. Whatever you're able to negotiate. Mr. Thorwald, are you in agreement with that?
I am.
Let's do roll call because it might be discipline.
Well, discipline, but it's going to come back to you guys for
Okay.
final vote.
So all those in favor?
Aye.
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 Any opposed? Hearing none, motion carries. Thank you, Mr. Hall. Board staff will be in communication.
Thank you.
18A, Pierre Fabre Pharmaceuticals.
Hi, present.
Hi, if you could please introduce yourself for the record.
Hi, my name is Chester Lamb. I am the designated representative for Pierre Fabre Pharmaceuticals.
Thank you. Mr. Jacobson, if you could provide us a summary.
Good morning, Board of Pharmacy. Max Jacobson, Compliance Officer, Arizona Board of Pharmacy. Pierre Fabre Pharmaceuticals submitted an application for a non-resident manufacturer permit. During the substantive review, it was discovered that a change of ownership had occurred without notification to this board. The ownership change effective date was February 29th, 2024, and the application that served as notice of ownership change was submitted June 14th of 2024. According to company records, they shipped or directed the shipment of 49 units into Arizona between the effective date and the notice of ownership change. There was also disclosed discipline within 5 years on the application, and there was discipline for the PIC. There was also discipline in Georgia that was more than 5 years old.
Thank you, Mr. Jacobson. Mr. Young, would you like to add anything before we proceed with questions?
No.
Okay, thank you.
I have a question. Is the transfer of ownership within the same parent corporation, or is it just a straight ownership from new people or new corporation?
I guess the permit holder could speak to that. Go ahead.
Sorry about that. No, so the change of ownership was actually from Pierre Fabre USA to a new company that was not disclosed to me as a designated representative until June. So that's why notification was delayed.
I'm sorry, I didn't get it. So it is within the same parent company? No, it's different.
It's a different company.
So standard non-disciplinary terms is $100 per shipment. So
Well, we can just ask that board staff work with them to come to an agreement regarding the items that are shipped, whether it be disciplinary or non-disciplinary.
In addition to the late change of ownership, so combine the two.
I kind of assume that would be part of the agreement.
but if we wanted to wrap it up today, we could approve the application upon payment of a $4,900 non-disciplinary civil penalty for the items shipped and a $250 non-disciplinary civil penalty for failing to provide notice of change of ownership. So
Or allow Dr. Gandhi to work out a consent agreement for discipline at a lower amount, potentially.
So it'd be
I think at the last board meeting, I think we took a different route upon me agreeing and they agreeing to a certain civil penalty, discipline or not discipline, that upon payment, their application would be approved so that we can do it sooner than later.
I didn't, I was just discussing.
Thoughts? That seems appropriate to me.
To give the option of either or.
Yeah.
Take care of it today or.
And to approve the
discuss.
permit.
Okay.
All right, I'll make that the motion to approve the application upon payment of a $4,900 non-disciplinary civil penalty for the item shipped into Arizona and a $250 non-disciplinary civil penalty for failing to provide notice before there was a change in ownership, for a total of $5,150 non-disciplinary civil penalty. Or option 2 would be to negotiate terms with our executive director. That would be my motion.
We've typically not done that. They may not have the authority to do it either,
Mhm.
to make that decision.
But we wouldn't know unless we ask.
Oh, this is a question for me. Yeah, I don't have the authority.
Do I have a second to the motion?
Second.
I have a motion and
Well,
a
there may be an issue here because the motion is to approve upon payment of the non-disciplinary civil penalty. So you're essentially issuing that. So if they don't pay that, then they're non-compliance with an order.
So can we reframe the motion?
Maybe just we do our standard, like allow our board staff and Dr. Gandhi to negotiate.
Do you guys want to
The,
withdraw your motion?
The attempt was to expedite it, right? I understand that. I think we just stick with our typical, and I'll rescind my motion or amend my motion, whatever. My second.
I've rescinded my first.
Okay, I'll rescind my second.
So it would be staff to negotiate discipline or non-discipline
Correct.
for the matter before us, and upon payment, issue a license.
Yes. And this is my motion. Yeah.
Second.
Have a motion and a second. Any discussion? Mr. Hargraves, are we in order? All those in favor?
We should,
Aye.
we should take roll call, Madam Chair, because it may be discipline as well, right? So
Okay.
just for the record.
And I'm sorry, do we need to address the 250 or is it
That's
already?
going
It's
to be
already
part
in
of the
there.
negotiation.
Okay, roll call. Go ahead.
Mr. Thorwald,
Aye.
Ms. Nair, Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you for your attendance.
I'm sorry, so what is happening?
The
So-
board staff
I'm
will
so sorry about that.
the board
Okay.
staff will be in contact with you after the meeting, probably on Friday or the early part of next week.
Okay, so communication is actually with our SLS, State Licensing Services. They handle all of our state licensing, so it'll probably be with them.
I think staff probably has that noted.
Okay.
Thank you. Let's go to 21D, Stella Young Min Jin.
Hello, my name is Stella Jen.
Welcome, Miss Jen. Miss Mitchell, if you could give us a summary.
Certainly. On September 30th, 2024, Stella Jin applied for the renewal of her pharmacist license. Ms. Jin has held an Arizona license since August 9th of 2010. She currently resides in California. On her renewal application, Ms. Jin disclosed that she'd entered into a stipulated settlement and disciplinary order with the California Board of Pharmacy on or about May 20th, 2024. According to the order, Ms. Jin's license was revoked, but the revocation was stayed and her license was placed on probation for 3 years. The terms of her probation include quarterly reports to the board regarding her compliance with the terms and conditions of her probation, restrictions on her supervision and oversight of licensed facilities, completion of an ethics course, and a prohibition on her ownership or management of licensed premises. The causes for her disciplinary action were set forth in accusation number 7265. The accusation listed 9 causes for discipline. Ms. Jin was listed in 8 of those 9 causes. The causes include expired drugs in the active pharmacy stock, failure to maintain current records, failure to maintain current inventory, failure to comply with requirements for fax-controlled substance prescriptions, holding or offering for sale misbranded drugs, and the unlawful purchase of drugs from another pharmacy.
Thank you, Ms. Mitchell. Ms. Jen, is there anything you'd like to address with the board before we proceed with questions?
No, we can move on to questions.
Thank you. Board members?
Ms. Jin, when does your probation end with California?
I will be on probation for 3 years. It started on June 19th of this year, 2024.
Thank you.
Why are you looking to get a license in Arizona?
I just wanted to have my license, continue to hold my license in Arizona for, potential future relocations. And I also graduated from pharmacy school in Arizona.
Do you intend to practice in Arizona?
Not at this time, but I just wanted to keep my options open for the future.
But your current employer is in California, and you don't intend, at least at this time, to practice here.
Correct. At least for the 3 years probation that I need to complete.
Okay.
I would to be here. Yeah.
Is there a stipulation on your California probationary terms that you must reside in California or work in California?
Yes, correct. I have to work in a total of minimum of 100 hours per month for the 3 years.
I would be comfortable knowing that California is monitoring her performance, if you will, to approve her renewal and ask that Miss Jen notify us, obviously, of change of employment into Arizona. We would be notified if there was any non-compliance with her order. Correct, Dr. Grundy?
We would, Madam Chair. Sorry.
An alternative thought is we could run a probation concurrent with California. So if she does move to Arizona and starts working here, we'd already have her covered and under probation.
We historically have not mirrored discipline unless we feel like Arizona patients are at imminent risk, and I don't see that in this case.
So to me, I have a concern about she moves to Arizona and become PIC and be a preceptor. So it's being PIC and or preceptor. That's, I don't want that happens during her probation with other state.
I thought she just said she has to be in California.
Yeah, but I don't see an issue with put her on probation in our state. We never done it, but I believe that's a safe way to protect our people here in the state.
Just because she has to be in California for this doesn't mean she couldn't turn her license in California if she has one here and move here.
Yeah.
Well, it's always a possibility to not renew the application. That's not, that is disciplinary as well, right?
But if she leaves California, then she's not complying with their order. And then we would find out about that again. Would that be correct?
But I don't see a harm for us to impose discipline in our state or put her on probation. I don't see why not. All this information in a data bank, known for all boards in USA, but.
Well, we just historically stayed away from reciprocal discipline when it doesn't affect our state directly. I think Lori just stated that, but I don't like the precedent of reciprocal discipline when it's already been handled in the state where the action occurred.
That's exactly how I feel.
I feel the same way. My only concern is that if she would decide to come to Arizona and she would turn her license in California, she would be licensed to operate here, and there would be no history, nothing that we could take action on. So how could we cover the state of Arizona in such a situation? Is there a mechanism to do that?
Well, it's in the National Practitioner Database, and we would have access to the history there.
Well, we still, having access and knowing it doesn't mean
Dr. Gandhi, can you
there anything we can do?
clarify?
Yeah, I was actually gonna poke Mr. Hargreaves' brain a little bit here, and I know we do shy away from reciprocal discipline, but is there a way to do a kind of like a memo of concern, letter of concern, stating that if she does move to the state and practice pharmacy, to notify the board prior to doing that?
I like that.
You could do that, but if she doesn't actually notify you, an advisory letter is not discipline. You can put
No.
anything in there, you can't enforce it. So if she comes and she doesn't notify you, there's nothing you can do.
But if she's not working in California, she's going to be non-compliant with her board terms and will be notified of her non-compliance.
But there's lag time and other things that are going to happen for us to be notified. So the conservative approach would be to mimic California to protect the public here. So that those lag times, I don't know, just throwing it out there as.
Yeah, or at least like if she applied for a job in Arizona remotely, for example, doesn't need to be, who knows, right? So we need to inform employer that, because as an employer, sometimes I just look at Arizona Board of Pharmacy website, and if nothing reflects her action in California, I will proceed with hiring this person as a PIC, whatever she applies to. So just I want to make sure at least the future employer in Arizona aware of the issue with other state. We can go with like non-disciplinary action here, just at least show public in Arizona about this issue. That's my thought.
So was the intent not to do the reciprocal discipline like, for CE and civil penalties, but this probation is kind of, it is obviously discipline, but it's a little different in that it's a monitoring / terms for a finite period of time.
I personally think California is addressing it within their state. I don't know that we need to. I understand the concern for being able to have access to it, and I would be comfortable with a letter of concern noting these violations. But we don't have any knowledge that she's done anything wrong in Arizona. I don't think we should hold her accountable for something that she's already been adjudicated for. I feel like it's kind of double jeopardy, in my opinion. So it's my opinion.
I agree with you.
Miss Jen, do you have any charges brought against you, or have you been investigated by any insurances? Just curious.
Insurance companies, as in third-party insurance, PBMs.
It states that you didn't return stock medications to stock. They weren't picked up.
Uh-huh. No, we have not been investigated by insurance companies, no.
Okay.
It was just the Board of Pharmacy and, yeah, Board of Pharmacy.
Thoughts on a motion?
I'm still unclear what.
There's a thought floating over there real quick. Just once they finalize it, we'll share.
Mr. Hargraves, do you have something to offer? Thoughts, group?
So our standard, just do we let the application, we accept the application or the renewal? That's our standard?
Well, I appreciate your concern. So if there's an option where we would be notified that she was working in Arizona or something we could do, I would be in favor of that.
But let's say she inform us she's working in Arizona, what action we will
Then it become
do?
before the board, because Then it would affect Arizona citizens, in my opinion.
But then we're
If
behind the
we're
eight ball.
able.
We're behind the 8 ball because we don't have anything on her yet, and it will be 2 months before she hits a meeting, et cetera. So it seems like there's an opportunity here to monitor her during a concurrent term with her California probation.
And if
Does she have an option to put her license on hold in Arizona while we are now? No, like not renew. Take it, put it in an inactive status.
We don't have an active status.
Okay.
if I understood Mr. Hargrave earlier, that if she doesn't notify us when she would come to Arizona, if she did, there's nothing we could do about it anyway. It wouldn't mean anything.
So what if she didn't renew? If she rescinded her renewal application, and she wanted, after she completed her probation in California, she wanted to move to Arizona, what would her process be to be reinstated?
It depends on how long it is. If
If
it's
it's less-
within 5 years, then she would just submit a renewal application with back fees and penalty.
That's the option.
Yeah, greater than 5 years would be taking the MPJE again.
And then the withdrawal of the renewal application, that wouldn't show as discipline. We would just simply allow that if she so.
That's correct. Withdrawal would be, I guess, an agreement between the board and the applicant.
Miss Jen, what state is your primary licensure?
I first received my Arizona Board of Pharmacy license, and then I moved back to California where my family was, where I'm originally from, and then I got licensed here.
We may be her home state.
So we're your home state license. You didn't get those at the same time?
No.
You reciprocated off of your Arizona license to California.
I'm not sure if it's a reciprocation. I just hold both licenses.
But you got Arizona first and then
First, yeah,
later.
correct.
So she has to keep her Arizona license to keep her California license. Right?
Not necessarily, no. You
Not
can let your-
necessarily?
You can let your home state go.
Unless you want to reciprocate.
Unless you want to
somewhere else.
reciprocate to another state in the future.
So if we were to allow her to withdraw today, what would be the potential implication?
Nothing on her California license.
But she couldn't
She couldn't reciprocate to
in another state
if she
until
wanted.
unless she brought her Arizona license back into good standing.
Correct.
So, so her license expired already?
It expired but was extended to this board meeting.
Okay. Can we file a complaint against based on California? We cannot do that. We do like complaints just based on California, so we can impose like probation or something on her
It didn't
license.
affect Arizona, so I don't know what the basis of the complaint would be.
Would the board like legal advice?
Yes, I think that is wise at this point. I'll make that my motion.
I'll second.
Okay.
All those in favor?
Aye.
Aye.
All right, welcome back, everybody. Discussion.
I think it would be a mistake if we renewed this, given what's transpired in California, and then she would come here and turn in her California license, and then something would happen here. I think it would not look good at all. I don't think it has potential of, I think, backfiring. I don't like having to do a reciprocal disciplinary situation, but I think that's our only alternative.
I'll make a motion to approve the license renewal upon her signing a consent agreement for probation to mirror the terms of California, and an additional provision that she notify us if she moves to Arizona to practice here.
Second.
I have a motion and a second. Dr. Gandhi.
Thank you, Madam Chair. Mr. Thorwald.
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, one absent, Madam Chair.
Thank you, Ms. Jen, for being present. At this point, we'll go to lunch. We'll come back at 1:15.
Will this continue after lunch?
You for a with an order.
Okay. Would I have to be present? I'm sorry, because I didn't.
No. You're done. You're done for the rest of the day. The staff will reach out in writing.
Okay, perfect. Thank you so
Thank
much.
you. All right, are we ready? Are we streaming? We good, Max? Okay. We'll bring the meeting back to order. Dr. Grandi, do you want to do a quick roll call?
Certainly, Madam Chair. Mr. Thorwald,
I'm not here.
Mr. Snare, or Miss Snare, sorry.
Cam, you're not here either.
Speaking of not being here.
I'm
yeah.
here.
All right, Miss Davis,
Present.
Miss Walmsley,
Present.
Miss Lehan,
Present.
Mr. Dang.
I'm here.
Perfect.
I thought Mr. Thorwald was the one that needed the nap, but
Yeah.
that's okay.
Mr. Al-Nasif.
just
Here. Mr. Anderson.
Here.
All present, one absent, Madam Chair.
Fabulous. Let's go to item 21E, Hollandale Pharmacy. Welcome, everybody. If you could please introduce yourselves.
Good afternoon, Courtney Sullivan and Mark Boson with Boson and Snow on behalf of Hollandale Pharmacy. Our clients are online as well.
If you could please unmute yourself and introduce yourself for the record.
Hey, I'm Leilani, Director of Quality for Hollandale Pharmacy.
Good afternoon. I'm Rachel Ponticus. I'm here with my colleague Susan Dewey, and we're National Counsel for Hallandale.
Thank you. Mr. Castaneda, would you like to give us a summary, please?
Sure. Thanks, board members. I'm Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. So this is a permit renewal application for a non-resident pharmacy. On its renewal, Hollandale disclosed discipline from other jurisdictions since its previous renewal. The summaries of the discipline are listed there in the board packet. They had some discipline from Illinois from previous states that had this issued discipline years back. Their permit in Illinois is currently active and unencumbered. And they disclosed discipline from Mississippi from March 2024 for administrative failure for not having the the requisite compounding certificate prior to shipping into Mississippi. The Texas discipline from March 2024 was a settlement agreement based upon the Mississippi matter, and they disclosed discipline from Louisiana from August 24 for compounding using bulk substances that had not been nominated for inclusion on the FDA bulk substance list and not yet categorized. This was based off of findings from an FDA inspection in 2021 and a closeout letter in 2022 that did not mention any additional, without any additional mention of, not yet categorized bulk substances. The Louisiana Board of Pharmacy fined the permit holder $57,000 for violating the Louisiana practice of pharmacy and deviating from federal guidance.
Thank you, Mr. Castaneda. Ms. Snow, Mr. Boson, would somebody like to make any preliminary statements for Hollandale?
Thank you. We do have Miss Bellini here who can provide the board with information on the specific issues here. We are asking that the board reinstate or renew the Arizona license. The conduct before you occurred in other states and has been remedied. We would also dispute some of the facts that were provided in the summary to the board. After Ms. Bellini answers any of your questions, we will ask that the license be renewed. Thank you.
Board members, does anybody have any questions for Ms. Bellini?
I have one. The bulk drug substances that you were compounding with that didn't meet the criteria, have you ceased compounding with those API?
Yes, we have.
And just so to provide the board with a little bit more clarity on that bulk substances, they believed they had an FDA inspection, and pursuant to that inspection, believed that they were permitted to compound those substances.
Pursuant to the FDA guidance regarding nominated substances, the dispute of the facts is whether or not they were nominated at the time. They stopped compounding with them when they became Category 2 bulk substances.
They did continue to ship product, but that was to deplete their stock of the product. They did not continue compounding.
So if it's nominated, you cannot go ahead and use it, correct? It's only in that process. It's not.
It has been
legal.
the posture of this board that it follows FDA guidance. When the bulks list was created, there were two guidance documents from the FDA. The first one published described waiting until the products were on the approved list. Later in 2018, and Reed Smith has actually litigated this much more than I have, and Rachel Ponticus may be able to fill in any gaps I've got here. But in 2018, the FDA issued new guidance based upon a concern that patients weren't accessing medications that were beneficial to them, in the process to get the products approved on the approved bulks list was taking too long. And so the FDA took an enforcement position, and still has one, that so long as it's nominated and hasn't been recategorized as a category 2, that they would use their enforcement discretion to allow compounding with those products.
And let me just add, thank you, Mark. If everyone doesn't mind if I jump in, let me just add that this case is very specific in that during the FDA inspection of Hallandale, FDA specifically did look at all of the substances and specifically looked at these substances that were nominated but not categorized. There was one that they not included in anything that had to do with Louisiana that they told Hallandale to cease, and Hallandale ceased it. But the remainder of the substances FDA looked at and exercised its enforcement discretion over. And, you know, these are FDCA issues. FDA does have control and is able to exercise its enforcement discretion. Importantly, in the Louisiana matter, there was really no corresponding Louisiana regulation. And this settlement was a business decision, a compromise on behalf of the Louisiana board and Hallandale to, if you see what's cited there, is just a general violation of Louisiana law because they didn't have a specific regulation that this could have been violating. So the specific regulation that it could have violated, the FDCA, the people who monitor the FDCA, FDA, came in and inspected and saw that this wasn't an issue, and that's what Hallandale had relied on.
Mr. Castaneda, all of the prior disciplines were appropriately disclosed, right?
In regards to this permit renewal or the previous renewals?
This permit renewal.
Yes, they disclosed these discipline.
Is Hallandale licensed in all 50 states?
Leilani,
Sorry. No, we are not. We've I'd have to grab the list. I didn't pull that up right here, but 40-ish. There is a few we're not licensed in currently.
And what's the status of your Florida permit?
Yeah, good, in good standing. Our resident state. We're licensed here.
And when was your last inspection by the Florida Board Compliance Officer?
So it's annually, and it happened mid-May. I don't want to give you an exact date. I hosted it, but yeah, it happened May time.
Were there any findings from that inspection?
Off the top of my head, I think there was 2. I think we had an OOS that hadn't been closed out in the verification of effectiveness, and so we had extended it with a deviation, which she accepted as a kappa. It just wasn't produced during the visit. And then another one was an SOP revision date. But to be specific on the revision, I would have to definitely get you those observations to give you the specific SOP. Sorry, I didn't pull any of that up for today.
Did any of those findings result in violations issued?
No, it was closed, and we received our renewal of licensure. We were just asked to do some remediation answers, so like a kappa improvement plan. And those 2 were provided in the same week. One of them was done when she was on site, but it still had to be written down to show the QRE was developed while she was there.
Thank you.
Do you have a current license to ship compounded products into Mississippi?
No, we do not. We let it expire as we agreed when we visited, and I appeared in front of the Mississippi board, and we talked about the issue at hand that you've been given. I wasn't sure if you read it out in the beginning. There's a lot of legal speak, and I'm terrible with it. I'm a microbiologist, but no, we agreed to let the license expire, and then we agreed to have a revisit where I'd go over there and we'd talk about some things that they wanted us to have a look at, and then we'll renew at the time when they feel happy.
Rachel, did you want to clarify anything on that?
I don't have to unless there are further, if the board has further questions, I'm happy to clarify.
Yeah, sorry if I misspoke. The licensing, again, I'm quality, so I make sure we're licensed and don't chip if we aren't. But bar that, if there's something I didn't explain, I'm sorry. I could keep going.
I'm personally comfortable with approving the license.
Yeah, I think the concerns that I had have been addressed, so I'll make a motion to approve.
I'll second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you. Thank you for your attendance today. Got a little trigger happy on the mic there. Next up is 21F Empower Pharmacy.
So you've got mostly the same players except for our client.
I'm recused from this.
Okay.
Mark Bozen and Courtney Sullivan for Bozen and Snow, Rachel Ponticus, Reed Smith, and
Jordan Cooch.
Hi, Jordan Kushat, pharmacist in charge.
Thank you. Mr. Castaneda, go ahead.
All right, board, before you today is a permit renewal application for Empower Pharmacy. On this 2024 renewal application, Empower Pharmacy disclosed discipline from the California board issued in 2022. The California board placed the permit on probation for 4 years based on 58 separate causes for discipline, which involved their sterile compounding practices. Included in the California accusations against the permit holder are concerns from a prior remote renewal inspection from 2019 and an FDA inspection from 2020. The other disclosed discipline on the renewal application were reciprocal disciplines from other states. The permit holder also provided a satisfactory home state inspection conducted in 2024. The FDA dashboard for this permit holder and the most recent FDA inspection from August of 24 are included for your consideration.
Thank you. Anything preliminarily Empower would like to add?
Ms. Ponticus, National Counsel, would like to be present as a fact witness to assist Empower. She assisted Empower in the California matter. She can walk you through what was brought before the California Board of Pharmacy for Empower. The conduct before you has been remedied, and we would respectfully request that the board renew the Arizona license.
Board members' questions or discussion?
Did you say she was going to go through what was brought before the California board?
She can if we want.
I'd like to hear it.
Sure. Hey, good afternoon, everyone, again. I just wanted to focus first on what was driving this California probation. As I'm sure you all are aware, there was an industry issue, is really an industry issue, which has been driving a lot of California probations. And it was about a rule that California did not have that they were enforcing that had to do with the ingredients in compounded products. And they were taking the position that ingredients could only be used if they had a USP or an NF monograph, not if any of the ingredients were on, let's say, category 1, which is a permitted category of FDA. They didn't want any of those ingredients used. And how they were enforcing this is they were calling those ingredients either adulterated or impure under their regulations, not because they had any adulteration or impurity in the actual ingredient, but just because they didn't like those categories of ingredients. There were about 7 pharmacies that were hit under this industry issue. Either their licenses were revoked or they went on probation. I represented 5 of the 7 of these pharmacies. Currently, California is trying to get that regulation passed. They've had a lot of trouble. They have not been able to get it past their board, the regulation that they had already enforced, right? Because it was a non-existent regulation. So that's kind of mired in controversy in California. And so that's a big chunk of what's happening here. And while California was in, they also came in and they looked at some other categories of activity, which I want to go over, which are also some of these common across clients. One of them they looked at was BUD, and the issue there was they were nitpicking the studies that Empower had. Empower does have studies to support all of its BUDs and is working with California to get the studies in the shape that California would like. There was a labeling issue because the name of the drug was too long to put onto the label, wasn't quite done right. And so they remedied that immediately. There was a record keeping issue. This was also common across several pharmacies where basically the records had the supplier's name instead of the manufacturer's name, which is what California took the position they were requiring, although they're allowed to allow the supplier. Now Empower has the manufacturer's name. There's also a sterility test issue. California takes the position that USP and USP alone is the only thing that's permitted. And what Empower has been doing and is doing is that rapid scan. So of course they switched to only USP because that's the position that the board took, is the only thing allowed. Although that board has admitted that rapid scan is scientifically superior. Another issue that came up where there were some things that the board found were essential copies, and Empower ceased to produce those products. And we do have Jordan here so that she can drill down on any questions that you may have. I just thought I should bucket it and explain that industry issue so that this board could get its arms around it.
Thank you. Board members, what additional questions does anybody have?
I don't have any further concerns. I'll make a motion to approve.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none, thank you for appearing.
Thank you for your time.
Thank you. I received a request to table item 21G till tomorrow, so we'll go ahead and do that. Moving over to item 23A. Action on previous action, complaint number 23-0693, Jacob Wade Doan. Is Mr. Doan present?
Yes, I'm here. Hello.
Thank you. If you could please introduce yourself.
I'm Jacob Doan, pharmacy technician.
Thank you, Mr. Doan. Ms. Brown, go ahead.
Jenica Brown, Executive Assistant to the Deputy Director. Jacob Doan was issued a pharmacy technician license on June 28, 2023. It expired on October 31st, 2024. I understand that he applied for renewal of his license this morning. His license is currently suspended. In December 2023, board staff opened a complaint against Mr. Doan's license after receiving notification from Amazon Pharmacy that he was terminated from employment for working under the influence of alcohol. He was screened for substances, leading to an immediate suspension and subsequent termination of employment following a positive test for alcohol. Mr. Doan responded to the complaint and acknowledged going to work hungover, not realizing the effects of the alcohol had not worn off. He also acknowledged that he was still somewhat intoxicated when he clocked in and began his shift. He denied consuming alcohol during his shift or inside the pharmacy, and he also denied having a dependence or addiction to alcohol. At its February 2024 meeting, the board considered this matter and offered Mr. Doan an interim consent agreement for substance use evaluation and interim suspension of license. He agreed to the consent agreement and it was executed on February 21st, 2024. In March 2024, Mr. Doan requested to appear before the board in April to discuss alternatives for the evaluation due to financial difficulties. The board requested staff to work with Mr. Doan to identify an alternate provider. Staff approved a provider and Mr. Doan underwent the evaluation on May 23rd, 2024. This matter was presented to the board during the August 2024 board meeting to review the results of the evaluation and to determine how to proceed. Mr. Doan was not in attendance, and the board voted to offer him a consent agreement to include a 6-month suspension, followed by a reevaluation, and then, if recommended, converting his license to probation for a period of 5 years. Board staff received notification from Mr. Doan after the case was considered, stating that he misunderstood the date he was noticed to appear and he wished to continue his case, as he was starting an outpatient treatment program the following week. The board reopened the matter and voted to table it until such time Mr. Doan completed treatment. This matter is being returned to the board to consider the evaluation results and recommendations outlined in the initial evaluation that was completed in May 2024. Also contained within the board's files are reports from Banner Health regarding the intensive outpatient program that Mr. Doan completed in October 2024. There is a clarifying note in the report in your board book that restates the motion that the board initially agreed upon in August for discussion and consideration. I would also like to add that last week we were informed that Mr. Doan did schedule a second evaluation.
Thank you, Ms. Brown. Mr. Doan, is there anything you'd like to add before we ask you some questions?
I don't think so, no.
Thank you. Board members, questions, discussion?
So the discharge summary from the intensive outpatient program did not provide the evaluation that we needed. So I understand, Mr. Doan, that you have scheduled that evaluation and we're still pending the recommendation from that evaluator. Is that correct?
Yes.
And when is that scheduled?
Next Saturday, I believe. Or this Saturday.
I'm glad that you're continuing to follow through and that you're continuing to seek treatment. My thought is, since he hasn't even gone through the 6 months probation, I don't see any reason why we wouldn't just go ahead and table this to the next meeting and review it at the next meeting when we have the evaluation that we need.
It's reasonable.
Jennifer, do you have a concern?
Just a comment. So I guess the first evaluation that he had that we have a record of was in response to his interim consent agreement. And so if the board tables, I suppose they could, act at a later meeting, but does the board want to consider offering him a consent agreement for what the initial evaluator recommended? So I'll stop there.
I'm totally forgetting. So this evaluation was not due to our order.
The one that he just scheduled is not due to our order.
But it is due to the one that we did order and the recommendation from that evaluator.
Correct.
That we needed that second evaluation because he was not safe to practice as a pharmacy technician for a period of time, and then he needed to be cleared by a second evaluator. So we're waiting for that second evaluation.
Excuse me. I have a comment.
Go ahead, Mr. Doan.
The initial evaluator recommended the outpatient treatment program and then a follow-up reevaluation once it was completed. That's why I scheduled the reevaluation.
Yep, we're tracking.
Yep.
I would like to see the next evaluation to ensure that he's safe to practice. I suppose depending on the evaluation, if he also makes a request to lift the suspension, we could potentially look at moving him to probation with a new depending on the results of the evaluation, but it might be too soon to tell. But I feel like we need to see the next evaluation before we can do anything.
Is that next evaluator one that traditionally works with this board that we're used to working with, or is that an exception?
It is my understanding it will be the same evaluator as the first.
So if there is a need for continued monitoring post-evaluation, has Mr. Dunn been connected with the resources available for that continued monitoring?
I think we would probably put him on a substance use contract of
Right.
some sort, which would then he would have to continue the treatment with whomever. That's my assumption that the evaluation will say, but without seeing it, I don't know.
Right.
So just to go back to my previous comment, normally when staff brings a case back before the board and where an individual's been suspended on an interim basis and had terms to fulfill, that is typically followed up with a consent agreement with those terms outlined. And we don't have that yet. Mr. Dunn is taking the initiative to do the things that the initial evaluator recommended, but there's nothing from the board that is requiring him to do so at this point.
Okay, that's a fair point. Except for the fact that he's suspended and so if I'm hearing you correctly, potentially we should, what you're suggesting is that we offer a consent agreement for the terms that were set forth in the original evaluation, of which he's completed most of them. The rest of it potentially would be completed when he completes the evaluation. Then we would amend the consent agreement pursuant to the additional findings that we get.
That would be consistent with how other cases have been handled.
If I may, the board initially was going to go in this direction last meeting, but Mr. Doan requested that we table the matter until this meeting. The original motion is included in your board book.
Thank you, Ms. Brown.
And if we do make a new consent order, maybe talk about if not signed or not done within a certain amount of time that we go to a hearing, or is that just standard?
So I'll make a motion to mirror our motion from the last meeting to offer him a consent agreement to include a 6-month suspension followed by a reevaluation. And then, if recommended, converting the license to probation for a period of 5 years.
Second.
And then our standard terms, if not signed, move to hearing.
Second.
I have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lahan,
Aye.
Mr. Dang,
Aye.
Mr. Al-Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, one absent, Madam Chair.
Thank you, Dr. Gandhi. Thank you, Mr. Doan, for being present, and glad to see that you are continuing on with your treatment.
Thank you, guys.
Thank you.
Have a good day.
23B is Dawn Christine Zadarko.
I'm recused from this one too.
Is Ms. Zadarko present?
I'm here.
Hi, if you could please introduce yourself for the record.
Hi, I'm Dawn Zadarko, pharmacist.
Thank you, Ms. Brown.
Dawn Zadarko was issued an Arizona pharmacist license on April 12th, 2020. It expires on October 31st, 2025. Her license is currently suspended. On June 24th, 2024, the board was notified that Ms. Zadarko may be unable to practice as a licensed pharmacist safely. The documentation provided in support of this discusses protected health information and is contained within the board's files for the board's review and consideration. On July 12th, 2024, the board offered Ms. Zadarko an interim consent agreement and order for voluntary suspension of license and fitness for duty with substance use component. Ms. Zadarko signed the agreement and it was approved by the board during the August 2024 board meeting. The agreement was executed on August 23rd, 2024. Ms. Zadarko completed the board-ordered evaluation on August 8th, 2024. The report is included in the board's files. This matter is returning to the board to consider the results of Ms. Zadarko's evaluation and to determine next steps in this case.
Thank you, Ms. Brown. Ms. Zadarko, is there anything you'd like to add before we proceed with questions?
Just that I do apologize for not notifying the board myself within the 10 days after my hospitalization.
Thank you. Board members, questions?
There are none. I'd be willing to make a motion.
Go ahead.
Offer consent agreement for probation with standard terms to run concurrent with our monitoring contract and comply with such monitoring contract. If signed within 30 days, lift the suspension and reinstate license in probationary status.
Do I have a second?
I'm sorry, what was the monitoring contract? Was it a standard monitoring? Substance use type of contract, or were there specifications there?
Do we have to speak to this in executive session?
Are you trying to go with what the evaluator recommended?
Correct.
Okay, that's fine. I just wanted to clarify.
And usually it's 5 years probation. That's a standard, right?
I think in
5
the
years.
recommendation, I thought it said 3.
3 years.
We usually mirror what the
What they're
evaluator says.
okay.
Yeah, I said to run concurrent with the contract that was recommended.
Okay. Okay, I'll second. Thank you.
So I have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis, recuse, Ms. Walmsley,
Aye.
Ms. Lehan,
Hi.
Mr. Dang, Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, 1 absent, 1 recusal, Madam Chair.
Thank you, Dr. Gandhi. Thank you, Ms. Adarko, for being present.
Thank you very much.
Thank you. 23C, complaint number 24-0296, Sophia Moreno. Is Ms. Moreno present?
Yes, I am.
Welcome, Ms. Moreno. If you could please introduce yourself for the record.
Yes, good afternoon, board. I am Sofia Moreno.
Are you able to turn on your camera?
Let me see. Hold on. Can you see me now?
Yes, we can. Thank you so much.
Okay, thank you.
Ms. Brown, go ahead.
Sophia Moreno was issued an Arizona pharmacy technician license on August 17th, 2004. It expires on October 31st, 2025. Her license is currently suspended. On May 28th, 2024, board staff received notification that Ms. Moreno diverted a bottle of butalbital, acetaminophen, caffeine from Veterans Affairs Consolidated Male Outpatient Pharmacy on or about May 17th, 2024. And she was subsequently separated from employment on or about May 20th, 2024. Board staff opened a complaint against Ms. Moreno's license and issued a subpoena for records. A response to the subpoena was received and included a narrative to correspond with video footage that supported the allegations that Ms. Moreno diverted medication from the pharmacy. The videos are contained within the board's files for consideration. On June 5th, 2024, board staff sent Ms. Moreno a notice of complaint and requested a response. Ms. Moreno responded stating that she wished to enter into an interim consent agreement for suspension of license, drug testing, and substance use evaluation. She did not answer questions that were posed to her by board staff in the notice of complaint. The board approved Ms. Moreno's interim consent agreement during the June 2024 board meeting. The agreement was executed on June 25th, 2024. The interim consent agreement required Ms. Moreno to complete drug screening and a substance use evaluation with a board-approved provider. Board staff received the drug test results for Ms. Moreno on July 1st, 2024. Of note, the results were submitted by Ms. Moreno rather than through the drug screening lab. Communication is included in the board's files that outline multiple challenges in obtaining the results from the lab. The drug test results were negative for all substances tested. Ms. Moreno also completed the required evaluation. A copy of the report is included in the board's files for consideration. Board staff provided a copy of the report to Ms. Moreno on October 21st, 2024, and offered her the option to voluntarily surrender her license. As the report suggested, she intended to leave the field of pharmacy. Ms. Moreno responded to board staff stating that she did not wish to surrender and would await the board's decision in this matter. This case is before the board for discussion, consideration, and to determine how to proceed.
Thank you, Ms. Brown. Ms. Moreno, is there anything you would like to add before we proceed with questions?
No, ma'am, thank you.
Thank you. Board members, questions, discussion?
I have a question. If you don't intend to work in pharmacy, why not surrender your license?
I am not working currently as a pharmacy technician. I wanted to explore other options, but I would like to have the license in case if I do want to return to the pharmacy field.
So, Ms. Moreno, can you tell us a little bit about what happened? So you diverted medications, non-controlled medications specifically. Subsequently, you tested negative, so it appears that you did not ingest those medications. Are you disputing the fact that you took the medications?
No, ma'am.
What did you intend to do with them?
I was
Or what
thinking
did
that
you
if
do with them?
I actually threw them in the garbage disposal the moment I came home because I felt really guilty and I could not believe what I just done. And I was just disappointed and disgusted with myself, and I couldn't comprehend why I had done what I did. So I didn't take the medication.
So Ms. Moreno, you've been a pharmacy technician for 20 years in this state. Is this the first time this has happened?
Yes, sir. Since 1995.
What led you to take the medication?
I suffer from chronic migraines and cluster headaches, and the
You don't have
Imitrex.
to disclose your medical conditions, just FYI, but thank you.
Okay, sorry.
You can just speak generally.
Okay, was experiencing a lot of headaches and the medication was not working for me, and I was desperate, and I thought I try this in 2016, maybe it'll help again. And that was the motivation behind stealing it.
So the results of the evaluation didn't indicate substance use issues. What have we done in the past with diversion of non-controlled substances?
We've typically done some sort of a suspension and a civil penalty. Or probation.
Or
Probation,
revocation.
I'm sorry. Usually done probation and a civil penalty. Because it's non-controlled.
I would make a motion to offer a consent agreement for 3 years worth of probation and a civil penalty of $250.
Second.
Any discussion?
So are there certain elements with it, what is required for the probationary period? Dr. Davis, what are you thinking?
Follow all pharmacy laws.
Agree.
Should we add some sort of a ethics CE requirement or something of that nature? I don't know, just a thought.
I wouldn't be opposed to adding some CE requirements to my motion as well. 3 hours of CE in pharmacy law.
I would say more ethics than law here.
I feel like
So-
more ethics than law, and I don't know if I think 3 years is too long. I feel like 3 years is a long time.
I'm okay with 2 years.
Also, I would want a stipulation that you would notify your employer. Good one.
All right, let me try again.
Current and future.
I amend my motion to offer a consent agreement for probation for a period of 2 years with 3 hours of continuing education and ethics, a $250 civil penalty, and a requirement to inform her future pharmacy employers of the existence of her probation.
Modify my second.
I have a motion and a second. Is the motion in order, council?
I would just like to say something. Maybe she can find hard to find like ethics CE. She can work with the board to authorize whatever course she will take. We allow the board approve whatever she finds.
That's fair.
Okay.
Miss Galvin, are we in good order?
Yes.
Dr. Gandhi?
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair, one absent.
Thank you, Dr. Gundy. Thank you, Miss Moreno, for being an appearance today.
Thank you.
Let's move next to conferences unless anybody needs a bio break. Are we good? Okay. We'll go to 24B and I'm recused.
Thank you, Ms. Walmsley. This is complaint number 24-0285, respondents Walgreens 15363, Jessica Story, pharmacist, and Heather Olson, pharmacy technician. This is a pharmacy technician administered the incorrect vaccine. It looks like we have parties here. Ms. Trujillo, would you like to introduce your clients and yourself?
Yes, good afternoon. Susan Trujillo from Corals and Brady, counselor for Walgreens. You'll introduce yourselves, please.
My name's Heather Olson, the pharmacy tech at Walgreens.
I'm Jessica Story, pharmacist at Walgreens.
Kanika Brantley, healthcare supervisor for Walgreens.
And we should also have, yes, I see him, Michael Cinco online from Walgreens as well.
Thank you, Mr. Trujillo. Mr. Castaneda, would you like to introduce yourself and provide a summary?
Sure. Thanks, board members again. Ben Castaneda, Compliance Officer, Arizona State Board of Pharmacy. Complaint 240285 was opened up by board staff due to a report of claim pursuant to ARS Section 2017-42, alleging that a patient had received the wrong vaccination. On or about September 21st, 24, a patient made an appointment at Walgreens to receive a flu and an RSV vaccine. The pharmacist on duty was Jessica Story, and the administering technician was Heather Olson. After the patient received the vaccines later in the day, Heather Olson was entering the vaccine information into their operating system. She noticed that the lot number she documented on the VAR for the flu vaccine corresponded to a Moderna vaccine. She determined that she had administered the COVID vaccine by mistake, and she notified Jessica Story of the error. Jessica contacted the patient and PCP and confirmed the patient did not experience any adverse effects from the incorrect vaccine. In addition, she filed an incident report of the event. She stated that she reviewed the vaccination form and reconstituted the RSV vaccine, but she did not recall Heather Olson showing her the vaccines prior to administration. Heather indicated that she had administered the incorrect vaccine. Sorry, I repeated that. In addition, she said the pharmacy was very busy that day and the system had double booked the vaccination appointments. The pharmacy records reflect that 128 vaccines were scheduled that day with 1 pharmacist and 3 technicians on duty.
Thank you, Mr. Castaneda. Mr. Trujillo, would you like to make a preliminary statement?
Sure. Actually, I'm going to have Heather and Jessica provide statements.
Great,
Go ahead,
thank you.
Heather.
So as I've said, I'm Heather Olson. I'm pharmacy tech with Walgreens. I've been with Walgreens since 1996, and I've been a certified tech since 1999. I'm the operations manager for the pharmacy that I work at, which helps manage technician schedules and other administrative tasks in the pharmacy. The day of the incident was an unusual day. We usually have 4 to 5 full-time technicians, most who are vaccine certified throughout the day. Unfortunately, we had 2 techs out that day. This meant that I was unexpectedly short 2 immunizing techs, though the vaccine scheduler system had already scheduled appointments as though we were fully staffed. When we walked into the pharmacy that morning, there was a lot of work left over from the day before. My store manager, who is a certified tech, came and helped in the pharmacy, fill prescriptions, and Jessica reached out to our district manager for more support. Our district manager sent Kevin Tran, who's another pharmacist from another store, and a store manager who's also certified tech to come help with reviewing, verifying, and filling scripts while we continued doing the vaccines. Jessica and I were getting vaccines together and helping each other with vaccine appointments, kind of tandem. Once a patient was checked in, I would pull the vaccines and place them in the yellow totes that we use for vaccine administration for Jessica to check. And if it was a shingles or RSV, Jessica would mix it for any of the technicians. The patient in this case checked in with us a little bit before his appointment. I pulled the vaccines for the next 3 appointments and set them up for Jessica. I knew she had to mix the RSV for the patient. At the time, I did not realize I pulled Spikevax instead of the Fluzone high dose for the patient. I went over and asked Jessica if the last appointment was done so I could start with this patient. She said yes. And I saw that RSV was mixed, so I assumed the bin had been checked. I went to the vaccine room, noticed the lot wasn't written down on the VAR for the flu shot, wrote it down real fast, then washed my hands and called in the patient to the room. He was upset by the delay and how long it was taking. I apologized and told him I appreciated his patience. I confirmed his date of birth. I read off the VAR what vaccines I was giving him. He confirmed RSV and high dose flu. I followed normal procedures for vaccine administration and gave him what I thought was the flu vaccine. I discarded the used syringe in the sharps and administered the RSV on the right side and put the RSV in the sharp. I told him, your right side is RSV and the left is Spikevax. And he said, I thought it was supposed to be flu. I looked at the VAR and said, yes, Fluzone. Probably because I'd given so many vaccines. Since I could not go into the sharps container to verify the syringe, I apologized again for the wait. We closed for lunch right then, and he left. The rest of the day was just as busy. Around 6:30, I was scanning in the VARs and documenting the lots. I got to this and saw that the lot that I knew was Spikevax because I'd been entering so many. I got Jessica and I told her what I expected had happened. We looked at the lots for both Spikevax and Fluzone high dose. She asked how I knew I gave the wrong vaccine, and I told her I was the one who wrote the lot. I was very upset, started crying. Jessica then called the patient to talk to him. She started an incident report and contacted the doctor. This incident has definitely shaken my confidence. I'm now super hyper vigilant when it comes to giving any vaccines. For a while, I was scared to give vaccines, so I started doing more continuing education courses in vaccine patient safety and will continue to do so because vaccine administration helps me feel like I'm helping my community. Thank you.
Okay, so I'm Jessica Story. So I've been a pharmacist for 5 years and I've worked with Walgreens for 12 years. So regarding the incident, Heather checked the patient in for his appointment and confirmed that he was to receive the RSV vaccine and then the flu shot. I checked over the vaccines entered into the system for him to make sure that he was eligible based on his vaccine administration record. And I looked at his patient profile. Heather brought me the RSV vaccine and asked me to reconstitute it. After I reconstituted it, I placed it into the tote for her to administer. Heather grabbed his other vaccine and placed it into the tote without me realizing it. Heather had asked me if the vaccine was ready, and I said yes, thinking she was talking about the RSV vaccine. She thought that I had looked at the other vaccine, which I did not, and she had put it into the tote as well. A couple of hours later, Heather realized that she had given him the wrong vaccine, which was when she was inputting the vaccine expiration and lot numbers into the computer. After she brought this to my attention, I confirmed with her that she was positive that she gave him the wrong vaccine, in which she said yes. I then called the patient to inform him of what had happened. I apologized sincerely and told him that this should not have happened. And he told me that there was no adverse effects and he was feeling fine at the moment and he was not upset. I told him I would be informing his doctor of the situation because it was the wrong vaccine, and he said that was fine. I felt really bad about this situation because it should have not occurred, and I felt really bad, and I comforted Heather because she was deeply upset as well. So since the situation occurred, I'm extra cautious about making sure that the vaccinating technicians do not rush to give the vaccines and make it a clear point by verbalizing that they cannot give the vaccines prior to me seeing them, making sure that they're correct. Since then, our company has also implemented a new vaccine schedule program. Under this program, only the pharmacist can approve the vaccine expiration and lot numbers, and it must be checked prior to the patient getting the vaccine, which greatly prevents an error like this occurring again. I also took 3 hours of continuing education in medication error prevention to learn more about how to prevent errors like this. To this day, the situation has affected me, and I'm extra cautious when technicians or I am administering vaccines, as I do not want it to happen again.
Thank you, Ms. Story. Thank you, Ms. Olson.
Yeah, we're happy to answer any questions you may have.
Thank you. Board members, the floor is open for questions.
I have a question.
Of course.
Okay, so for Heather, So actually for either of you, honestly, when you're pulling the vaccines, what kind of like quality assurance is done from when you pull them versus like selecting them? Do you have any additional, what are your steps? How's that? What are your steps?
Well, now, because we have the new system, I have the pharmacist pull the vaccine first. And then we match everything to a tablet, which actually pulls up exactly what the patient's getting and the lot number, so we can actually match everything to the screen before we administer it. So more than one person's eyes are always on it because the pharmacist sees it first and puts it in, and we see it visually second before we administer.
So does that then give you an extra layer of safety because it's already input there of what should be correct, and now you're just matching what's in your box versus what's in the system?
Correct, instead of just using it against a bar.
So is that what happened before there? What happened before that is different?
That's what it was. We used to do it on the paper. Like we'd write down the lot numbers.
You had nothing to match it against then. If you pulled the
No.
wrong one, you just wrote
No,
down the lot
no.
number. So there was no scanning
Not
to
really.
ensure that you'd matched what was on like the prescription label.
I
or-
thought she'd already checked the vaccines. Like it was totally a disconnect there when we were trying to get the vaccines done.
And it's all entirely manual.
At
pretty
that
much.
time, yes.
Okay.
I just trying to make sure I understood what's happened. So patient checked in, right?
Mhm.
And scheduled for 2 vaccine, flu and RSV. Pharmacist entered correct data, right? And everything was correct. And then you put it on the side for technicians to administer it, right?
Correct.
And then you brought another
No, the vaccine was inside the tote. She had just mixed the RSV, not realizing that I'd already pulled the other shot. And I went and gave the shot without her checking that second one.
Oh, so you pulled it without her
Correct.
checking. Okay.
I thought she had checked both when I said, is this person ready?
Okay. So when you check
I checked
before,
the RSV vaccine
yeah.
that I had reconstituted.
Okay. So your previous protocol, when you check, do you sign or initial that you checked? I mean, how the technician would know that you already
We
verified?
have it like a tote system where after we check it, we place it into the tote.
Okay.
And then we have like the leaflet, we call it, is which the patient information, which matches the vaccine
The
actually
vaccine.
in the tote.
Okay.
Yeah, supposed to.
So you put it the one she pulled and gave it to a patient. It wasn't checked, but it was on the wrong tote or wrong.
It was in the right tote. It was just under the bar. So like.
But you just pull it out and then
I just grabbed it because I thought she was done with everything
got it.
because she had put the RSV on top
I
of the
got it.
bar. And I was like, out
Yeah.
the door.
I have a question. So there's no barcode scanning that goes into vaccine
No,
administration at
Not
Walgreens?
for vaccines, not at Walgreens.
I have a question about counseling. It looks like it wasn't documented that counseling was done in this case.
Sure, I'll take that one. So counseling is performed, via all the paperwork that's provided to the patient. So through the VAR process, and when the patient fills out the form, there's information on that sheet. They also get a VIS, a vaccine information sheet that has all of that information. And so the vaccine counseling, all that is provided through all the paperwork and the exchange with the patient related to the vaccine.
So no verbal counseling takes place. It's all written.
Right, it's all written.
I'd like to explore a little bit on workload. So Mr. Castaneda's narrative states that 65 vaccines were scheduled to be administered before lunch. You had acknowledged that there were, I'm not sure, were there call outs that day or were there just not a sufficient
I
number of
had one
technicians?
tech that was actually out on disability from the week before and another one who surprised us with his disability literally 2 days before this day happened.
So
So I had 2 full-time immunizing techs out within this week period.
So can you share with us how the scheduling system and the capacity management works? So if you generally have 3 immunizing technicians and you're down to just 1, how is that configured within your system? Because the workload with the double booked, triple booked appointments really impacted this.
Right.
So explain to us what happened, you
I
know, in this
honestly
event.
don't know how the system would work with that, with the call outs.
So So
It's-
does it know who is scheduled? What
No.
credentialed clinicians are on duty?
No.
It does
Not at
not
that time.
know dynamically like who's on duty. But before like respiratory season starts, it's based off of how many immunizing technicians they have. And so then those stores are placed into like, say, clinic mode, for example, and the store was in clinic mode. And what that essentially means is that 40 hours are given to that store to have a dedicated immunizer. And so that's what they were set up on. But to your point, thought it was a dance break, I'm sorry. But to your point, in the moment, the system would not know that. And so typically what happens is that we would advise for our store managers to maybe call those patients and then reschedule if it's that kind of situation or circumstance. In this case, though, we brought in extra technicians and pharmacists to kind of help support the workload. And that's what happened that particular day.
Yeah. So these store managers, these CPHT store managers that came back, are they immunizer certified? No?
No, the ones that came into my store that day were not.
So it-
No,
They
they
are.
are.
They are. They are
Not Mike
certified.
Schmitz.
Mike
and,
Schmidt is? Oh,
Mike
okay.
Schmitz and
I know
Kevin
my store
Channel.
manager's not, so
Oh,
that's
did I?
why.
Yeah. No, the two
Who's
that
there?
were brought in like to an additional or
So you had one immunizer technician plus the pharmacist on duty. And, you know, if the narrative is correct, and I'm not hearing that it's disputed,
Mhm.
that's like 4 to 5 hours, you know, before lunch, that's a vaccine every 4 to 5 minutes nonstop.
right.
Mhm.
That seems very, very high. And the fact that there's no sort of capacity management. I mean, I'd just be honest with you, my barber does better. You know, if my barber's out sick, I get a call that my appointment's not available. So, you know, your first reference to having the store manager contact patients to reschedule appointments, to me would have been a safer approach than to subject this pharmacist and pharmacy technician to this excessive workload that ultimately resulted in or contributed to this error. That's all my comments.
Do they have a ratio to appointments that they try to stand by? Is there a general rule? Just curious.
So a couple of things to add. In that previous scheduler, the way that it worked and it appeared double booked because it also mirrored our testing scheduler. So it was immunizations, it was testing. What they've done to improve this year are two things. One, it's more dynamic. So if you were to call and schedule or book an appointment, it will block out subsequent appointments so that it's not double booked or there's not all of these appointments that are added, whether it's testing, whether it's immunizations of that nature. So that's part of the changes that have happened, but we did not have that before. So you had the testing, you had the immunizations. So there were a lot of appointments that were happening in that moment, but now that's been corrected as of this year.
So Ms. Story, do you feel empowered as the pharmacist on duty to say, we're going to cancel some of these appointments? Do you feel empowered by your employer to be able to do that today?
I do. And I actually did talk to patients that were coming in. And at that point, I asked them, I said, I'm sorry, but we're very full and we're overbooked. Do you guys mind, you know, coming back, rescheduling for another day? Unfortunately, some people, they did opt to cancel their appointment, but when they canceled the appointment, the slot opened up and more people would book for that appointment. So there was a flaw with the system, but it has been corrected since then.
Do you, oops, go ahead. Do you feel comfortable with the change? Do you feel like the changes that have been made as far as on the safety aspect with being able to have a little bit more oversight into making sure that you're getting the right vaccine and the appointments and whatnot? Do you feel like there's been big strides from where you were when this occurred versus what is
from
now?
what it was? Yes.
Is there any additional things beyond what you told us that you feel have also been that much more that have been implemented that make you feel even safer in what you're doing?
Right. Well, like Kanika said, it does like block out a lot of our appointments now. Like if we have 3 appointments set for that hour, if they're both getting 2 shots, that's it. That's all we got for that hour. It's maybe 3, maybe 2 appointments. But they do take into account the multiple shots now too. Because that was the other thing with the old system is like we'd have people coming in wanting flu, Shingrix, and the new RSV, and that takes time to put all those together for even one person. So now with the new system, it actually will take into account how many shots each person's getting. And sometimes we'll only have one person getting 4 shots in an hour just because it's that much more time for us to actually get that ready and keep the safety checks going. So.
Okay.
I'm pleased to hear that you've made the improvements. That's
I mean, I kind of have a motion to, unless anyone has more questions.
any further discussion?
All right.
All right.
It's just like, in fact, like from my perspective, technician should have do a better job. You know what I mean, with checking, especially the patient already asked her this is the right vaccine, and she just kept proceeding, right? So I don't think like pharmacist or the permit holder has anything to do with it. I know they're overworked and to fix this. So my motion is to dismiss permit holder and the pharmacist and apply 3 hours non-disciplinary for pharmacy technician.
She's already done 3 hours of CE on vaccines. Are you going to accept the
If the
hours
board
that she's
staff,
done?
yeah, if the board staff accept this, that'll be fine.
I just have some comment. I think at the time, there weren't things in place to make the workload smoothly. And it looks like it has been addressed, but I think a letter of concern for the time that this occurred, would it be appropriate just to document that I'm happy with the change, so the change already occurred, but a letter of concern regarding workload and ability for staff to be able to safely give immunizations would be appropriate. Also, I don't disagree with what you said about the 3 hours of CE, but it sounds like it was just a miscommunication. I don't know if they would say that was your performance directly. It was a
No, I've
miscommunication
given
of
thousands
what
of
had been
shots
checked. Misunderstanding, and maybe.
But when she named the medication, the patients already said, "Hey, are you sure this is the right one?" She said, "Yeah," and then she gave it to
Oh,
him.
I
So
see.
I mean,
I thought you
she
meant
could
the
have,
pharmacist.
yeah, she could have
Administered
stopped
it
it. Yeah.
before he asked the.
Oh,
second
she
time.
already administered.
Yeah,
Okay. Okay.
yeah,
then-
I couldn't
okay.
reach into the sharps
Okay.
to just
Okay.
double check.
All right.
Yeah, I thought I misspoke
Okay.
in the room with the patients, so.
Thank you for clarification. So advisory letter to who? To permit holder or to?
Yeah, not advisor, a letter of concern, so
Letter
it
of
would be
concern?
non-disciplinary about workload. So, because I was concerned with the workload that they were expected to keep up with at that time.
Okay.
And it's been addressed, which makes me happy.
Okay, I'm gonna define my motion to send a letter of concern to permit holder, right? And 3 hours of CE, except what she's done for pharmacy technician, non-disciplinary, and dismiss pharmacist involved.
All right, so there's a motion on the floor for an advisory letter of concern to the non-disciplinary letter of concern to the permit holder for workload, and a non-disciplinary CE 3 hours. Will accept the 3 hours already completed for Ms. Olson, and to dismiss against Ms. Story. Is there a second?
Second.
What were the CEs completed for? Was that immunization?
It was immunization and
okay.
patient safety.
All right, so we've got a first and a second. There is no discipline, so is a voice vote sufficient? All right, all in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you.
Thank you.
Thank you. Thank you.
All right, let's go on to 24C, which is complaint number 24-0171. Santa Teresa #2 Pharmacy and Joanne Linson. If you could please introduce yourself for the record.
Good morning, Madam President. Michael Rain with the firm Bozen and Snow on behalf of Santa Teresa and its pick, Miss Linson. And both are on the Zoom call.
Okay, that was my next question. If you guys could unmute yourself and please introduce yourself for the record.
Hi, my name is.
Oh, go ahead.
My name is Joanne Linson. I was a former PIC at Santa Teresa. They hired me temporarily.
Good afternoon, board. My name is Raj. I'm the permit holder for Santa Teresa.
Thank you both. Mr. Castaneda.
Thank you again, board members. This is complaint 240281. We opened this complaint as a result of findings during a routine inspection in March of 2024. When I arrived at the site, I was reviewing the permits for the facility and I noticed the DE registration that was posted was expired. When I asked the owner if he had a more current registration, he said he did not. He explained that this location was not operating as a true remote, but more of a pickup location for the public in that area. He explained the pharmacy did not have any controlled substances in its possession, but I did find filled prescriptions in the will call section awaiting pickup. Other concerns noted on the inspection were the qualifications of a remote pharmacy technician and the inability to produce a report of prescriptions sold from this location. The pharmacy remote technician did not have her 2 hours of the required 2 hours of telepharmacy CE. She did provide that the day after the inspection. In May of 24, Compliance Officer Carla Pudi and I went to investigate the complaint that was opened, and the expired DEA registration was still posted. Again, I asked if he had renewed the registration. He said he had not. In addition, when we arrived at the clinic, the only staff member that was present in the pharmacy was a clerk. The owner had pulled the technician from the remote site that day to help at the supervising site, and a clerk was there in its place. We explained that our statutes do not address a clerk working in a remote setting, and the owner closed the pharmacy for the remainder of the day. Shortly afterwards, the owner notified the board the remote site would need to be closed for an undetermined period of time. Any further communication went through Mr. Rain. Mr. Rain was able to provide a current DEA registration, although it was not maintained at the site, it was valid. Santa Teresa addressed some of the concerns the staff had about its operations, but was not able to provide a report reflecting what was sold at the remote location. There was some discussion of not sufficient amount of time to gather the documents. The records were requested from the owner when we went to investigate on 5/31, and the final response came from Mr. Rain on 7/12/24. In addition, one of the reasons the remote pharmacy could not provide a report was because the owner had removed the pharmacy server at the remote site, and all transactions for all prescriptions would reflect as being sold by the supervising location. In regards to the PIC, the response was that the PIC was not enrolled long enough to make any changes. In addition, the pharmacy was not able to provide any information about when the pharmacy would reopen and in what capacity.
Thank you, Mr. Castaneda. Mr. Rain, would you or someone from Santa Teresa like to make a statement?
Sure. Thank you, Madam President. Yeah. With regard to Ms. Linson first, she became the pick at this location or for the pharmacy in February, and these events were happening in March. And so at least as to her, we asked that the board take that into consideration. She was not involved in the creation of this remote location and really just was only there a brief period of time before these issues came to light and just really didn't have any involvement whatsoever. I suspect if you ask her about what was going on, she won't have much to offer. So while she was the pick at the time, we would just ask you to consider that she was only recently named the pick, and this operation was already winding down at that time and then ultimately paused. There's really no dispute about what Mr. Castaneda has presented. Just to be crystal clear, there was a DEA registration. It just was not the current license posted at the site. So they understand that, of course, but there was no lapse in a DEA registration, just not the current wall certificate posted at the site. And the site was operating more as a pickup location. I think what Mr. Shaw, he's a non-pharmacist pharmacy owner, what he would tell you is he can't find the staff there in San Luis. But he does want to offer this service to the public. It's a very remote location, and there is a desire to have this open in the future. And I know that Mr. Bozen from our firm has had some conversations with the director about how can they do this? How can they make it work when there's not the staff to do it? And the concept, I think, moving forward, of course, subject to further discussion with board staff, would be presumably to open this location up for 1 day a week. Prescriptions would still be filled at the supervising pharmacy. A properly qualified technician would take prescriptions to the remote site for pickup. Anything that was not picked up would be returned to the supervising site. But there is a desire to reopen. And so part of the discussion is they couldn't say when it would be reopened. A lot of that was based on the thought of making sure they had communication with the board and with board staff that the way they would want to reopen to provide this service to that community would be compliant, with the appropriate shared service policies, and of course, an appropriately trained pharmacy technician to do that job. With regard to the record keeping, it's an acknowledged issue. I mean, essentially what it would have looked like is that all the prescriptions were filled and picked up at the supervising pharmacy site. And so when the request is made, what had happened at the remote site, admittedly, there was an inability to identify exactly which prescriptions had been picked up from that location rather than the supervising site. We didn't have any concerns to our knowledge, of course, about lost or diverted medication, any sort of medication errors, anything of that nature. I think I would characterize it as an issue with the shared service policies and the record keeping, truly documenting what was happening. But it was a remote pharmacy that was operating as something less. But ultimately, the goal is to find a way to offer this service to the people of San Luis, because it is a valuable service. And Mr. Shaw is available to answer any questions you have, as is Ms. Lenson.
Thank you, Mr. Rain. Board members, questions?
Madam Chair, I have a couple of questions. How long has this remote location been open prior to the inspection conducted by our compliance officer?
Raj, can you answer that?
Yes, the location has been open since the permit was issued, and we switched locations from the previous location to others. So since I believe mid-2021, if I'm not mistaken.
So the remote location has been in operation since 2021?
Correct.
Without the DEA license registration?
No, the DEA license was intact. I was actually a bit flustered during the inspection. That was my first inspection at that location. The DEA was active from the time of opening that pharmacy.
They just didn't have the license hanging in the pharmacy.
Board members, if I may interject real quick, the opening inspection was performed in June of 2021. It originally was unsatisfactory. Then in July of 2021, they had a recheck and it was satisfactory at that point.
Thank you.
And if I made the DEA certificate, as I understand it, Mr. Castaneda can correct me, it was on the wall. It was just the expired version of it.
And the DEA registration covered both facilities, is that correct? Or they're separate. So this one that was not found at that time or was not current at that time was for the correct, it does have a correct licensed DEA registration.
I believe that the DEA license for the remote location was always current, always active. In fact, what was on the wall was an earlier year's wall
Okay.
certificate.
Thank you.
So it was never expired. It was just the old copy was on the wall.
And just to clarify, the way the language in the CFR reads that the registrant shall maintain the certificate at the site. It doesn't necessarily have to be posted.
And Mr. Castaneda, you did confirm that that address is correct, because as board members, we don't have those addresses available to us to confirm that that address is Santa Teresa 2 and not Santa Teresa Primary.
Let me find it in the board packet here and I'll confirm that.
So, Mr. Rain, has this facility ceased operating as a remote pharmacy today?
Yeah, it ceased all operation currently, and I think that was as of May.
Okay. And the issue and why they were operating the way that they were operating is because they couldn't find a technician that met the requirements, so they just operated using a clerk?
No, that's not accurate either. I think that they had a clerk, and Raj can clarify this. My understanding is the day it was a follow-up inspection and the day that the clerk was present only to tell people we are closed. There wasn't the normal pickup activity happening, is my understanding. Otherwise, there was a technician present, but that technician also had this additional issue that Mr. Castaneda identified of missing the telemedicine continuing education, which was then immediately provided. But the clerk issue was more of a one-day issue. It wasn't consistently manned by a clerk. The clerk was there to tell people we're closed.
Sorry to cut off. What Mr. Rain stated is correct. Right previously, we had a previous PIC who actually took 2 of my techs with him to a different location at a different pharmacy. So we didn't have a clerk, and I had notified Mr. Castaneda that we will be closed that week. So we were letting patients know that, that this pharmacy is closed. We also had it posted on the wall, but we're just letting patients know that we are not going to be dispensing. There's no pickups at this location until further notice.
Just to clarify your question on Mr. Anderson, the DEA registration that was provided in the response does correspond to the remote pharmacy on Babbitt Lane.
Thank you, Mr. Castaneda. I do have a question for Ms. Linson. When you were hired as PIC, did your employer, did Mr. Shaw tell you that there was a remote permit that was tagged or linked to your primary permit that you were responsible for?
He told me that they had another pharmacy. All it was a drop-off point, like a hub, because it's very rural and people didn't have any vehicles. They either had to walk for miles or they had to purchase a cab. There's no Uber, there's no nothing there. So that's what he told me, that it was just to help the rural people there.
So Ms. Tinson, have you been responsible for remote dispensing permits in the past? What's your experience been?
I just followed what the prior PIC left. And we did do the tele-pharmacy with consultations.
So did you do any sort of discovery on your own to see this location, or review the regulations on remote pharmacy permits and see what did you do as PIC when you came on board to understand what your responsibility was for this remote permit?
He took me over there and showed me around. But my main focus was the other location where they had to be staffed, because I had to make the workflow to be improved. The way the prior PIC left it.
Can I jump in? What happened if someone picked up and they needed counseling?
You turn on the tele pharmacy, and it has a they consult, we can talk. Since I don't speak Spanish, they have the technician or clerk there to translate for any questions or new prescriptions.
I have a question about the controlled substances. So if the server was at the main location, you can't tell where these prescriptions were dispensed out of. Which DEA registration is responsible for the controlled substances? Wouldn't they need to be transferred to the remote DEA ownership?
Mm-hmm.
Raj, you told me you had one shared service, Raj?
Sorry, would you mind repeating that question again?
I was wondering about the ownership of the controlled substances and the record keeping, because if they would be transferred to the remote dispensing location, you'd think there'd need to be some paperwork to show what went there, what belonged to that DEA number versus the main hub's DEA number.
Mm-hmm.
Correct. To my knowledge, we were doing it as a will call procedure. So there was no way of switching the DEA, but I believe we have implemented that into the SOPs. And it was not meant to have prescriptions, controlled substances sent there. But that there was a change in picks, and as in we've implemented, and staff has been trained as well regarding as in we haven't kept it open, so it's just from one location currently.
And
Mr. Shaw, I've got to ask the question. If this is just a pickup location, I don't know. I know this is rural Arizona. Does the U.S. mail deliver to these patients? Is there?
No, it's the only right now, currently it's only PO box based, so they don't have physical locations. So if medications were sent, they would be sent to PO boxes, but as in that's up to the patient to pick up, and as in it is extremely hot here too, so it comes down to temperature, and it's just
Sure.
I thought it was safer for patients to pick up from a secured location where everything is regulated, temperature regulated, and patients can pick it up. And it's mainly we're doing it for the patients, because once we switched over, it was very difficult for patients to come to our location, even though it's a few miles away.
Thank you.
Mr. Shaw, I have a subsequent question. Why did you remove the computer server from the remote location? Because it's imperative for us to identify which prescription was filled from that location.
The remote server is linked to having prescriptions filled at the location. So if our permit had a remote server, we would have to fill medications there. No medications were ever filled at that location. So that server is actually technically not removed from that location, it just hasn't been active at that location.
And I wanted to follow up on that, is that the prescriptions were filled at the supervising site, bagged and taken there. They didn't have any stock of controlled substances or any medications to my knowledge. And so I don't know if it's more accurate that they were reflected as dispensed out of the supervising pharmacy. And I think what was lacking was the fact documented in the record that they were picked up from the remote location. It's a good question about which DEA or both licenses would be implicated, but I just wanted to make it clear that it was really a pure pickup site. Nothing was stored or filled there.
So distance-wise, how far is it? How far is the remote location from the main pharmacy?
It's 5 miles, but it's considered out of town for patients. So cab fees, for instance, if they were to go to the only other pharmacy that's there, they charge a lot less fee going to Set Pharmacy, Walmart, than they would to come to my location, even though it's only 5 miles away. It's that patients in that surrounding area, which we were previously serving, were, as in they don't have vehicles and stuff, so they would just walk over to the pharmacy, like the neighborhood pharmacy, and they were not able to do that. So initially we had started a car service thing, which the clinic did that I'm attached to. They started a car service thing for patients, but it just wasn't feasible for the clinic to continue on with that program.
So other question is, prior to the opening of the remote location, did your pharmacy offer delivery services to your patients?
Would you mind?
Prior to the opening of the remote location, how did you service these patients who are living?
They would just bicycle over or walk over to the pharmacy because it was in the neighborhood. This is technically a new developing area, 5 miles north of where we're from.
I just want to check out all those points. So the DEA wasn't expired, so we fine with this. Is that right, Mr. Castaneda? So the DEA wasn't expired.
But it wasn't.
But the one is posted was the old copy or like expired copy.
Yes, that is correct.
Okay. And the pharmacy technician already provided proof of CE. Did this technician complete the CE before the inspection, or they just?
No, she did not have it completed at the time of the inspection. She completed it after and sent it to me the next day.
Yeah, just to make sure, like, now for that remote dispensing pharmacy, did you sell any OTC there, including Sudafed?
No OTC, including Sudafed, were sold there. As in, there was basic products such as like talcum powder and stuff like that, but no Sudafed was sold there.
Thank you.
Mr. Castaneda, did the pharmacy have the required policies and procedures to operate as a remote pharmacy? There's a lot of things that are required of a remote pharmacy, like a perpetual inventory, monthly supervision visits, so on and so forth. Do they have those required elements documented in their policies and procedures?
I do not recall seeing their policy and procedures for that. Oh no, I apologize. Needs improvement areas on page. It's in the inspection report here. Give me 1 second, I'll find it for you. All right, the report begins on 697, and if you go to the end under notes, on page 3112, I did note needs improvement areas, remote policy and procedures need to be sent to CO for review within 30 days.
Did that happen?
I don't recall getting anything.
Ms. Linson, when you were hired as the PIC, were you aware that you were going to be the PIC of both locations?
Initially, no, but later on, he told me. So I just thought the remote was from the prior PIC. Everything was set when they put it, the other CO approved the way it was set up. So I had no prior knowledge to that. It was a prior PIC, so I just went with it, how everything was running since 2021.
And when you found out that you were going to be the PIC of both locations, which is kind of atypical, what did you do to prepare yourself to ensure that you understood the laws and the regulations that came along with being the PIC of a remote pharmacy?
Well, there was no medication held there that could, like stock bottles, to be dispensed. Everything was carried from the main pharmacy to the hub pharmacy. They had two sections. One they kept there for the patients on Oak, and they had one the patients who needed medication. They would call in and they would be delivered there. And I asked for policies and procedure. I was looking over that, but I was only focused on the main pharmacy, trying to make sure everything was compliant with the present pharmacy that I was physically at.
Ms. Linson, you made a comment when you made your introduction that you're the former PIC. What happened?
Yes. I live in Tucson. The prior pharmacy manager left and gave about a week's notice, and the owner couldn't find anybody. I did a friend a favor to help the owner. That's what happened. I just did it to help them until they can find somebody else to take over.
Ms. Linson, how long have you been a pharmacist?
30 years,
All in Arizona?
California.
In California?
Yes.
And Mr. Shaw, is there any appetite to voluntarily surrender this permit?
If that's something that has to be done, that's something we can definitely discuss and make that. I can make that decision. I would love to have it open still, because even if I can, give the patients their one a day pickup for them to come pick up, everything is counseled, we document everything. It's still, I feel, extremely beneficial for the patients. It's not even about a business decision. It's actually, it's just mainly for the patients, and that's a place that was opened for a long time, and I just think is more beneficial for the patients of that area instead of, them going and taking cabs to go to either Walmart or us. So
How long has the pharmacy been closed for?
since the inspection, the week that Mr. Castaneda came for the second time he came in it's been closed since then. So May, I believe.
Yeah, it was May 31st that we, compliance officer Carla Puda and I went out to investigate the complaint. And just another point, I did find in some emails, some initial policy and procedures that did provide for the facility. We didn't discuss that any further because the complaint was opened up.
So 6 months it's been closed.
Which seems like a long time for an open permit to sit empty.
We just wanted to make sure that, I didn't know that the board, this is my first time going through this whole process. And we didn't know how long it was going to take. I just wanted to make sure I was compliant, that if we do, if we were to reopen up, as in patients will come back automatically to that location. And it's a safer place for them to pick it up. It's closer to them too.
Dr. Grandi, did you have a comment?
I had a question for Mr. Shaw. Is this your first set of pharmacies you've owned, or have you owned pharmacies prior to this?
No, sir. This is the first set of pharmacies I've owned.
Madam Chair, more follow-up if I can. Whose idea was it to implement the remote? Was it yours or the former PIC?
It was a joint effort with the remote location, but it was my idea to open up the remote location just because we can get prescriptions to patients, and not having a proper mailbox delivery was a bit tricky here because it is all PO box based.
I think this board is very empathetic to wanting to make sure there's access to medications, particularly in rural communities like that you're serving, but you've got to do it correctly and you've got to follow our regulations and federal law. And there are some gaps there that were identified by Mr. Castaneda that I sense from my colleagues that we're very concerned about.
What about offering a consent agreement for probation and requesting them hire a consultant of some sort? Or either or.
I mean, I have concerns that there's a permit that could, in theory, be ordering drugs that is just potentially that's been sitting empty for that long, and they have no plans to reopen it. If we have a permit that we issue that doesn't open, at some point we take action to close it. So,
Madam Chair, if I may?
yeah.
Or Madam President, they do plan to reopen it, and there has been discussion with the director about how to do that compliantly. And I think what Mr. Shaw was trying to articulate was we've been waiting for this day to have this discussion and further discussion with the director as needed to make sure that when they do reopen, it is a more compliant operation. And probably what I think that ultimately means is creating revised policies and procedures that would reflect what is actually happening and what they would like to happen, which is what they were doing. The problem was they had a remote pharmacy site location that would look to the world like it was operating as a remote pharmacy, but it was just a pickup location. So I don't think the task is too large to have a pickup station manned by an appropriately trained technician. The plan would be to do that only one day a week. And I think Mr. Shaw can correct me if I'm wrong, but I think he'd like to do that as soon as he can get the all clear, in communication with staff that they were comfortable with the manner of reopening. But Mr. Shaw, you can let them know if you think it would take longer than matters of weeks.
But the intent would be to keep the remote pharmacy license?
I think that is what he's expressed today and in the past, and just the ongoing communication about how to do that. Candidly, I was not part of that discussion with the director, but that is the desire. But if there needs to be an interim solution between now and reopening, or even a deadline, we'd like you to get this back up and running by X date, I think that would be okay as well. I think it's his intention to do it as soon as possible. But Mr. Shaw, you can correct me if I'm wrong, if you think it'll take a longer period of time.
No, as in, the staff has been trained. We've also hired a new tech also. So we're just waiting her 1,000 hours of onboard time and her CEs. But otherwise, as in I can have it up and running as soon as in if I can get clearance for it, or compliant, doing it compliantly.
Mr. Shaw, so Ms. Linson identified that she's no longer your PIC. Who's your PIC now?
We have a new PIC. His name is Mr. Carter. He's also, as soon as he joined, I've notified him as well that, he is a supervising pharmacist for that other location. He's also started taking CEs for telepharmacy. So he's aware, I'm aware, and we can go forward compliantly if that's possible for the board.
Is he in your community and somebody you feel is going to be stable, or is he
Yes,
using?
yes. That was the main issue that we deal with here is staffing and having someone who's stable here at the pharmacy. And he has planned on moving down here, as in, to my knowledge, everything is moving forward. And he's planning on staying here for long term.
Madam Chair, I have a question for Mr. Castaneda. So were you the one who inspected this remote pharmacy when they first opened?
No, I did not do the opening inspection.
Who did the opening inspection? Oh, Mr. Haber? Now I have a question for Mr. Haber. So, Mr. Haber, the question I have for you is, when they opened up this pharmacy and you did the initial inspection, do you recall seeing all the policies, all the requirements? Did they have everything that are required by the board?
They did not,
Okay.
and that's why they failed. And then they created them, and that's why I gave them a permit.
So they created them.
Mm-hmm.
I mean, they have it with them. They created the policies.
Well, that's not always the case. Sometimes policies disappear after a length of time. That's why we always check every time we go.
Okay.
It
So if
seems
Ms.
to me that like, probation would be appropriate and there be a reinspection at their cost. So we feel a little more comfortable with what's going on at this location.
And I also like to clarify about the DEA. When you transfer prescription from store to store, from DEA
They're
to
not
DEA,
transferring.
They're not transferring, they're sharing
so
the work.
so they're using it as a hub center, like, right? Like pickup station.
The
Pickup.
dispensing
Are
of
they
the,
allowed to do that by DEA?
the dispensing of the controlled substance has to be tied into the DEA for that facility. So if they're using as a pickup hub and it's registered with the DEA, RCS PMP, and anybody they report to would have to reflect that DEA number,
The pickup DEA,
the pickup location DEA.
which didn't happen. Right? That
They
did
didn't
not
have it
happen.
available, that they're saying that they do have it.
They're working
DEA
on it.
registration,
Yeah.
right?
I mean, they have the DEA registration, but I think you're correct that the records would not have reflected
Yeah, record
the
reflect
controlled substances
yeah.
were dispensed out of the remote
Correct.
site.
Yeah.
But that would be one of the corrections. And I think as to the policies and procedures, I think, to be transparent about it, they did exist in theory, but I think there's a recognition they weren't following them because it was designed to be a remote pharmacy, not a pickup location. But, the revision to those policies to match what they want to do would be part of the reopening.
But if they're going to operate as a remote pharmacy, they need to follow the remote pharmacy regulations, not a version thereof of it.
Yeah. And I think that's the idea of having a reinspection and making sure that any way they want to reopen is compliant is what they had in mind the whole time after they began the communication with the board. And I know that Mr. Mosen and the director have explored this. I am not qualified to discuss those distinctions, but it's my understanding that the bottom line is they want to be a pickup site in a 1 day a week, and to do that compliantly. However, that needs to be done to make board staff comfortable on the board.
We don't have a license type for a pickup site, do we?
No, it would be a pharmacy because they'd have drugs on site. and they would be shared services.
And they have telecounseling or whatever you want
Yeah.
to call it. So pharmacy is taking place.
Do we authorize like kiosk pickup in Arizona? I believe we do.
They have a permit for kiosks, so they're not
Pickup
permitted.
kiosk, yeah, I
until-
believe so, yeah. Just to
Yeah.
make sure.
And maybe Mr. Shaw can clarify. I do want to be clear about this, though. I don't understand there to ever be a plan to store drugs there and to fill them there. It would be more of a shared service. And a
But that's
hub.
what a remote pharmacy permit is. And a remote pharmacy permit requires that you have to have the like the regular visits, the perpetual inventory, all the things, the communication software, the shared common database, all the things.
Yeah, I think all those can be in place without storing drug inventory and doing more of a shared service model, just as two pharmacies would do, would be my understanding. I just want to describe the environment that will exist there. It will never open up as if it's a full pharmacy. They would still be packing at the supervising site and taking those for pickup, which, it might not be the full capacity that a remote pharmacy can do, but I think it's a subset within it, is my understanding.
Dr. Gandhi, if we went the direction of a consent agreement for a period of probation on this license, do you think that there's a way that they can come into compliance based on your conversations with Mr. Bozen and Mr. Shaw?
I think we can figure it out and be compliant with statutes and rules, yes.
Board members, if I may interject one last thing. As they have a new PIC, could we please remind them to have the permit update their PIC on file? We only have one PIC currently in our database from a couple of years back.
I have updated, or it should have been updated on file. Is it for the R location or for the Y location?
I am currently looking at the profile for the R permit on Babbitt. And I just see a PIC listed as Eswar Maserati.
Okay, well, that should have been updated. I can update that right away.
Board members' thoughts? Questions?
So Dr. Davis was starting a motion.
How do we feel about this consultant idea? I don't even know if there are consultants for remote pharmacies. So what about offer a consent agreement for a probationary period of 3 years and a requirement to open the doors within 2 months?
What would the terms of probation be? What do you want them to accomplish during that 3 years?
We want them to operate as a remote pharmacy should under all.
And I would want there to be a reinspection done within 90 days or some. Is that possible?
Yeah, I could add that to my motion.
I was looking for the inspection again to look at the violations on it.
I guess part of the probation you're kind of stating, but that the policies and procedures are in place, that the DEA registration is properly available for inspectors.
Record keeping
Record
is
keeping, continuing education, all of the requirements.
the periodic visits, all of the.
So do we ever
The database.
in the probationary terms for something like this, would we say, 0 violations on your next upcoming inspection? How would we kind of monitor for success with the probation?
The inspector usually brings it back for us for a review.
So is that standard? So if they're on probation and there is a violation, does it come to the full board? Okay.
So is 90 days an accurate, appropriate time frame for our compliance officers to be able to meet?
Yes, that'll be fine.
Perhaps 90 days within, from the date it reopens. Approximately 90 days.
Yeah, I think I would like to see it, the terms of the probation to address all the areas of needs improvement. So there was something in here like the audio wasn't working on the AV system, etc. too.
This almost feels like an opening inspection. Should it be done before they begin to open the doors? Because
Mhm.
these are all the things you need to have in place to open
Mhm.
versus giving 90 days operating out of compliance. I just want to hear thoughts on that.
Ms. Snare, Madam President, that kind of was where my mind was going, is it almost seems like we might want to be coming back here at your next meeting and discussing what we were what the reopening looked like and what the discussion with Mr. Gandhi looked like, or at least contemplate that whatever you do today, you might have a more meaningful set of facts to look at in a future meeting to revisit this. And again, I think my understanding is whatever we need to do to put in place with the board to let you know, in the interim, no activity will take place. I think that they would contemplate doing that. You do interim agreements and things of that nature with pharmacists. If something needs to be done, then, they're not open, they're not going to be ordering or doing any dispensing of controlled substances, and they're more than happy to try and give you confidence in that.
Ms. Davis has a conflict that she has to address. So I think we had a motion. I don't know that we had a second.
Well, we're discussing, do we want it to be,
Well, she can't amend her motion, so
oh,
at this point, because she's not present.
can that motion fail so we can discuss a different motion potentially?
Yeah, so we have a motion. Do we have a second?
Well, if there is no second, then.
That's what I'm saying.
Yeah.
What'll fail? I have no second, so the motion fails. Okay, let's come up with a new motion.
Okay. So, a reinspection at 3 months prior to them reopening. Therefore, they would be in compliance. We'd be assured that they're in compliance when they reopen is my suggestion, along with that probation period to keep in compliance, I guess would be the terms, or maybe just the reinspection. I don't.
How about cooperation between the compliance officers, board staff, and the permit holder as to an approximate opening date? Prior to that, they would have a reopening inspection. And then if everything is great, they get the reopening and it's ready to go. If not, it would come back before the board.
But I thought if they're not open or reach out to us within 6 months and no sign of opening, what do we do?
Then the permit is closed automatically.
I can make all of that my motion then.
To Lori's point, can the permit store medications while the license is on probation?
This wouldn't be probation.
So it's
What
still
we just
active and
suggested.
clear. Legally, it's got a DEA permit and a pharmacy permit. They can, to Lori's initial point, they
Yep.
could order from McKesson and have a order of, oxycodone delivered to the remote location.
That is my concern
Right.
too. Mhm.
Can part of, well, I don't know. I'm not.
Can we ask the owner to voluntarily close out his store? And then when he's ready, anytime when he's ready, he can contact the board for an reopening inspection.
I think that's where we're headed. I
Okay.
think you have representation from the permit holder and council that no operations are taking place. I am sure that they will continue to abide by that representation. And then the permit holder and staff will schedule an opening inspection.
Can we get an attestation that there's
Yeah.
no drugs being ordered
Mhm.
or being stored at that location?
Absolutely. Yeah, we can give you something signed under oath, notarized in writing, all of that. And I would say that if we're not far down the road in discussion, not to volunteer the director's time over the next 2 months, but by the time your next meeting comes, if we're not approaching that, based on what Mr. Shaw has said, in my understanding, we have no objection to coming back before this board, at which time you might have your level of concern heightened and want to take more, aggressive action to fully suspend the operation. But I truly believe that by the time your next meeting comes around, it may already be reopened or on the verge of it, if not. And if the progress isn't made, then of course we'd understand that maybe more significant action needs to be taken to surrender it or inactivate the DEA, something of that nature. But we commit to working diligently. Honestly, it really has been a waiting period till today's day to have this discussion. I think they're rearing and ready to go. And like many pharmacies that operate and get inspection violations, these aren't insurmountable obstacles. They can operate compliantly. They just wanted to have this discussion first. And I think, as Mr. Shaw mentioned, he had to get some people trained and up to the level.
Madam Chair, since we're in discussion mode right now, we'll work with the DEA also to see if this is in compliance, because you're ordering inventory for controlled substances out of the main pharmacy and strictly dispensing it from a different location, where this location is not ordering anything. So there may be some balancing issues of numbers. So we'll touch base with the DEA and see if they're okay with this operation as well.
So for discussion's sake, are we best to table this until the next meeting and allow the compliance officers and the director time to continue to work through this? Or
It may be a good idea, yeah, because we may be approving something that we may not be able to today also, for as far as controlled substances go, right? But for non-controls, I think the board can make a decision if they would like.
But if we table it, can we get the attestation that they're not ordering or continuing to do business?
I think Mr. Rain can work that out with his client.
We have no objection to doing that. Regardless of what you do, we will supplement what we've said it in letters and things like that, but we will make it very formal just to have that in your file for your purposes.
Mr. Rain, do you have any concern with us tabling this till the next meeting and you guys seeing what you can do to work out rather than us taking some sort of action that maybe doesn't need to be taken?
I think that's appropriate, because I think by then, and we would concede or, do an inspection provisionally. It sounds like that's what you'd like, regardless of the circumstances. If we can work it out that far and do an inspection at their cost, some of these things you might order might have already been done, but I think tabling is a good idea.
Madam Chair, how should we handle pharmacist Joanne Linson?
I think we should take that separately than the
Yeah,
table.
that's my point.
Yeah.
Is it advisable to address her today since she's no longer working for them, Ms. Galvin?
If at all possible, yes.
Okay. So thoughts on a motion for Ms. Linson?
I'll withdraw my first.
Okay, thank you.
Okay, so for the pharmacist, Joanne Linson, what I have in mind is clearly when she took on this job as a pick, she pretty much neglected the key factors of all policies and things that are mandatory for the opening of a pharmacy. So for that, I'm leaning towards at the minimum letter of concern, or could be some sort of disciplinary. Because she is a pig, she has been operating the pharmacy, and clearly how she operated the pharmacy has deviated from the policies that were provided to our compliance officers.
And she toured the pharmacy, looked at a license that was expired and allowed it to stay on the wall expired,
Correct.
which was peculiar to me that she did. I mean, as a new PIC, when I'm touring a pharmacy, I'm gonna look at the basics.
Mm-hmm.
But she only worked there when they got the inspection. She was a new PIC, right, at that time, and she came from California to Arizona. I totally agree that she should be aware of the law and all rules. 100% agree with that. But I believe letter of concern that will be.
I feel like a letter of concern and some continuing education. I mean, the fact that she signed on as the pick of 2 locations, which she had to sign on as the pick for the remote location as well,
Correct.
which
Yeah.
clearly the profile wasn't updated either.
Correct.
I mean, if I'm going to take responsibility for a pharmacy and it's a
Should
different kind
understand.
of pharmacy than I've ever supervised before, that's my responsibility as a licensed professional to make sure that I understand
Correct.
what's required of me as a pick. And she wasn't doing any of those things,
Right.
nor was she following the company's
Yeah.
policies. So I think that there's some education that could be beneficial there.
Yes,
I
agree.
would
So,
also agree with the letter of concern in CE.
yep.
So how many CEs?
I almost wonder if that's disciplinary. It's not following what you need to do in that role.
Well, and ultimately, she was allowing a non-licensed person access to
Yeah.
to medications without a pharmacist
Mhm.
present.
Right.
Mhm.
And I don't think she was monitoring cameras or any of those other kinds of things because it doesn't seem like she even knew that that was her responsibility.
Correct.
Right.
No, sorry to cut you off. She was monitoring the cameras. That day was the only day that we've ever had a clerk that was present, and that was only to have patients being sent to the other location. We've always had a tech at that location, and they've also had their hours as well.
I still think it should be disciplinary.
Did she update her profile like as a PIC for that location? Like her own profile.
I can jump in here. She did.
She did?
Yes.
On time. Yeah. So she's responsible for her own, update her own information, and the permit holder is responsible for the pharmacy information, like, so
She does have a start date, but she does not have an end date.
she did not end her, so.
Correct.
Okay.
Miss Linson, are you working as a pharmacist?
Yes, I am.
Who is your employer?
San Carlos Apache Hospital.
Thank you.
So Dr. Kianabong, did she update that? Does she have that on her profile that she hadn't changed her employer?
She does. She, on second look, she has Santa Teresa Pharmacy, herself at Santa Teresa Pharmacy as the pick, but at the location on Oak Avenue. And there's a start date, but not an end date.
But she's working at San Carlos Hospital, is what she said.
I don't see that on here. I don't see that in her profile.
Miss Linson, are you working for Santa Teresa at all at this point?
No, no, ma'am.
Why did you not change your employment on the board website?
I'm a contractor.
Still. I believe still, even you're a contractor, you need to update your employment information.
As a pharmacist, do you understand that it is your responsibility to notify the board of change of address and change of employment?
Sorry, I forgot. I'm sorry.
Ms. Linson, you've been a pharmacist in Arizona for over 30 years. You testified.
Kind of.
Yes.
Yeah. Mhm.
Thoughts on a motion?
So if we like the CE and we like discipline, we could frame it in a consent agreement.
Also, failure to update your profile as a $50 non-disciplinary fine.
Is that appropriate to add since it's not a part of the investigation? It is. It is not appropriate. Miss Nair, do you want to finish?
So 3 hours of disciplinary CE in pharmacy law to the PIC. I can't remember what else we discussed.
Letter of concern, but that would serve for it.
Right. That's my motion.
Second.
I have a motion and a second. Any further discussion? Dr. Gandhi.
Thank you, Madam Chair. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
I'm going to abstain since I missed part of the discussion.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, one absent, one abstained.
Thank you. And then with the permit, do we need a motion to table?
No.
Okay. I know Dr. Gandhi has a meeting that brief call he has to take. So
It was canceled, Madam Chair.
it was canceled. Okay, well, I have a request for a bio break regardless. Let's come back in 10 minutes. So 3:25. Okay, welcome back, everybody. Dr. Gandhi. I think everybody's afternoon is like getting a little tired here. All right, welcome back. Let's move to 29A. If I can open the book. Are you in it, Jeff?
Yes, this is special request 29A, board staff, Mr. Patel, and subject probation termination for Sunrise Pharmacy, Mr. Patel. And do we have anybody from Sunrise on the line?
Present.
If you could please introduce yourself for the record.
Dr. Ezekiel K. Kisitule, PIC Sunrise Pharmacy.
Thank you. Welcome, Mr. Patel. If you could give us a summary.
So this is a special request to lift the probation for Sunrise Pharmacy, permit number Y007983. In 2022, to resolve the board case number 21-0527, the Sunrise Pharmacy and Ezekiel Kesitilwe entered into a consent agreement whereby they agreed and signed in 2022 that they would be placed on probation for a minimum of 12 months and also be subject to 2 random inspections by the Board of Pharmacy at their cost. One of the other terms of the probation was to pay the $5,000 civil penalty within 90 days. The 2 board inspections were conducted. They were done in 2022, October, and also June of 2023. In October of 2022, it was unsatisfactory with a few violations issued to them. But in June of 2023, there was no violations and the inspection was satisfactory. And I had conducted that particular inspection and I find that I'm satisfied with the condition of the pharmacy to operate.
Mr. Kesatowi, is there anything you'd like to address the board before we proceed with questions?
No.
So, Mr. Patel, you're satisfied at this point that they've fulfilled the terms of their probation?
Yes, and I see no concerns.
I'll make a motion to lift the probation as requested.
Second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, thank you very much. Best of luck to you, Mr. Kestalwi. Great to see that you've made such improvements.
Thank you, guys. Have a happy holidays.
You too. Take care.
Thank you. Bye-bye.
All right, moving to reports. Dr. Gandhi.
Thank you, Madam Chair. A lot of my stuff is informational. Some of it is conferences that we've had an opportunity to attend. I think the first one on my agenda is one, unfortunately, I couldn't attend. It was the ASPL conference held here in Arizona. I had the privilege of, I had the luxury of Max volunteering on my behalf to speak on behalf of board's positions on a number of issues that were presented. So if it's okay, Madam Chair, since I wasn't there, if you and Max could maybe chime in on your experience at ASPL, that would be helpful.
Well, actually, there was a number of the members there. Ms. Lehan, Mr. Anderson, and Ms. Nair also attended, and we also had prior board member Dennis McAllister there as well. So Arizona was very well represented. Max, I'd love your perspective. I've attended a number of times, but also the other members. But I think Max was probably voluntold to go to the meeting, and he did a nice job representing us.
Sure. Thank you, Madam Chair. This was my first time attending the ASPL annual conference, and I found it very helpful as far as content goes. There was a lot of seminars about updates on law, national law, and hot topics in Arizona. Like the chairman said, there was a a lot of representation from Arizona, so I would be curious to have other board members chime in. But I found it very helpful. A lot of useful content was delivered in the sessions.
Ms. Snare, Mr. Anderson, Ms. Laham, anything you'd like to share with the board or talk about?
I would just say Mr. Morris co-presented a great case law update, and I always appreciate that. And I thought there was a lot of content, so there was a really great conference.
I would just jump on board with the same thing. There was a lot of different things that I learned that I didn't have a lot of experience in, and I felt like they were more cemented. And I always appreciate the law updates, because that's things that we can take back and share with others in the community to help them be aware and practice safely.
And I would just echo and appreciate Mr. Morris for the invite and sharing with the board that the conference was being held here locally. I think one takeaway for me is, like, this happened right after the election, and the uncertainty of what some of the policies are going to play out as a new president and administration comes into play next year. It was very interesting just to get people's perspective and on that.
I think the discussions around the intersection of telehealth and what that means for controlled substances is certainly going to be something that continues to be an emerging issue. A lot of the things we've already talked about with compounding and things like that obviously were hot topics of discussion, as well as DCSA. So really good conference overall. I always learn something new there.
Awesome. And I think next year's conference is in Florida. I've had the opportunity, of course, to attend ASPL many years ago when it was here in Phoenix also. And it's always nice to stay up to date on what's happening across the country legally. And an interesting thing about it is, and not just ASPL, but any meetings, conferences I attend, I go to those conferences thinking we're on an island by ourselves, and then we go there and we learn that everybody's in the same boat. And so it's refreshing. It's sad, but it's refreshing that we're all struggling to keep up with current times and face challenges together. Thank you for that recap, everyone. Next on the agenda is also, I've had the opportunity to go to a couple of other meetings, NABP Executive Officer meeting and an NABP Member Forum meeting. And those two meetings are very similar in topics. One of the hot topics that we had an opportunity to talk about is AI. And I think the message from AI is definitely integrate with it, because it's already here today in many different facets. So either you work with it or you don't work. And I think that's the message, because it's not going away. It's just going to continue to build. And lots of learnings from it. So we'll have to see. We don't know how it's going to evolve over the next 5 years. I think AI still is in the infancy stage. We're just touching the tip of the iceberg from all the speakers that I've listened to, is what that message was about. Next thing we've talked about is the Pulse by NABP, and it addresses Drug Supply Chain Securities Act. I believe a member from NABP is going to be giving a training session to our compliance officers in January, Truman, to see what Drug Supply Chain Securities Act is all about, and how we can track and trace and make everybody's life easier, because I believe NABP has created a tool that allows for individuals to put data in there and for us to retrieve it to make sure that we've closed the loop and counterfeit drugs are not coming into the play here. So,
Dr. Gandhi, one comment there, and perhaps this is something for later, but I think there would be benefit in NABP doing the education for the full board. I think it would be interesting for the other board members to hear it, but I also think it could be good education for the public, since they're offering that service for free. While small dispensers are exempt for a little while, I think that there certainly could be some education that could be a little bit more broadly educated to our communities in Arizona.
absolutely. We'll set that up. But as far as from our learnings, we'll figure out better way to maneuver through Pulse, and then that way if there's any questions or anything like that, at least we're kind of in the know before you guys see it yourself. But that's a great idea. We'll do that. Some of the other topics discussed was 503A, 503B challenges, and then the big one is MPJE and UPJE. Right now, I think the movement across the country is, and it makes sense that majority of the laws governing each individual state is federal law. And we have, and it's consistent law. Each state, from state to state, the laws are very standardized, except for minor nuances here and there. So I think the movement is to move to a UPJE setting where if an individual took an exam in one state, they should be able to reciprocate freely without taking and having that hurdle of another state's law exam to take. So there's a strong movement. But having reviewed our rules and statutes, I think if we were to adopt a UPJE going forward after our evaluation of it, I think we already have a foundation to move in that direction if the board chooses.
And have you discussed like grandfathered pharmacists already licensed in their state? Or never?
That hasn't come up with NABP yet, but that's a good topic to bring up at my next topic of discussion with them. There are other topics. Just culture, of course, was talked about again. I think many of us have heard that discussion numerous times. Working conditions, we kind of just talked about a little bit today and had a case before us related to that. That's still a hot topic, and the pharmacy personnel wellness, well-being, and how they're mentally strained out there and the challenges and how to overcome those things. So very informative meeting. And again, these topics are constantly reoccurring just to keep those fresh in mind. I think the other one that was mentioned is conflict of interest. And, you know, that was a good topic. I think I've read I had the PDF report on it. We'll be addressing that, and we do that every year at the February meeting to go over conflict of interest with the boards, board staff, and so forth. So we'll refresh that information with you in February. Anything I miss, Madam Chair?
The one thing you didn't hit on that I thought was really interesting that I didn't have a lot of understanding around was the NABP Research and Innovation Institute that was created as a part of NABP President Massaros's kind of charge related to innovation and technology and those kinds of things. So it's interesting to hear about what that institute is designed to do, which is really to use it essentially to research various different topics to provide guidance to boards using kind of more of a data-driven, evidence-based decision piece towards rulemaking. So things like if we're talking about, for example, AI, if there's some sort of research that can be done with AI to determine what boards should look at from a like model regulation standpoint, those kinds of things. There is a form on NABP's website that you can request that certain topics be examined for NABP to look at, trying to do some research around those kinds of things. But I think really exciting opportunity for us to continue to collaborate with NABP and to use evidence to make good decisions on regulations moving forward.
Thank you, Madam Chair. Next on my list is a rules package. And this rule package was not discussed at the task force meeting because I didn't feel it needed to be. It was a repeal of a lot of language. Several years ago, the board repealed over-the-counter dispensers, retailers, and it was still in our rule section. So it didn't make sense for it to sit there and take up space. So that's been completely repealed in all the areas I was mentioning, non-prescription drug retailers and permits. The other one that was repealed was the definition of virtual manufacturer. Last year, there was a bill that was run that was moved into statute that is almost identical to what the definition rules was, with the exception of CMO device companies. They don't need to be permitted. With us, that was an exception that passed the bill last year. So with your permission, I'd like to move forward with this rules package by opening the docket, getting the governor's approval, and so forth.
I have a motion with regards to the proposed language as proposed.
I second.
Was that your motion? We didn't have a motion. I
Make a
said, do we
motion.
have a motion?
Yeah, I motion to approve the request from Dr. Gandhi.
Do I have a second?
I'll second.
All those in favor?
Aye.
Madam Chair, I'm abstaining from this one since I may have conflicts with.
Okay.
the-
And just for the public, since I know it's not posted, it's only repeal language. There's no additional regulation added to it.
Thank you, Madam Chair. The next on my list is I've been having discussion with the DA on several subject matters, a couple of topics. Remote pharmacy, dispensing pharmacy sites came into discussion, and right now, federally, the DA does not know how to handle remote dispensing site pharmacies, and they treat them like an online pharmacy, where then the Ryan-Haight Act comes into play. And so their position today, and I know federally it's being discussed on how to incorporate remote dispensing site pharmacies, but nothing has been finalized yet. So the gist of it was that the DEA's position on controlled substances is that if you're a remote site pharmacy, you can only fill controlled substances if it's received through a EPCS system. You cannot dispense it through a paper copy. It becomes a little complicated in Arizona because we also have approved a hybrid model where pharmacists may be there part of the time and not there part of the time. So how does a business then maneuver through that process? And that's going to have to be a business decision on how that works. But I know that the DA is looking at those remote site pharmacies, not just in this state, but across the country. So just informational. Any questions on that? The second headache from the DEA is about virtual manufacturers. And it's been a headache. The virtual concept, wholesalers, manufacturers, and all these other virtual is very complicated and complex. Again, the DEA does not know how to manage virtual manufacturers at this time because they don't have any product on their premises. But they do broker transactions and so forth. So there's some of their components in the DA wheelhouse which they need to regulate. And the other component is they can't because there's no product on site. So again, there's a question to their headquarters on how to appropriately deal with that. Today, they don't know how to permit them appropriately. So it's creating some confusion. There are some companies that want to jump into this virtual manufacturing of controlled substances. But without a DA registration, they can't. And that's in that space where they don't know how to move forward today.
Question, with the administration changing the policies, I would think, and of who's been proposed to move in there, would potentially change greatly in the pharmaceutical area, along with manufacturing. Has any of those things been considered or thought of in any of these discussions of what may take place? And obviously that's making assumptions, but any kind of planning for the upheaval that may or may not take place?
Federally, are you talking about, Mr. Thorwell? So whenever we engage discussion with the DEA, it's almost difficult to get a clear, concise answer right away. It's always, let's get with headquarters and we'll get back to you. So we can talk about it all day long with them, but we don't necessarily get an answer from them quickly. We actually have a meeting coming up here in the next couple of weeks to talk about some of the subjects I just talked about and some of the challenges we're facing as well out there in the field. And more to come on that meeting. But I think to answer, so it's more complicated than that. The next on my list is I have a grid. There's no update to that grid since the last time I report on it. We did try to coordinate a rule writing task force meeting a couple of times. I had a difficult time getting a quorum. And I think chair, vice chair wasn't available for one of them. So we're going to try fresh at the beginning of the new year. There's no update to give. The last thing on my list, Madam Chair, is what we're hoping to do is, again, continue to speed up the process to get individuals licensed. One of the processes that we're looking at and would like permission to move forward with is having NABP approve individuals, release them to test for what if they've had discipline in their home state. In general, we carve those out, and we may have them appear before you, or we may not, depending on if that action was isolated to that state, or if it's going to impact us as well. I think after discussing it with Gene and Seth, I think the position of the board is after everything is met, our position is whether we issued a license or not necessarily release them to test. That's more NABP's role. I haven't seen a situation, maybe one situation where we may have denied somebody to move forward with licensure, but we haven't prohibited anybody or denied anybody licensure as a pharmacist. And so based on that, we're like, let NABP release them to test. And then if we find anything criminal history or disciplinary action in another jurisdiction, we'll bring their entire case before the board for consideration.
Along those kind of similar lines, I know NABP, and I don't know if it was at this meeting or if it was at the district meeting where it was talked about that they're doing a pilot to look at moving the law exam forward to allow for students to take the law exam before they graduate, or is there any discussion on expanding that to other states? Or is that something we can consider in the future? And I don't want to get off on a non-agendized topic, but if possible, I'd like to potentially talk about that in the future.
We can put it on the future agenda, definitely. Talk about it at the next meeting.
And maybe we can talk about these two things together.
Sure.
Since they're kind of somewhat related.
Yeah, our hope was to implement that at the beginning of the new year, or did we already do it? I'm sorry, but Jen.
I know we've talked about it before.
Yeah. The NABP releasing them to test.
No, about taking
Before graduation.
The test.
No, but what you're saying is we may implement the other because the other would require a change
The
with NABP.
UPJE.
Yeah, the other may require a statute or bill regulation change, and we can talk about it at the next meeting. My ask today is that the NABP release people to test. And then if there's a criminal or disciplinary background check coming up on our review, we'll bring that whole profile to you guys for consideration.
That makes sense to me, given the environment with staffing and things like that. I think if there's anything we can do to move forward licensing quicker, I think that makes sense to me. We'd still get a chance to vet it before we issue the license.
Oh, absolutely. And I think it just delays the process for the board to review, give them permission, and then the slots are filled up, and then it just delays the licensing process for those guys. So if I can get maybe a vote or something to move forward with that, that'd be great.
I'll make a motion to move forward.
Second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed?
Madam Chair, that's all I had. Thank you.
Thank you, Dr. Gandhi. Ms. Ganavong.
Okay. All right. Hello, board members. I'll start with the compliance activity report. Okay, this report is current through November of this year, and it is year to date. So we'll start with inspections. The compliance team, as they do every day, has been keeping very busy. They've completed 1,250 inspections so far this year. Next slide, please. Okay, in terms of violations, we have, again, year-to-date through November, a total of 136 violations issued year-to-date, most of those being in counseling, controlled substance audit, controlled substance collector, and expired drugs. Next slide, please. All right. The compliance officers also make visits over time that are not related to inspections. Year to date, there have been 89 of those, the majority of them being courtesy visits to permitted facilities. Next slide, please. And then finally, on the year, the team has completed 402 CE audits. They've completed 422 complaints, investigated 434 complaints, and conducted 269 permit reviews. So just want to congratulate Mr. Leong and his team. Really a lot of work done this year so far, and we'll have more to report out for 2024 at our next board meeting. Okay, we'll go ahead and move on to licensing. A lot of work being done here as well. Our data here is also through November of this year, year to date. So far this year, the team has issued 6,968 licenses, permits, and registrations collectively. Next slide, please. A total of 4,304 licenses, permits, and registrations have been closed. Next slide, please. There was a request from board member Anderson a couple of meetings ago with respect to data on how many technician trainees have become pharmacy technicians. And we were able to get that data. A big thanks to our data team here at the board. As of this year, as of the end of November, we've had 707 individuals who held a technician trainee license or registration at some point in time become pharmacy technicians this year in 2024. Next slide, please. Okay, so this is a graph of our pending applications. I took a look at this on December 2nd, and we had just 46 pending applications at that time. Our licensing team has been moving through applications very, very well. The turnaround time is less than 5 business days. Next slide, please. We do trend to have more in-progress applications. And again, I would just reiterate, as we do each time, to please do your best to submit a complete application on the first go so that we can get the license or permit issued to you. Any incomplete applications do take more time to process. And then final slide, please. This is a pictorial of our license and permit renewals. The blue bar that you'll see here is for the time period of September 3rd through September 30th. And then the red bar is for October 1st through October 31st. And this makes up our license renewal period. And during this time, we had 13,241 renewals. So it's been a busy year. Want to thank Hannah Boltz and her team, as well as Jennifer Mitchell. She makes a lot of contributions to this process as well. And that is all I have.
Any questions or comments? Otherwise, I think you forgot something.
I did forget one.
I was going to come back to you.
Yeah, thank you. I appreciate that.
I read your mind.
Agenda item, and thank you, Jenica, for reminding me as well. 30A7, there are 2 rules bills in your packet. One bill is there was a bill a couple of years ago that limited the amount of time a discipline could stay on the board, and then it's got to be grayed out. It was for 5 years. This bill is kind of overriding that and leaving it on our website, whether it's discipline or non-discipline, for 25 years. So that's up for consideration. And I believe I have a meeting next week with the legislator that's proposing that language. So I wanted to get your take on it so that I can appropriately chime in our discussion next week.
That seems pretty long. Do we know the rationale behind this amount of years?
So today it's 5 years, but it's grayed out and you can still request it through a public records request. So we still have record of it, but it's just not readily accessible on the website. This would just make it readily accessible on the website for 25 years.
Curious, what does the Board of Medicine, Board of Nursing do? Like 5 years?
All health boards were 5 years, and then it grays out. It would just have a Y, and it's grayed out where you can't click it to see what the discipline was.
I personally think that 25 years is a very long time. and it could potentially impact somebody's ability to get a job. And I don't know that I think that, I mean, it's still discoverable. Like it still notes that there was discipline. Somebody can still contact you. I mean, I'd like to hear the rationale of why they're requesting the bill. Without
That-
having more information, it's hard to say.
Yeah, and that I won't learn until next week sometime. But it does open it up for, I'm sorry, Jean, go ahead.
Okay.
It opens it up for more public records requests. And I don't know how many, Jen, how many have we gotten? Is she here? She is not. Let me circle back with Jennifer Mitchell. She does a lot of these public records requests to see how many we've gotten, because like to your point, the designation for discipline is still there. Although they see the details of it, they'll reach out to us and ask for it. But as far as the thought process, why they're modifying it again, I don't know.
Well, and I mean, other regulators can still see it too. So I don't know what is the average across the country. I don't know if that's something NABP could help us with. But like, what other states look like too? Because I wouldn't want to be an outlier here.
Yeah.
Where people maybe don't want to come practice here.
We don't comment on pending legislation, but if you look at the wording of this, it says letters of concern, advisory letters shall be made available on the Health Profession Regulatory Board's website for not more than 25 years.
Okay.
So in theory, a board could say, oh, okay, we're going to do it for 6 months then. 6 months is not more than 25 years. And I know that it's the same language as 5 years now, and everybody says, oh, we have to keep it on for 5 years.
That's why you're an attorney.
So I'm just, if you're meeting with the sponsor, the intent is for at least 25 years and not more than whatever. So, but we don't comment on pending legislation.
You could also check with the National Council of State Legislators. They'll have a list of what's going on with every state.
I did, I'm sorry. No, not at all. How many public records requests have we gotten for disciplinary actions beyond 5 years? Because it's grayed out now on our website.
I get at least once, twice a week at minimum. There's always one per week. So a couple hundred per year, maybe.
Okay.
And they have to be redacted.
Yeah.
So it takes a minute.
So I can get further clarity. Thank you, Jean, for bringing that. And next week. And my last ask on this is to work with chair and vice chair, as I do every year, because bills are gonna flow this starting soon. And I need input. So that would be my last ask. The second bill, proposed bill in this is.
Do you need a motion for that?
I will, yes, but after I discuss the second bill,
Okay.
if that's okay. Is to expand psychologist prescribing authority. I think it's in your package right now, so I just want you to know that these things are starting to come up. And these are just two examples of bills that are being run or being considered to be run. There's a lot more to come. And for those that have seen my board in my office, you can see that the whole thing gets filled up pretty quickly. And by the time it's all done, it whittles down to a handful that gets passed. But there's a lot to follow. And to call a full board meeting each time a bill drops doesn't make sense. So with that, I would ask the board to consider board staff to work with vice chair and chair on any bill that gets dropped for to give me direction.
I'll make that my motion.
I'll second.
Second.
I have a motion second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none. I think that is it.
I think I did. I got it all.
Where's Doug? You're up. The CSPMP report.
Good afternoon, members of the board. I really have two subjects to discuss with you guys today. being the end of the year, kind of in line with what Ms. Gianavong talked about, I wanted to share a little bit about our own compliance efforts. And one of the requirements is that pharmacists are registered to use the PMP. And I often share with you that we do everything in our power to help them. And Mr. Anderson and I talked about this a little bit at lunch. And over the course of this year, there were a total of 110 pharmacists that kind of hit the naughty list that needed to be registered, weren't registered. And my team was able to work with them to get registered with the PMP. Instead of bringing every single one of them in front of you, my team is working with trying to contact them. If they communicate with us, we help them get registered. And what can be a little confusing for the public is you could work in an environment that is not required to use the PMP, but the way our laws are written, they're still required to be registered to use the PMP. So often those pharmacists that we're helping are pharmacists that work in a hospital setting. They're not required to use the PMP, but they are required to be registered. So that's one area that we work on. We also work on data submitters, making sure that we're getting data daily like we're supposed to. So that's mainly pharmacies that report to the PMP. And throughout the year, there was a total of 113 notices regarding delinquent reporting. Again, I don't bring every one of them in front of you immediately when they're delinquent. Often there's IT challenges, there's change of vendors. There's a lot of different moving pieces to report into the PMP. And if we can help them get back on track, we do. And that's exactly what I'm sharing with you is that 113 times we were able to help a pharmacy report prescriber registration. Big deal, right? Without being registered to use the PMP, you can't meet the obligation to check the PMP before writing for an opioid or benzodiazepine. And that's what prescribers are required to do. So since January, we were able to help 4,000 prescribers register for the PMP. Now, these 4,000 were not necessarily all quote on deny list. They could have moved here from Ohio, but 4,000 was the number of prescribers we helped get registered. And then finally, prescriber usage of the PMP. Like I said, they're required to use the PMP before prescribing an opioid or benzodiazepine. As I've shared with you before, we kind of take the top 20 offenders and we call the offenders who wrote for the most benzos and opioids and had 0 queries of the PMP, 0. And we send those names to the appropriate licensing board and those licensing boards take over with their own investigation. And sometimes that comes back to me asking for reports and we help those licensing boards with their investigations. So I just wanted to share a little bit about our own compliance efforts. I'll pause there, see if you have questions. If not, I'll jump into item number 2. And item number 2 was, every year statutorily, we put out a survey and we try to revise that survey. Yeah, at the same time, we try to have some consistency so that we know if we're improving. When we put this survey out, it's role based. And when I say role, what I'm saying is when you register for the PMP, you could be registered as a prescriber, a pharmacist, a delegate, a law enforcement agent. So we cater the questions that we ask to that audience. And a great example of that would be, we've talked about the MyRx report. We had the DEA come in and talk about how important it is for a prescriber to look at their MyRx report. So we ask the prescribing community questions about it. Do they like it? Do they use it? Things like that. Pharmacists don't get MyRx report, so they weren't asked questions about that. And that's just one example of how we cater that survey question to the role of who's conducting or who's completing the survey for us. But subjects that we covered in the survey include thoughts about our state indicators. We used to call them clinical alerts, and that's whenever we shout out a warning that the patient may be on opioid and benzo or over 90 MMEs or going to 5 pharmacies and 5 prescribers. We ask questions about that. We ask questions about, like with pharmacists, their knowledge about error corrections. Because sometimes I get phone calls from patients and the patient is saying, I never received this medicine. And it's because the pharmacist picked the wrong John Smith. And that gets reported to the PMP. So I need to help that patient. That patient's in a rough spot because their prescriber may be not wanting to give them the medicine that they're used to getting because their PMP report has the wrong information. So we ask questions about that. We also ask them, everybody was asked questions about our staff's training, our educational efforts, thoughts about our website, and the PMP software in general. Law enforcement, they were asked questions about the usefulness of the reports and the helpfulness of my staff. So that kind of gives you a little recap of like what was in the survey. But with every survey, you try to take away some wins and opportunities, right? And when you look at the wins, one big win, and it started at the beginning of the year with DEA coming in, was the MyRx report. We saw an increase in usage of the MyRx report according to what the survey told us. And then we also we saw like the delegates are using the PMP properly, and that becomes important because everyone wants credit for their lookup. And Miss Lehan and I talked about that at lunch, right? The law says we need to do this, and you want credit, but if your delegate doesn't pick the right pharmacist, the right prescriber, the credit goes to the wrong person. So anyways, the awareness that delegates have about how important it is for them to make those right choices. Those were big wins that we saw through the survey. Opportunity wise, I just talked about the state indicators, and we were hearing there's alert fatigue. I get it. I don't know what the right answer is. But on one hand, we know that if you're on a benzo and an opioid, there's an increased chance of overdose. We also know that if you're going to 5 doctors and 5 pharmacies, there might be diversion. And we also know that over 90 MMEs, you have higher chances of overdose too. So, we're going to look at that, and we're going to try to figure out, maybe the alert criteria could be expanded so that we're not looking at such a tight window, and hopefully then reduce the amount of alerts. Another area of opportunity is we know that our education's working. The only problem is only 10% of those that did this survey have seen our educational efforts. So, we try webinars, we try through the website, I go talk. How do we get that word out there? in a more meaningful manner. And I think the answer lies with leveraging associations, pharmacy association, the medical association, and having them post things that we want, trying to create awareness, because not everybody's going to spend their time coming to the PMP website to look for things. I'm open for questions.
Thank you, Doug.
I have a question, but not related to those items. So last month, I believe Suboxone reporting disappeared from PMP. Have you heard about this? For a couple days, that provider was, yeah.
What happens is, we eliminated the need to report naloxone dispensations to the PMP. Because naloxone is one component of Suboxone, that as the technology was weeding out what needed to be in the PMP, yes, there was a day or two where Suboxone that was dispensed from pharmacies was not coming into the PMP.
But I believe it's fixed now.
That's
fixed.
fixed. Instead of just focusing on naloxone alone, it kind of lumped out anything that had naloxone in there. And again, it is just Suboxone that's dispensed from the pharmacy. Yeah.
So Doug, the dispensing of naloxone OTC formulation, does that get reported in?
It does not. The statute was changed so that naloxone is no longer required to be reported to the PMP. And that was done with the idea of helping hospitals be able to distribute naloxone out of the emergency room. Thank you.
Madam Chair, if it's okay, I'm going to slap Kevin's and Tariq's hand for talking about things that's not on the agenda. And we should have nixed it a while ago, but
Thank you.
I had a comment. I like your idea of working with the state associations to provide education. And I get questions all the time from naturopathic physicians about how to do reporting because they want to administer and stock testosterone injections in their office or pellets. So a presentation to the Naturopathic Medical Association would probably be a well-attended event.
I'm more than glad to, but it's a pretty easy answer. Administrations aren't reported to the PMP. So I could present that in 2 seconds there.
That would be great because I get questions all the time.
Yeah. The dispensations, so that if they're dispensing.
I think we're off agenda, right, too?
So,
that one is a smack on your hand.
Yes, ma'am. Very cool.
Future agenda items?
Yeah, great idea. Call the public. Mr. Morris. I know you're waiting.
On the website. Roger Morris, call to the public. I had a couple of quick ones. You guys talked about ASPL. It is November 6th through 9th in 2025 in Fort Lauderdale. So if you want to get it on your calendar now, the travel is not the simplest to that. So if you're looking at it, put that one on. Second one, we had a discussion earlier today where we talked about, and I think you ended up giving a non-disciplinary letter to someone about use of NTIs and substitution of it. I don't believe NTI is defined on the board website at all. We all know what it is, but it is not something that you have different laws on in the state. So if we're going to hold people to a different standard on NTI, and I'm not opposed to that, I do think we need to put some announcements out. We need to put something in the board's newsletter or issues that are there. Now, again, it was non-disciplinary, so I think it's just better practice. And so I think there's a reasonable position for it. But I don't believe this board holds NTI drugs to any different standard than any other drug with it. So we just want to be careful on that. And then the third one, you had a long discussion about remote work that was there. I'm going to try and summarize what I think I heard, but I'm not sure that there was actually a conclusion. But I think that the standard in Arizona as we sit here today is you may work remotely as long as you meet all of the requirements to do so, meaning having adequate security, HIPAA standards, issues with that. But I don't know that we actually said that. And if that's what we're saying, we either should probably change the rules and be very, very clear on it or put that in the board's newsletter, because I think it's a very positive thing. But we had a lot of discussion about it, but I don't know that I actually heard the ultimate conclusion that you need to meet all of the standards that are there. Those are my three quick ones.
Thank you, Mr. Morse. Anyone else? How long has it been up for, Max? Oh, you didn't put it up while he was talking?
Are there future agendas from the board members?
I already have 3 things for my list for you. Do you want me to give them to you now?
We can wait till tomorrow.
Okay.
Give me a break tonight.